who is always, whether I am organizing the conference, whether I am organizing the workshop, or whether he is organizing everything and he wants to have our contribution. He is always there to support me as well as the GITM. Thank you, sir, for coming here, and I am again very honored that you are always here for us. Last 3 years, we have got the association with the Lucknow Management Association, and I am very fortunate that Colonel Sameer Mishra sir, who in a very short way, whenever we invite here, he always comes to deliver the things in order. He always comes here to give his lectures to the students of MBA, as well as guiding the faculty how to become a successful entrepreneur. As a director of the GITM, I again welcome you here in this IPR workshop. Again, I welcome Dr. Alok Jain sir, Director Coordination and Planning, who always support me to organize every type of events. Our 3 directors who are present here, Directors Dr. Brijesh Pandey sir, Director Dr. Karuna Shankar Sukla sir, as well as Director O.P. Verma sir, who is here to give us their blessings also and to support the Goel group. We are all the 5 pillars of the Goel group here and always comes together to organize any type of event. Thank you, sir, for coming here. I am also welcome the deans, HODs, principal diploma, our chief proctor, Dr. Shalinji, as well as all the other HODs, faculties, senior faculty members from the different colleges who have came here for this one-day IPR workshop, as well as the students here. Some of the students of the pharmacy as well as diploma are here to attend this thing. I all welcome you here in this college. As far as Goel Group is concerned, I am honored to tell you that we are having achievements in all the way you can say. We are having the NAC, prestigious NAC in the Mahavidyalaya. We are having the NBA in the GITM as well as pharmacy. Our pharmacy college has got the 2 times NBA, which is the best in, I think, UP. No other college is there. Starting from the nursery to the post-graduation, every type of varieties programs we are having. And this is all due to, last but not the least, our chairman sir. His vision, his mission, and how to develop a college is marvelous. And I know that he is watching us through the YouTube channel, which is also live. And I thank her for giving us all support as well as the other things for organizing such events. Thank you very much here for attending this workshop. And I also want to express my thank you as well as the convener of this program, Dr. Brijesh Pandey, HODs, Computer Science, Dr. Anita Pal, as well as our cultural committee members, our entrepreneurship members, our innovation cell members, our members in the dais, our members in the hair, all the teachers who are supporting us from the every bit of it. Thank you very much and thank you.
Thank you so much, sir, for your inspiring words and valuable guidance.
This one-day workshop is organized on intellectual property rights to help students, teachers, and researchers to understand how to protect their ideas and innovation. The workshop explains the basics of IPR, such as patent, copyrights, trademarks, and designs. It also teaches how research work can be converted into patents and how IPR helps in academic, industrial, and startup growth.
Participants will learn the patent filing process, legal rules in India, real case studies, and practical aspects of IPR. The workshop also highlights government schemes and opportunities available for innovators. This program is very useful for anyone who wants to turn creative ideas into valuable assets and contribute to national development.
Now we come to the very inspiring part of today's workshop.
It is our great honor to invite our Guest of honor Dr. Pooja Yadav Ma'am, Joint Director, Council of Science and Technology, Uttar Pradesh, to kindly come forward and share her inspirational words to us.
Ma'am has been actively working for promoting the research, innovation and scientific development in our state and has guided many young researchers and academician journey.
We request everyone to please welcome her with a warm round of applause.
Thank you. First of all, I would like to thank Professor Rishi Asthana, Director GITM, and other faculty members and honorable guests present in the program for inviting us here and honoring us. I am Dr. Pooja Yadav from Council of Science and Technology. Basically, Council of Science and Technology UP is a part of Department of Science and Technology UP, and it was established in 1975 to promote scientific temperament in Uttar Pradesh. Currently, we are in a session of IPR, so I would like to tell you that CSTUP funds IPR workshops and establishment of IPR cells across various educational institutes in UP. And regarding IPR, I would like to give the students who are here a brief introduction. See, there are two types of property. One is tangible property and one is intangible property. Tangible property is something which you see around yourself, such as land, cars, and gold, ornaments, other things. But intangible property is something which you cannot physically feel, but it has a monetary value. So in our country currently, many people are not aware of the kind of value, the kind of monetary benefits they can get out of the intangible property that we have. We have a lot of young crowd, people who are in their 20s, 30s, and they have a very good scientific temperament. They want to do new things, innovate new things, but we are not completely aware of how to make maximum use, draw maximum profit from our intangible property, which is creation of our mind. It can be in the form of patents, when you develop a device, a new process for something. It can be in the form of copyrights, which is protection for literary and artwork. It can be in the form of trademarks, which is protection of logos for commercial goods. And it can be in many other forms, such as GI tagging, industrial designs. I want to tell you that in the field of GI tagging, Uttar Pradesh is number one, the first state, followed by Tamil Nadu. And we have almost 34 GIs from Banaras, many GI from Lucknow, such as chicken embroidery, the Dasheri mango, and others. So I would like to tell all the students here, teachers who are also present here, to focus on and to promote the protection of intellectual property which we have. Sometimes while doing research, in fact most of the time we feel that whenever we get a new finding, we go for the process of publication. But you should do patent before publication in case you develop a new device or a new process. It can lead to monetary benefits as well as it will also make you famous among the people, and people will know that this invention belongs to Mr. So-and-so or Dr. So-and-so, Professor So-and-so. So I would like to say that all students, all the faculty members present here to please listen to this workshop carefully and then promote IPR in GITM as well as from all colleges from where you are. And thank you so much.
Thank you so much, ma'am. Your words were indeed very motivating and encouraging. Before we move forward, I would like to request Dr. Brijesh Pandey, Sir, Director GITM, to please present a token of welcome and welcome Dr. Arun Dakkar, Sir, Director Administration GGI. Can we have a huge round of applause for Sir? We now feel honored to invite a respected guest of honor, Shri Ravi Lal Sir, Joint Director Council of Science and Technology, Uttar Pradesh, to kindly address the gathering.
He has rich experience in supporting scientific programs, research activities, and innovation initiatives across the state. His commitment towards strengthening science and technology culture is highly admirable. We request everyone to please welcome sir with a big round of applause.
Yeah. Good morning to all, respected directors, sir, and entire team of Goel Institute of Technology. मैं and student, researchers and यहाँ के कर्मचारी जो सुबह ही आ चुके होंगे, उनका मैं राधे लाल साइंस एंड टेक्नोलॉजी की तरफ से हार्दिक अभिनंदन करता हूँ। वैसे तो मेरी सहयोगी पूजा ने IPR के बारे में बहुत कुछ बता दिया है, लेकिन मैं थोड़ा सा ये इसमें ऐड करना चाहता हूँ कि IPR शब्द कोई नया नहीं है। IPR हमारा प्राचीन काल से हम लोग इसको IPR को करते आ रहे हैं, वो किसी ना किसी वे में। जैसे मैं एक स्टोरी बताऊं, आपने भी सुनी होगी, शायद न्यू बच्चों ने नहीं सुनी हो, स्टूडेंट्स ने, कि एक द्रोणाचार्य और एकलव्य की आपने स्टोरी सुनी हो। तो द्रोणाचार्य बहुत अच्छे धनुष विद्या में निपुण थे, और जो एकलव्य था वो पढ़ा लिखा नहीं था, वो धनुष विद्या सीखनी चाहता था। तो वो जब द्रोणाचार्य के पास एकलव्य गए तो उन्होंने मना कर दिया कि वो बहुत ही बच्चा सही नहीं था, बहुत ही लोअर उससे था। तो उसने एकलव्य ने क्या किया कि उनकी जंगल में एक अपनी मूर्ति बना दी द्रोणाचार्य की, और वहीं पर वो धनुष विद्या का अपना अभ्यास करने लगा। एक दिन द्रोणाचार्य वहां से गुजर रहे थे, तो जो एक डॉगी था उनके पीछे पड़ गया। तो उसको चुप करने के लिए एकलव्य ने अपनी बाण विद्या का वहां पे यूज किया। तो उसने इतने बाण किए कि उसके मुंह जो है डॉगी का उन्हीं धनुष जो बाण थे उन्हीं से बंद कर दिया। तो द्रोणाचार्य को बड़ा आश्चर्य हुआ कि ऐसा महारथी हो गया कि मेरे से ज्यादा उसको ये धनुष विद्या में निपुण हो गया। तो एकलव्य से वहां पर बोला, तो वो विनती करने लगा। एकलव्य ने विनती की कि मैं ही हूं, मैंने ही ये इस डॉगी को किया है इस टाइप से। तो द्रोणाचार्य बोले कि तुमने तो मेरी नकल की है। द्रोणाचार्य बोले तुमने मेरी नकल की है, तुमने मेरी मूर्ति बना रखी है, तो इसका तो आपको खामियाजा भरना पड़ेगा। तो उन्होंने उसका बदला उनके दाएं हाथ का अंगूठा ले लिया था बदले में। तो ये हमारा IPR वहां से प्राचीन काल से चल रहा। ये नहीं कि हमने अभी से हम इसको अभी ये ठीक है कि हम नियम बना लिए, पॉलिसीज बना ली, बट उस टाइम पे ऐसे नियम और पॉलिसी नहीं थे। उदाहरण के लिए किसी के विचार को चुराना चोरी है, लेकिन उसे कानूनी रूप से सुरक्षित करना बुद्धिमानी है। ये तो आप सहमत होंगे IPR से। IPR के पूजा ने बता दिया होगा, 4 सेंटर्स है हमारे, दिल्ली है, चेन्नई है, हैदराबाद एंड मुंबई। 4 सेंटर्स है हमारे। देखिए मेरी गाड़ी में एक डिवाइस लगा हुआ है। मेरी गाड़ी में डिवाइस लगा हुआ है, यदि हम पेटेंट के फॉर्म में चले कि जब हम लोग हाईवे पे जा रहे हैं वो मुझे 1 किलोमीटर पहले इंटीमेट कर देगा कि आगे कैमरे लगे हुए हैं, आप अपनी गाड़ी को स्लो कर लीजिए। तो उसका यदि हम पेटेंट कराना चाहें तो पेटेंट नहीं हो सकता, वो हमारी नेगेटिव है। यदि हम किसी को पॉजिटिव वे में पेटेंट कराने की कोशिश करेंगे तो वो पेटेंट हो जाएगा, बट किसी चीज को हम नेगेटिव लेके चलेंगे तो वो पेटेंट नहीं होगा किसी भी रूप में। यदि हम ये बोले कि हमें नाइफ का पेटेंट कराना है और उसमें लिखा जाए कि इसको मैं आदमी को मारने के लिए यूज करूंगा, तो वो पेटेंट नहीं होगा। यदि वो कहेगा कि इसका उल्टा हम रिवर्स बोले कि इसको मैं फ्रूट्स वगैरह काटने में, सब्जी काटने में, तो उसका पेटेंट पॉसिबल है। अब मैं CST की कुछ गतिविधियों के बारे में बताना चाहूंगा, क्योंकि यहाँ पे हमारे प्रोफेसर, स्टूडेंट्स सभी बैठे हुए हैं। R&D में रिसर्च में आप जानते हैं, शोध विकास के लिए हम लोग ग्रांट देते हैं। उसमें जो लम सम ग्रांट होती है 15 लाख से लेकर 18 लाख तक की ग्रांट होती है, 2 से 3 इयर्स के लिए वो ग्रांट होती है। आप लोग जो प्रोजेक्ट फिल करते हैं उसी टाइम पे जब हम आपसे पब्लिकेशंस मांगते हैं तो पब्लिकेशंस इतने सारे आप दे देते हैं, लेकिन वो पब्लिकेशंस उस फील्ड से जिस प्रोजेक्ट को आप फिल कर रहे हैं उससे रिलेटेड नहीं होता है। आपने प्रोजेक्ट किसी और टॉपिक में भर रखा है, पेटेंट वो अपने पब्लिकेशंस किसी और से उसमें अटैच कर रखे हैं, तो ये भी एक प्रॉब्लम हम लोगों को काफी फेस करनी पड़ती है। देखिए हमारे यहाँ ये मत सोचिए कि हम लोग किसी प्रॉब्लम, हमारे यहाँ यूपी में 75 डिस्ट्रिक्ट्स हैं, आप ये मत सोचिए कि हम लोग इंडस्ट्री के लिए काम करें या किसी के लिए काम करें। 75 डिस्ट्रिक्ट्स की कोई ना कोई प्रॉब्लम है, उस प्रॉब्लम को ही हम लोग सॉर्ट आउट कर लें। जैसे अभी फॉग आया था, अभी सब लोग परेशान हो गए थे, स्कूल कॉलेज सब बंद थे, बुजुर्ग लोग घर से नहीं निकल पा रहे थे, तो उसके सॉल्विंग के लिए हम लोग कोई उपाय ढूंढ लें, तो ये भी इसको हम प्रोजेक्ट के रूप में कर सकते हैं। कानपुर में चमड़ा उद्योग इंडस्ट्री बंद हो रही है, उसका कोई सब्स्टिट्यूट ढूंढ सकते हैं, उस पर हम लोग प्रोजेक्ट सर्च आउट वगैरह कर सकते हैं। या कोई चीज हम इंपोर्ट कर रहे हैं, उसकी हम प्राइस को कम कर सकते हैं, उसके लिए हम प्रोजेक्ट का आप लिख सकते हैं। दूसरा CSTUP इंजीनियरिंग प्रोजेक्ट ग्रांट स्कीम है, अभी जो बीटेक फाइनल वाले स्टूडेंट के लिए होती है, इसमें हम लोग 20,000 देते हैं। अभी कुछ बच्चों के आपके यहाँ से सिलेक्ट भी हुए हैं प्रोजेक्ट्स, तो उसमें फर्स्ट ईयर की ग्रांट हम लोगों ने ऑलरेडी दे दी है 10,000 रुपीज, और उसका 27 अप्रैल को हमारे यहाँ प्रोजेक्ट प्रेजेंटेशन होगा, तो उसका सेकंड ग्रांट। और उसमें मैं स्टूडेंट से कह रहा हूँ, उसमें प्राइस भी बहुत अच्छा रखा है हम लोगों ने, 1 लाख फॉर फर्स्ट, 75,000 फॉर सेकंड एंड 50,000 फॉर थर्ड ईयर। एंड उसमें हमने पब्लिकेशंस वही, कोई बच्चा SCI IEEE इसको पास के पेपर पब्लिश करेगा तो उसके लिए 20,000 अलग से अमाउंट है। तीसरा हमारा CSTUP समर फेलोशिप स्कीम है, उसके अंदर जो MSc के स्टूडेंट्स हैं वो 2 मंथ के लिए IIT, NIT, CSIR की लैब, DRDO, NPCIL, BHEL, इंडियन ऑयल, हम लोग 2 मंथ की ट्रेनिंग के लिए वहां पर बच्चों को भेजते हैं। हम उसके लिए हम 50,000 देते हैं 2 मंथ के लिए। तीसरा हम लोग में इनोवेशन का भी काम करते हैं हमारे पे, तो इनोवेशन में हम लोग ग्रास रूट के लिए काम करते हैं, मीन्स किसान मजदूर के लिए, किसान के लिए, रिक्शा वाले के लिए, उसको पेटेंट कराना, उनको प्रोटोटाइप डेवलपमेंट कराना, नो हाउ प्रिपेयर करना, ETC। IPR में पूजा ने बता ही दिया, हमारे यहाँ पे 3 प्लेनेरियम है, इंदिरा गांधी प्लेनेरियम लखनऊ, वीर बहादुर सिंह गोरखपुर, आर्यभट्ट रामपुर, और गोरखपुर में एक और साइंस पार्क, बहुत बड़ा साइंस पार्क बनना है, अवैधनाथ विज्ञान साइंस पार्क, ये गोरखपुर में काम चल रहा है इसका तेजी के साथ में। एक अभी हम लोग नई स्कीम लॉन्च करने जा रहे हैं PhD स्टूडेंट के लिए, ओनली फॉर PhD स्टूडेंट के लिए वो स्कीम, जो स्टूडेंट एस्ट्रोफिजिक्स, एस्ट्रोनॉमी, एरोनॉमिक्स, ETC, मतलब हम लोग स्पेस को बढ़ावा देना चाहते हैं, यदि कोई स्टूडेंट उसमें PhD करना चाहता है किसी भी यूपी की यूनिवर्सिटी के साथ में, उसको हम 5 इयर्स तक, पहले 3 इयर्स में 36,000 पर मंथ और प्लस 50,000 उसको कंटिजेंसी, लास्ट के 4th ईयर और हम लोग साइंस पॉपुलराइजेशन के अंदर हमारी कुछ साइंस बस है, 75 डिस्ट्रिक्ट्स के अंदर प्रोग्राम्स हमारे रन करते रहते हैं। बहुत सारे प्रोग्राम हम लोग अरेंज कराते हैं, उसमें DM, CDO, BIS और जो हमारे साइंस टीचर रहता है वो हमारे इन्वॉल्व रहते हैं। अब मैं किसी को यदि कोई क्वेश्चन पूछना है तो वो पूछ सकता है मेरे से। अब मैं अपनी बारी को विराम देता हूँ। धन्यवाद।
You shared very valuable things with us. Thank you so much. Now we move forward.
Now we move to a very important and inspiring session, the valuable words by our guest of honor, Professor Kuldeep Sahai Sir, Director, Rajki Engineering College, Basti. Professor Sahai Sir is a senior academician with nearly 30 years of experience in electrical engineering. He is also a professor at the Institute of Engineering and Technology, Lucknow. He holds a PhD in Power Systems and an MTech degree from IIT Delhi. Please welcome sir with a big round of applause.
Thank you, Vidushi ji. First of all, I would like to thank Rishi ji for inviting me to be part of your. And then I would like to director. There are a number of directors in this institute, number of department, and that is the thing is your college is running core branches also. This is the good thing. Now I miss this type of the diversity in the colleges. And then I would like to thank Director Administration and Samir Misra sir, Arun ji, Radhelal ji, Pooja madam, and all the participants. So this topic is workshop is very relevant because our country has been lagging previously, but from the almost 5 to 6 years, we are moving forward. Forward in the sense now our country and innovation index is 38 of our country. So this is the rate we are moving towards the innovation. And in intellectual property right does not mean only innovation. Here you can have your books, that is also copyright, logo, papers, GI tagging, all the variety of things that you have. So only innovation is not an intellectual property right. So sometimes people fail to fill the information when it's required by the different body. So this book is also a intellectual property right? So this way we are moving ahead. Now I would like to request all the director of the institute, since you have a different departments, also pharmacy college and innovation center also, IIC. If you have this type of the atmosphere and all the director I think are dynamic. If they are dynamic, they should form a corpus fund for this activity, because private sector participation is very much important compared to the government. CSR fund is also not being released for the R&D purpose. We are far behind from the Western countries. So if you can fund and very specific manner, means since you are guiding your BTech student projects, if you have a master's, then master's degree and pharmacy. So through the project, you can move from the department, say electrical engineering, first, second, third, initially identify the problem and then generate the idea, and on that idea you can evaluate it through your internal committee. So if This way you will move. After 2 or 3 years, you will have a good impact in this area. So this is my suggestion, and that way moving slowly always give impetus to the system. Once atmosphere is developed, all the students will come to you and say. Another thing is that you should have a cell that should have some counselor who can guide you, because sometimes innovative idea is very good, but if you don't have a good counselor, you fail to file. And challenge for our country is also another challenge is for our country is getting evaluated, final award. So this is filing is okay, but converting filing from the last product and getting some industry to motivate or to propagate that idea in the market, that would be the great challenge for our country. So no government is also funding, AKTU is also funding the innovation center. So this way our state is giving lots of impetus, Government of India is giving lots of impetus to this cause. If government is moving, then being a student also move ahead. And one thing is that in your system, only 5 to 6 member is required to take the decision, like director administration, director academic. If they think this idea is good, they can sponsor it, and this will. And why sponsor it? Because along with the students, your institute name will also be a part of the patent filing process. So your institute will have also a tie with this. So this way, I would like to sum up, and once again, I would like to thank everybody to be part of this, and Dr. Rishi Asthana ji for inviting me and for saying such a wonderful, humble words for me. Thank you.
Thank you so much, sir, for your inspiring and knowledgeable words. We are truly grateful for your guidance.
Thank you so much, sir, for telling us about to create a mediator between students and industry. Now we move forward. We are pleased to present a valuable message from our next guest of honor through an online video. Faculty of Engineering and Technology, GITM Lucknow. His research areas include solar energy and heat transfer. He has also contributed greatly to curriculum development, admissions and placement activities at AKTU. We now request our technical team to kindly play the video message of Professor Arun Kumar Tiwari, sir.
To dignitaries, faculty members and participants, it is great honor to be invited as guest of honor by Goel Institute of Technology and Management, Lucknow, on one-day workshop in association and sponsored by Council of Science and Technology, Uttar Pradesh, on intellectual property rights organized by the Computer Science and Engineering Department. I express my heartfelt gratitude to our Chief Faculty, Professor Dr. Brijesh Pandey, Honorable Vice Chancellor, Chairman, Goel Group Institution, Lucknow, for his pivotal role research culture in every CST funded projects and promoting IPR driven innovation. I also warmly welcome Dr. Pooja Yadav and Sri Radha Joint Director CST Uttar Pradesh, whose presence greatly enriched this occasion. The CST plays a crucial role in nurturing student-centered research, supporting translation, innovation, and bridging academia and industry through structured funding and mentorship, thereby significantly enhancing students' technical competencies and career readiness. I would also like to briefly highlight the importance of IPR, which serve as the cornerstone for protecting innovation, encouraging original research, and enabling the commercialization of academic outcomes. A strong IPR ecosystem not only safeguards researchers' ideas but also enhances institutional credibility, industry collaboration, and technology transfer. In today's knowledge-driven economy, effective IPR implementation is essential for translating research into society and economic values. Lastly, I would like to congratulate the Goel Institute for organizing this workshop, which reflects a strong commitment to impactful research and social advancement. I wish all the best for productive session. Thanks, one and all.
Thank you very much, sir, for your valuable message and kind guidance about ecosystem and idea generation.
Next, we are honored to present the online video message of Professor Anuj Sharma sir, Dean, Research and Development and Industrial Consultancy, AKTU Lucknow. We now request the technical team to kindly play the video message of Professor Anuj Sharma sir.
Good morning to all respected dignitaries, honored of the dais, guests from CST, speakers, faculty members, and my dear students. First of all, I would like to express my gratitude to the management of Goel Institute of Technology and Management and the Director of Institute, Professor Brijesh Pandey, for inviting me and for providing me this opportunity to share my views on intellectual property rights. It is my pleasure to address this gathering in a workshop dedicated to IPR, a subject that is becoming increasingly important for engineers, researchers, and innovators in today's knowledge-driven world. As engineers, we are trained to think creatively, solve real-world problems, and develop new technologies. But an idea has true value only when it is protected and recognized. Intellectual property rights provide the legal framework to safeguard our innovations, whether they are inventions, software, designs, or research outcomes. IPR plays a crucial role in encouraging originality and preventing misuse of ideas. Patents, copyrights, trademarks, and designs ensure that creators receive due credit and benefits for their work. For students and researchers, understanding IPR helps in avoiding plagiarism, promoting ethical research, and converting academic projects into patents, startups, or commercial products. In academic institutions, IPR awareness strengthens research culture, enhances industry collaboration, and contributes to national innovation goals. With India's strong focus on innovation and entrepreneurship, engineers today must not only create technology, but also protect and manage IPRs effectively. I encourage all students to develop an IPR mindset, document your ideas, respect others' work, and seek guidance when you create something novel. Faculty members play a vital role in mentoring students and fostering a culture of innovation and protection. In conclusion, intellectual property rights are not just about laws and regulations. They are about valuing knowledge, respecting creativity, and transforming innovation into impact. I hope this workshop helps you understand IPR not just as a subject, but as an essential part of your professional journey. I personally express my sincere gratitude to the Council of Science and Technology, Uttar Pradesh, for their generous financial support in enabling the institutes to conduct this workshop on intellectual property rights. Their continued commitment to promoting scientific awareness, innovation, and research culture among academic institutions is truly commendable. I wish the workshop great success and hope it inspires many productive innovations from this institution. Thank you, and I wish you all a productive learning experience. Jai Hind, Jai Bharat.
Thank you very much, sir, for your inspiring and encouraging words. Thank you for updating us about the ethical aspects of innovation. Now we move forward to a very proud and encouraging part of this program, the felicitation and certification of students whose innovative ideas were selected for UPCST call. This moment celebrates the creativity, hard work, and innovative thinking of our young minds. To begin the ceremony, I would like to introduce and invite a person who has been a constant source of inspiration to our students, Dr. Brijesh Pandey, ma'am, Head of Department, Electrical and Electronics Engineering, also the convener of Innovation Cell, GITM.
Our Innovation Cell has been working actively for more than half a decade, and under her guidance, many students have gained confidence to think creatively and work on innovative ideas. She has always motivated students to believe their ideas and convert them into reality. I now invite Dr. Priyanka Jaiswal ma'am to kindly lead this felicitation and certification ceremony. So please welcome from a big round of applause.
Good morning to all, respected chief guests, distinguished speakers, and dignitaries, esteemed faculty members, researchers, and dear students. It gives me immense pleasure to welcome you all to this IPR awareness workshop funded by CSTUP. I would like to take this cell of Goel of technology and management, highlight its achievements, and share our association with CSTUP through student innovation projects. The Institute Innovation Cell, established under the guidelines of Ministry of Education's Innovation Cell and AICT, functions as a central platform to promote innovation, entrepreneurship, and intellectual property creation among students and faculty members. The IIC aligns its activities with national initiatives such as Atmanirbhar Bharat, Startup India, and Viksit Bharat, and actively integrates innovation into the academic ecosystem. Through its consistent efforts, the IIC has achieved significant recognition at national level. It has been awarded a 4-star rating for 3 consecutive sessions, 2021 to 22, 2022 to 23, and 2023 to 24, by Ministry of Education and AICT, and was placed in the 51 to 100 band under the innovation category of NIRF 2023. The institute is recognized as a mentor institute under the IIC Mentor Mentoring Scheme and has received a granting aid of 2.25 lakhs. The IIC has established pre-incubation and incubation facilities, including the Goel Incubation Foundation and IPR unit, enabling multiple student and faculty achievements in the National Innovation Platform. Now I would like to hand over to Dr. Vidushi.
As we move forward for the certification of the students who were selected for UPCST, I would like all the dignitaries to please join us on the stage for the certificate distribution. I request Dr. Pooja ma'am, Shri Radhe Lal sir, Professor Kuldeep Sahai sir, Dr. Alok Kumar Singh sir, Dr. Colonel Sameer sir, Dr. Alok Kumar Jain sir, Dr. Santosh Pandey sir, Dr. Karuna Shankar sir, Dr. Om Prakash Verma sir, our Dean Academics Dr. Devendra Agarwal sir, and Dr. Rishi Asthana sir to please join us on the stage for the certificate distribution. I request Dr. Alok Jain sir, Dr. Devendra Agarwal sir, and all the directors present over here to join us on the stage for the. I also request our Director Administration, Arun Kumar Dr. sir, to please join us on the stage. I request the technical team to please cover the group picture.
The CSTUP Engineering Students Project Grant Scheme is a flagship initiative of the Council of Science and Technology, Government of Uttar Pradesh, aimed at encouraging creativity, research-driven innovation, and technological development among engineering students. The scheme provides financial assistance, expert evaluation, and recognition. Our institute has been an active contributor to this initiative, and the consistent selection of student projects under CSTUP reflects the strong innovation culture nurtured by the Institute Innovation Cell. In the previous year, 2 student projects from GITM were selected under the CSTUP Engineering Student Project Grant Scheme. In this year, 4 student projects have been selected under this scheme and have received the first installment for project implementation. I would like to request Dr. Pujaya Yadav ma'am, Joint Director CSTUP, and Shri Ravi sir, Joint Director CSTUP, to give certificate of appreciation to these students. The first project is Maya, the MSc method from Information Technology Department. The mentor of this team is Mr. Shivam Dikshit sir. I would like to call this team on the stage. The team leader, Prabodh Upadhyay, with team members Ayush Tripathi, Divyansh Mishra, and Aditya Shukla.
Can we have a huge round of applause for the students whose ideas were selected in UPCST?
I also request Kuldeep Sahai sir to give certificate of appreciation to our students. I will request students to kindly stay here on the right side of the stage. The second project is Intelligent Drone AI-based platform for environmental mitigation using advanced dispersal method from Mechanical Engineering Department. The mentor of this project is Mr. Shiv Kumar Tripathi sir. I request Vishal Nandkishore Mishra to come on the stage and receive certificate of appreciation from our dignitaries.
Can we have a huge round of applause for Mechanical Department students?
The third project is IoT-based smart wheelchair, voice-controlled wheelchair with collision avoidance and health monitoring system from Electronics and Communication Engineering Department. The guide of this team is Mr. Abhishek Kulshesh sir. I'd like to call the group leader Anush Kumar Yadav and Ariba Ahmed to come on the stage and get the certificate of appreciation from our dignitaries.
Can we have a huge round of applause for Ariba and team?
The fourth project is Anomify, anomaly detection in streaming data from Information Technology Department. The mentor of this project is Mr. Shivam Shukla sir. I request Ananya Joshi and Divyanshi Shukla to come on the stage and receive certificate from Pooja ma'am.
Can we have a huge round of applause for Divyanshi and team from IT Department?
Now I request all the dignitaries and students for a group photograph. Thank you, students. We congratulate all students and mentors for their efforts and express our gratitude to CSTUP for supporting innovation and IPR initiatives at our institute. I hope that all participants will be beneficial from today's IPR-based workshop and make best use of the valuable insights of today's session. Thank you to all.
Thank you so much, ma'am. I request all the dignitaries to please stay with us on the stage for the felicitation and momentum presentation to our guests. Now we move forward to a very special and the proud moment of today's workshop, the formal welcome and thanking of the guest of honors.
We feel honored to invite our respected dignitaries to welcome the guests with their warm presence and their gestures.
I would also request Dr. Anita Parnam, Head of Department of Computer Science, and Dr. Brijesh Pandey, Sir, Convener of the program, and Associate Dean to join us on the stage. Now, we request Dr. Anita Parnam, Head of Department Computer Science Engineering, to present the token of gratitude and thank Dr. Pooja Yadav, ma'am. Can we have a huge round of applause for Dr. Pooja Yadav, ma'am, for joining us and taking out time for our IPR workshop today. Dr. Pooja Yadav, ma'am, is working as a joint secretary at UPCST. Now, I request Dr. Alok Jain, Sir, Director Planning and Coordination, to present the token of gratitude and respect to Sri Ravi Lal, Sir, Director UPCST, to please come forward and take the mementos. Thank you so much, sir, for joining us today and taking out the time for this IPR workshop. We are very grateful. Now, I request Dr. Brijesh Pandey, Sir, Director, Goel Institute of Technology and Management, to present the token of gratitude to Professor Kuldeep Sahai, Sir. A huge round of applause for Professor Kuldeep Sahai, Sir. I request an August gathering to please put their hands together while we present the momentum and thanking gratitude to our guests.
Now I request Dr. Devendra Agarwal, Sir, Dean Academics, GITM, to present the token of gratitude to Dr. Arun Kumar Singh, Sir. Thank you so much, sir, for coming for this session. Now I request Dr. Brijesh Pandey, Sir, convener of the program, to present a token of gratitude to Colonel Dr. Sameer Mishra, Sir, Executive Director, Lucknow Management Association, Lucknow. Thank you so much, sir.
I request the technical team to please cover the group picture. Thank you so much, dignitaries, for joining us today on the stage. Now, I would like to call upon the stage Dr. Brijesh Pandey, sir, Associate Dean Academics, GITM, for the inauguration session vote of thanks. Can we have a huge round of applause and welcome Dr. Brijesh Pandey, sir.
It gives me immense pleasure to welcome and thank all the dignitaries present here. My sincere thanks to Pooja ma'am and Sri Rahul sir for giving valuable talks and information about the CSTs and all. I again thank Professor Kuldeep Sahai sir for giving his valuable time here in the institute. Arun Singh sir is here for a keynote session, and Samir sir is here for the keynote session. I am thankful to you also. All the dignitaries present here, directors, deans, HODs, faculty members, all the dear students. This session is very valuable for us, and I would like to say that after this session, I commit to CSTUP that you will see a lot of patents from our institute, and this workshop will be will give a lot of importance to our students and faculty members. Thank you so much, sir. Thank you.
Thank you so much, sir. Now, as we move forward with the keynote sessions.
We now move to our first keynote session. It is our pleasure to invite Dr. Arun Kumar Singh, sir, Associate Professor, Department of Electronics Engineering, REC, Kannauj. Sir has academic experience and research knowledge will surely guide us and inspire us. We request everyone to welcome him with a warm round of applause. I request sir to welcome on this stage
I request students at the back to please settle down as we move forward with the program.
I would like to invite Dr. Arun Kumar Singh, sir, Associate Professor, Department of Electronics Engineering, Rajki Engineering College, Kannauj. So please give a big round of applause for sir.
good morning to all of you. I think still it is a good morning. The IPR workshop, as you know, the IPR workshop is one of the flagship program of the UPCST. I am one of the founding member of the startup program in the Engineering College, and we have taken a workshop, I think in late 4 years back, to start the ecosystem of startups and innovations in the government engineering colleges. As our colleague Chancellor is also there with me in that workshop when we are planning to start the ecosystem of research, innovation, incubation in different RCs. So, I have made that GITM for how we can start that ecosystem in the government engineering colleges. At that time, I contacted one Ms. Geeta Madam from the MIT and J. Ram Kumar sir of IIT Kanpur. I have just concluded one IPR session and workshop in RC Kannauj in the month of November, just 2 months back, in which J. Ram Kumar sir from IIT Kanpur and his team members are there to share their thoughts on the IPR. Today I have make a presentation on the academics in IPR, how we can use the IPR and what are the significance of intellectual properties in the academics and how we can use the prevailing laws to protect our intellectual properties. As Pooja ji has said, because he is the joint director, but he was co-author with me in the year 2015 because his and my supervisor are same, Professor B.S. Yadav sir, and we have worked on the same technologies, forward methods and other. In the core computer science, basically I am the man of the electronics, but my more of the research are in the core computer science. In BTech, I have done my research on the expert system, in MTech in VLSI and other with the help of simulations, and in PhD, the ad hoc networking, the formalization of ad hoc networking, which is the core mathematical foundation of any computer science field. The persons who are working in the field of pure mathematical background, they know that how it is difficult to formalize any system. So, when you put lot of efforts in anything and anyone other use their framework or your work and start from there by making little bit of modification in that, here comes the protection from the patent and other copyright forms. So it is important to know about the rights you have to protect your work from the copying. In patent, one thing is important, that anything which has the value of commercial importance, that can be patented. If it has no commercial value, it is of no use. We cannot patent that things. So I simply started from the basics of the IPR. I try to address the keywords, what that means, because we heard a lot of terms, but before going into details of that, what we start to using that terms. So it is important to know the exact meaning, what it tries to convey. It is important before filing any IPR, before filing any patent. It is important to know whether it is changing or not. It can be sustainable or not, because we can apply for any patent. It can be granted or not. It depends on its originality. Yesterday I was reading a newspaper because one company, I simply say that he has applied for the patent of the drug for the cancer, and just it is rejected by the Indian patent law, by the patent authorities, because there is no innovation in that. They are using the generic drug but selling with some other names and try to patent it in their name. So they simply reject it. Anyone can say, can search it on Google by TOI News Times of India news on drug patent, rejected drug patent application of the NLC. So you can say that because there are a number of things already available and we are not patented it or claiming that it is the original of our country or our area where GITM is also coming to the picture. As Rajesh Pandey and Rajan Lalji and Madam has said that the UP is one of the leading state who is taking the lead in the GI tag. So now we can start with the basics of the IPR because I am an academics and deal with the academics. So I try to be like a teacher and try to explain the each and every intricacies of the IPR. If anyone wants, then I can also cover the how we can file the IPRs and in which way we can be aware of these things. So basically, IPR means patent. It is a creation of mind. Anything which is in your mind and it is of any commercial value, it can be patented. So intellectual property refers to the creation of mind. That is invention, any industrial design for articles or literary or artistic work. Anything which is of any commercial value can be patented. And according to the so according to what the intellectual property organization, intellectual property refers to literary, artistic and scientific works, performance, broadcast, videos, computer games. You know that computer games also can be protected by the under the patent. Computer programs, images, logos, anything which is generated from your mind can be protected within the laws of the countries and WIPO. So anything, when we say anything, means anything which is generated from your mind. When we are talking about anything, it should be tangible or intangible, irrespective, can be secured with the laws and which is what is known as the patent or copyright and other things. So it is a set of principles and rules that regulate the acquisition, the use, the enforcement and the loss of rights and interest in intangible differentiating assets that are vulnerable of being used in the commerce. So what are the nature of rights? Rights only in the form of an expression and not on content. You can claim on the nature, not on the content of that nature. Any other person can come with other content. So, but have different natures. He can get patent on that also. You can make a claim on the complete part or some part of any of the work you have done, or any things you want to know that it is of any commercial value in future or in that project. You can claim that I want to patent this art case or this portion only of my work. It can be patented. When you patented it in your name, you can transfer later on to any other third party. and you also keep with yourself that you want to transfer or not. It is up to you. So when we talk about areas of IPR, it can be classified into majorly two parts, that is industrial property and copyrights. There are 10 industrial property rights are there. 10 ideas are covered by the industrial property rights. I will cover it in the next slide. And number of expressions are the subject of the matter of copyrights. You can, different type of expressions or design can be patented under the expression of copyright. So when we say about the industrial property rights, there can be any technical creation, for example, invention, industrial design, layout of ICs. As engineering students, you all know about the ICs. We are using number of ICs, and different companies use different design patterns. So because why they uses, we are all using the computers and mobiles nowadays, but all companies, although their functionality are the same, but they use different design because it was patented by some other companies. They cannot use the same design for themselves without paying some money to the patented company. So that's why we see that there are the same functionality with different design patterns, because some other companies got patent on that. It can be patented under industrial property. So utility models, plant varieties can also be. That's why UP is leading in that, because there are a number of plant varieties in Lucknow also. For mangoes, the mangoes. You can use patent different distinctive sign. By only seeing the sign, you can distinguish that this is the product of this or that company. So any sign can also be protected under the patent law. Trademark, trade names, for example, when we say about the Tata EV motors. Geographical indications are the GI tags. Also the non-property competitive advantage, goodwill in the trade sectors and test data. With these we can move to the next slide. Invention can also be patented. What is invention? Any new solution to the problem. There are a number of problems already exist. If you make some changes and make it new and optimize it, it can be patented. Invention means an idea of an inventor which permits in practice the solution to a specific problem in the field of technology. So, patents are basically for the inventions. As I have said, discussed that any industrial design can be patented. So, you can use any design for aesthetic creation, determining the appearance of the product, ornamental aspect of useful or things, or the way it is produced, that is by industrial means, the way it is produced by the industrial means, that can also be protected by the patent and copyright. But it must be new and original. Anything which is new and original, either it is idea or it is product, can be patented. As we see the bottle, this bottle is patented by the Coca-Cola. No other company can use the same design of. It is of no monetary value, but only for appearance. Its appearance is design is protected by the Coca-Cola. Its design is protected by they are taking the patent on this design. No other soft drink company can use this bottle for their product and replace the name Coca-Cola. It is not possible. As this design is this shoe design is patented by the company Adidas. So they specific when we take the patent, we have to specify the different positions,
taking the soul, how we are taking, as far as this food is concerned, what is the internal material, how, so that no other company can use these type of design itself. If they want to use this type of design, they have to make minor changes into it. Without that, they cannot make the exact duplicate article of the same type. As an engineer, we all know about the integrated circuits, and I have already discussed that. When we see about the different tools and the use of the ICs in that, although their functionality are the same, but we cannot replace the IC of one company with the IC of other company, because they are protected by the laws of that country, that it has to be protected. So you have to take permission by giving some money, as far as they, because they are the commercial companies, they charge for everything they service. So, because anyone who are electronics background, they know that ICs are not simply the upper portion which looks from the outside. There are a lot of intricacy, lot of labor is required to design any layout. There are a number of the fabrication of IC. It takes 6 steps from fabrication design to final product. It takes 6 steps. So all these steps, because any company who is going to design an IC has to follow these 6 steps. So where they differ in the process, in their outlook, and their application is same although, but they differ from their outlook, so they can be patented. Because if one has developed some design, other can use that by changing that and only changing minor changes in that can use for their commercial purpose. So ICs are patented, are protected by the patent laws. Natural resources can also be patented if it is specific to some geographical areas. Any plant, if you develop by modifications, it can be patented. You have found that you all have heard about the GM modified food. So, the product or plant or seed which is naturally growing, and we are going to make the changes by mixing or by changing the properties of that natural plant, it can be patented. It is of this other discussion that it is of basically it should be done or not, but it can be patented. GM modified mustard is, there are a lot of discussion when GM modified mustard is coming in Indian market. Either we should use or not. It is of other discussion for us, but as a patent, as a copyright, you can be patented. And when you got patent on that, you can sell the seed of that and make some profit from that. So anything which you want to protect, as it is your design or it is a natural product or it is look of that product, all things can be patented in the form of one or another. Only Indian patent laws protect atomic research from that and exclude atomic research from that and generic medicines from that and agriculture methods from that. Although agriculture instruments can be patented, but the method of agriculture which we are using cannot be patented in Indian laws. In other countries, it is also possible to make patent and claim that we have using a different way of seeding or growing any seed. It can be patented, but India is not possible. So, what is trademark? Any signed words, including personal names, letters, numerals, figures, elements, combination of any such signs, which is capable of distinguishing goods or services of one undertaking from those of the other undertaking shall be capable of constituting a trademark. It comes under the Article 15.1 of TRIPS. So you can also patent trademarks. You can claim what trademark. It is also granted by the patent laws of that country. For example, this is the trademark of the Tata. So that this is the trademark of Tata. By seeing that, you know that it is a Tata product. You have not to mention that this is from the Tata group. Only seeing the logo, you can know that it is from the Tata company. So, the slogan or when we are going to market that product, the taglines sometimes are more catchy and it can be patented. As we see in the Tata EV, the tagline is "Move with meaning." It catches and it is one of the most valuable tagline once 2 years back as claimed by the trade companies that Tata EV, which is used the "Move with meaning," catches the headlines. What is trade names? Commercial names and designations. It is the name or designation which identifies the enterprise. Any name which all the names cannot be protected unless it has the potential of being commercially used or exploited. You cannot name. If you are reading newspaper, I think 3 or 4 months back, one thing comes in the market and its name was patented, but ultimately it was got cancelled by the company. Anyone knows or anyone remember that name which they got patented by the patent office? One company which sells namkeen, she got trade name for that product. Anyone remember which ultimately got to be cancelled by the patent office? Because it hurts the sentiments of the persons. In the same line of Haldiram's, I also hinted that you can search and name me in the 5 minutes, otherwise I will tell you the story of that. So you cannot name anything which hurt the sentiment without any commercial value. Sometimes the patent authority give the copyright patent name and patented, but they have to cancel that because there is after granting the patent, there are 3 to 6 months time period in which anyone claims that it is already patented or it hurts, it is of no commercial viability or it is making the only for the purpose other than its commercial values. It can be cancelled. So it is not that once you have granted the patent, you started using that. In 6 months it can be cancelled. And by using that laws, only it has been cancelled by the Indian Patent Office. Any slogan which is unique to that organization can also be patented, like कुछ अच्छा हो गया, कुछ मीठा हो गया. All one know that this is for the Cadbury chocolates. So, like these small things which comes into our mind can be of commercial viability, can be of commercial values, and if we got patented, we can make happy amount from this thought of this creation of our mind. So, be aware, be careful in getting the protection and getting the rights from the patent office, because which thoughts or which invention or which innovation of your makes you richer, you do not know. Be aware and try to take, if you think that will be of any commercial viability, got patented in your name. The fees is very much less And now, as a technical institution, we got support from the AICT under the name of Kapila support. They got for every patent they support by providing giving the application fee reimbursed by giving it a 5600 rupees per patent you apply. Also, AITU is supporting the IPR patentable, and from their fund they are supporting the cost, all the cost involved in applying for the patent, the till grant of the patent. They are charging nothing from you. As a affiliated institute, we can take advantage of that, and they are supporting each fund. Not a single penny from your pocket is going to be there. Because I am coming from Kannauj, so it is important that I talk about the perfumery of the Kannauj. So, after 1990, although it is used decades and 100, 200, 500 years back, but only got patented or secured after GIA 1998 come into the picture. So now, if any perfume which is they are manufacturing from last 200, 400 years back, but now they can got their protection from under the GI indication tag. Because it is simply, when we talk about perfumes, the area comes in the picture is Kannauj. So, although we all know that it is from Kannauj or it is related to Kannauj, but we have got protection by applying the patent for that or GI tag, getting the GI tag for that product. So, it is important if anything is specific to that region, for example, rice, which is known as Kala Namak, it is specific to the Gorakhpur region. So, it is got GI tag nowadays. So, you have to be careful as a businessman, as a educationist, as a technocrat, as a student also, to take which you thought that it is of importance got patented by applying for that design. As one also know, we are in the habit of publishing papers as a researcher or as a tech students or PhD students. But once when you research a paper, you cannot got the patent on that paper. First of all, you have to apply for the patent, and then after that, you go for the publication. Once a paper is published, you cannot claim for any things of that paper for your patent application. This is a classical way how the perfumes are made in the Kannauj. So, what invention means an idea of an inventor which permits in practice the solution to a specific problem in the field of technology. Now we talk about the technology. So, a patent is an exclusive right granted by a country to the owner of the invention to make, use, manufacture and market the invention, provided the invention satisfies certain conditions stipulated in the laws of that country or that region. Exclusively, the right implies that no one else can make, use, manufacture or market the invention without the consent of the patent holder. So, when we talk about patents, there are three terms which are commonly used. That patent is not that it is for valid for their lifetime. It is only valid for 20 years. After that, it becomes property of the general person. So, any patent is only for the 20 years. Otherwise, you have to repatent that term. The right is available for a limited period of time, that is for 20 years. Right is temporary in nature, that is applied to the country where it is granted. And the right is confirmed by the state, it can be revoked by the state under very special circumstances. That's why I give the example of that nothing. So, under TRIPS agreement, more than 140 countries give such protection of the patent. Any country, which is if under that agreement the members of the TRIPS countries will recognize the patent granted in other countries. So, what can be patented? So, to be patentable, the invention must qualify three aspects simultaneously. What are these three aspects? That is, it must have novelty, inventiveness, and industry applicability. Without a third, it is of no use. You cannot only make patent ideas, but if it has no other commercial value or industrial applications, it is of no use. So, before granting any patent, the patent companies or authorities look in these three issues, that is novelty, inventiveness, and industry applicability. It is given in the Article 27.1 of the TRIPS. So, what is novelty? When we talk about novelty, means novelty is of three types, that is absolute novelty, relative novelty, and territorial novelty. Absolute novelty means no one else has done work on that before you. Means not published anywhere in the world, not used anywhere in the world. Relative novelty, not published anywhere in the world, not used in that country, but it may be used in the other country. So, patent can be granted in that country for that product which is already used in some other country. Territorial novelty, not published within the country, not used within the country. So, you have to play when you are filing for the patent that it is in which category it falls. Either it is absolute novelty, or it is in relative novelty, or it is in territorial novelty. What is inventiveness? This is two types, that is non-obviousness, and the proposed invention should not be obvious to a person skilled in subject matter of the patent application. When you read any chapter as a student, many things come into your mind, but it is natural to all the students, so it cannot be patented. Unless it is, because every other person or every other student who reads that subject, at least they know about what is in that subject. So it cannot be obvious. Complexity or the simplicity of an inventive steps does not have any bearing on the grant of the patent. More simplicity of invention is sufficient to form a valid patent. What is industrial applicability? An invention is capable of industrial application if it satisfies three conditions. When we say that it is industrial applicable, it must follow, it must comply the three conditions. What are they? It can be made by using any known means or methods. It can be used at least one field of the activity to satisfy some of the human needs, and it can be reproduced with the same characteristics as many times as necessary. So, reproducibility, usability of human person, and known methodology, known algorithms. If it follows, it satisfies these three conditions, then only it can be patented. So, when you are going to file a patent, what cautions are there? So, filing of an application for a patent at the earliest possible date is critical, because you are not the only one who are working on that subject or that area. Many persons in the world are working on that area. So, the time, the instant the thought comes in your mind and you work on that and you got some positive results, try to patent it. It may be late because some other company, some other person, some other group are also working on that problem. File with the provisional specification, you can file with the provisional specification, and later on you can explain it or remodify it. It can be modified. Should be considered for publication only after patent application, as I have already said. the date of patent is the date of filing the complete specifications. You can start your patent filing by giving the provisional specifications, and later when you make it more specific or complete specifications, the date you submit your complete specification, from that date it is considered for the date of filing. So you can start your filing the time, the thoughts and the applications or work you think is of any commercial viability or use. Something I say which is not patentable in India or which is contrary to the well-established natural laws. Anything which is defies the natural laws cannot be patented. Contrary to the law of morality of public order, if any patent you are going to file, it is going to disturb the public order, it cannot be patented. Or it is not falls under the morality section, it can be not patented, it can be revoked if somewhere in some other country you got the patent on that product, but it can be revoked in that country or in that territory where you are going to use that. Something which is injurious to public health, including human, animal, plant or environment, is not patentable in India under the Section 3 of the Indian Patent Act. More discovery of scientific principle, there or formulation of an abstract theory or discovery of an living things or discovery of non-living substance occurring in nature is not patentable. In India, it is not patentable, but some other country, you can got patent on that. That's why nowadays it comes, the patent should be of Indian, not we are Indian under Patent Act. Any patent which is patented under Indian Patent Act is now recognized in different types where you claim that I got that patent. In India, you have got that. Any process of medicinal, surgical, curative, prophylactic, diagnosis, therapeutic use or treatment of human beings or a similar treatment of animals to render them free of disease or to increase their economic value or that of their product cannot be patentable in India. However, treatment performed on tissues or fluid permanently removed from the body and surgical apparatus or instruments are patentable. Means only anything, the process cannot be patentable unless it is done with some novelty, some new instruments to remove or changes. For example, to remove the fluids permanently from the body by some surgical method, then it can be patented. And in method of agriculture, horticulture is also not patentable, as I already discussed. However, the agricultural equipment can be patented. Under Section 4 of the Patent Law of India, inventions relating to atomic energy, anything related to atomic energy cannot be patented in India. That is, for example, invention relating to the compounds of uranium, beryllium, thorium, plutonium, as notified by the central government from time to time. So, any chemical engineer from the person from the chemistry background, they cannot claim for the patent of these compounds, that radioactive elements. It is not permissible in India under Section 4. Other is copyright. What copyright covers? Simply artistic creation, any literary work, musical work, dramatic work, cinematographic work, it all can be copyrighted under the Patent Law of India. In most European languages other than English, it is called author's right. Copyright is also known in other name, it is the author's right. And the symbol for the copyright is C under circle. So, what are the terms for copyright? The work must be first published in India, or the author of the work must be a citizen of India. Forget the literary work copyright. The scope of a copyright includes reproduction, performance, communication, translation, or adoption. In India, copyright on literary work is provided for the lifetime for the authors, plus 60 years after his death, means your complete life, and after your death, it is valid for the more 60 years. You can get copyright and the copyright amount from the publisher of that work you have done. In case of blind authorship, the 60-year period is calculated from the beginning of the calendar year following the year in which the last author dies. So, what is the infringement of IPR? All the forms of IPR are liable to be infringed upon. That's why courts come into the picture. Infringement of IPR means unauthorized use of someone else's intellectual property. It is critical that the IPR owners duly safeguards their asset. And the copyright is said to be infringed when a person violates the exclusive right of the owner of the copyright without a license having been granted to exploit the work commercially by the way of sale or hire or distribution. So, when we copy a book and use that, it also comes under copyright forms. Although in India we are generally used without knowing or knowingly or unknowingly. We are using the book without purchasing the original copy, but just copying the copy, it also comes under the copyright act. So, for that the provisional penalties are there. It is a non-bailable offence. The period of imprisonment is a maximum of 6 months, which may be extended up to 3 years, and a fine of 50,000. So it is the purpose of the patent is for the fair use. If you have done some work and got patent on that, the other person has to take permission from you to use that. You can challenge if any other person or any other company uses your product or your work for their use without your consent, you can challenge that, and for that there are IPR enforcement agencies. But to make them the enforcement, it is challenging because the police are not telling that. You can have to prove that your copyright is misused by some other person without your permission. So it is not easy to identify pirated software, primarily because the pirated version is identical to the original in almost all aspects. But the enormous price difference between original and counterfeit encourages infringement. But the price is the factor which encourages this type of copying. So now I come to the last 1 or 2 slides. What is the significance of IPR? The access to more advanced technologies increases because someone has already done basic work on that and got patented in their name. You simply get access, permission from that person or that company, and it starts to where it has someone had already done in that area. Technology transfer, licensing, and investments become much easier with IPR laws. Leads not only to export of product but also the export of adopted improved technology. Acquired technology generally comes accompanied by foreign capitals and investment in considerable quantities. One case study. You and me all have. This lady has got a patent on this. I think you all know this. Right? And it got expired in the year 2005 because we had not paid the amount of removing that IPR of $400. And nowadays, this toy sells 19 million per year. And because she has not paid only $400, she loses around around 1 million per year because of only not spending $400. Because nowadays it is a market of 900 billion globally per year. This device sells 90 billion per year. And by taking only few considerations, get only 1% of that, you can know that how much is or not got patented by that, not removing that patent. Although she got patent in 1993, 1997, but in year 2005 she has not renewed that patent. So sometimes you are not so, by your casual approach, are not so inclined towards seeing the commercial viability of that while the work you have done. You have lost anything. It is of a huge amount in the terms of monetary. So with these, one thing I know that Kapila, this is Kalam program for archery literacy and awareness. By this, you can search on the AICT website and get the support of 5600 INR per application for patent filing. Any institute which are supported is AICT affiliated because any technical course, all the courses are approved by the AICT. So any institute who run the technical courses can use the program of central government, Kapila, for applying the product. So these are the references I have taken to make my slides and convey my knowledge or my understanding of the patent for you. So, in the last, we can conclude by this that IPRs are valuable. They help in improving the economics conditions of the country only if they are well protected and enforced. So, thank you. And if any question of you for anything regarding how we can file or what are any terms you have not understand, I am happy to answer that.
Thank you so much, sir. It was very indeed inspiring. We got to know about the geographical indicators, about the patents in detail, and also the ethical and the legal aspects of patenting and IPR. Now we move forward with our second keynote speaker. We are honored to invite our next keynote speaker, Colonel Dr. Sameer Mishra, Sir, Executive Director, Lucknow Management Association. He brings extensive experience in leadership, strategic management, and professional development, and plays a key role in promoting industry, academia, collaboration, and managerial excellence. We warmly welcome Colonel Dr. Sameer Mishra, Sir. Can we have a huge round of applause for Sameer Mishra, Sir?
Good afternoon. Firstly, I'd like to thank Dr. Asthana, the Management Committee of GITM faculty for inviting me for this session. And I would like to say and my sincere thanks to the faculty those who have come from outside, and the students for coming and attending this important session. Those who are the faculty and the students, for both, the understanding IPR is very important in the sense that in today's scenario in India, where our Prime Minister is focusing more on Make in India, we are focusing more on the startups. In startups, initially when you pass out from the college, you got two options. One, you are go for a job or you start your own startup. Now, the advantage of a startup is that if you go for a job, what you will get? You will get a salary. You will earn certain money. But when you start your own startup, what you are going to earn is not the money. What you are going to earn? You are going to earn wealth. Instead of becoming an employee, you will become an employer. Now, one has to take a risk, and you can say if they got an idea, they feel their idea is brilliant and it can work and you can do something, then startup is the right choice. And when you are going to start your own startup, the most important thing is understanding IPR, the intellectual property theft. I will just put one incident. In 1992, while I was serving in the army, I was pushing the border area. There was a lot of infiltration was taken from the enemy side. So I was being a technical officer, done my BTech in electronics and MTech in microwave. So I was asked by my seniors to do something. So I had invented one device called passive infiltration detection system, and that was very effective. I gave it to the unit. They made number of pieces of that, and they were installed in the border areas, and they were quite effective. One day, my senior officer called me, and he said, "Yeah, see, देखो, ये vendor आया है. He is also selling the same passive device, detection device which you had developed." So I was surprised. It कैसे हो गया? So I said, "Sir, can you get me one piece of that?" So जब मैंने उसको लेके आया और खोला, I find that the same circuitry which I had developed. That time I realized कि यार ये तो बहुत बड़ी गलती हो गई. After inventing this, I had not gone for the patentship. And now, since I was in army, I cannot go commercial. Now that chap is taking my stolen or whatever you can say, he has taken my idea and he is making money. So, one has to very careful when you are going to start your startup. You do lot of R&D, you do lot of running around, lot of hard work, and then you develop a product. Once you have developed a product, you will definitely like to recover the money which you had spent in developing that product. So automatically your price will go up. But somebody will copy your idea and he will save that much of R&D money or the hard work, which physical, tangible and intangible, you can say, efforts. And then he will start selling in the less price. You're gone. Nobody is going to purchase. We all are in India, we all are economy-driven society. We are more concerned about the money. We are not seeing who is doing what. Same thing, second incident had happened. My wife, she runs an NGO. She had developed a product. Because she was an artist, so she had made some product and she put it on the online for sale. We were in Delhi at that time. She had gone to the market. She is the same product what she was making. लगा हुआ था उधर पे. क्यों सरप्राइज कि कहाँ से आया, किसी ने बनाया, कुछ पता नहीं. बट मार्केट में धड़ल्ले से बिक रहा था. No, to protect such things, one has to be very careful. And understanding that faculties, they also got a lot of responsibility in this regard, that they should keep telling their students कि भाई इसको जो आप कर रहे हो, they must be having a today's generation, the little jet is very brilliant. They got a lot of good ideas and brilliant ideas, but half of them are not able to succeed because their ideas are before that it has been stolen. Before they put into the action, it is stolen. So, with this, I will, the certain slides of mine is covering the same data which Dr. Arun has already covered. I will just add on to him what he said, and I will skip to save the time. Now, what is intellectual property right? It's a right linked to intangible assets. By an individual or a business to safeguard such assets against unlawful use. Tangible assets है, आपका गाड़ी है, मकान है, आप उसको अच्छी तरह प्रोटेक्ट करोगे. गाड़ी में 4 ताले लगा के रखोगे, घर में 10 ताले लगा के रखोगे, लेकिन उसका क्या जो आपका इंटेलेक्चुअल प्रॉपर्टी है, उसको प्रोटेक्ट करने के लिए we are having IPR. Now, in this case, this includes 3. It's basically right to reproduce, right to sell such work. बनाया आपने, बेच कोई और रहा है. तीसरा, right to create other forms of such work. थोड़ा बहुत ऐड किया और उसमें अपना नाम जोड़ दिया और उसको मार्केट में फ्लोट कर दिया. That is also prohibited. Now, in this monopoly, once you have a patent shape for copyright, you will have certain monopoly. You enjoy the monopoly and the benefit of monopoly. But it is not one way that you enjoy the monopoly. It is that you should not get, as Dr. Rana said, that you cannot get each and everything patented. You cannot have right on everything. अब ये तो मेरा ही हो गया, मैं करूँगा. No, you cannot have a monopoly on everything. So, certain things are permissible under IPR Act to get registered. Now, these include invention, literature, artistic masterpiece, design, enabling titles, pictures, supplies, commerce, and business. Such creation prone to copying, which are prone to copying and can be used for a commercial benefit. Now, the tagline this thing is commercial benefit. If I had reading some material from some book, I'm using it for my personal listing or for some personal knowledge or increasing something, that is not, and there is not a punishment. If I will start making use of that knowledge and start making money out of it, then it's an offense. Now, we have already gone through this. There are 7 types of IPR. Already been covered by Dr. Arun in great detail. I'll just add on something to it. That is, copyright basically right not to copy. As the word says, copyright मतलब कॉपी मेरी है, इसका कोई कॉपी दूसरी कॉपी रिप्रोडक्शन नहीं हो सकता. Second is that it is authorized use of कॉन्टैक्ट, जो कंटेंट है वो सिर्फ मैं इस्तेमाल करूंगा। The second is a trademark. Now, in today's world, things have changed. Marketing has become very difficult. The concept has gone. जो दिखता था वो बिकता था, खत्म। Everything is customized. Now, to remain one product, पहले जमाने में वनस्पति मीट, हम पुराने वनस्पति मंडल को क्या बोलते थे? डालडा। मतलब डालडा बोला सिनोनिम ऑफ वनस्पति। रथ भी आता था उस जमाने में, ठीक है, सनफ्लावर ऑयल भी आता था, बट लेकिन वनस्पति बोला तो यानी डालडा। सो वो जमाने अब गए। Now people have forget what dalda is. Now there are 20 other vanaspati oils available in market. Now how to increase the saleability? The best method is you have to remain in the top of the mind. बंदे ने बोला वनस्पति, you should immediately say dalda. Luxury car, BMW. So just to keep remain in the top of the mind, one has to create a trademark. मैकडॉनल्ड गए कोई? हमें कितने जो मैकडॉनल्ड में गए हाथ खड़ा करें? डाउन। और मैकडॉनल्ड का सबसे बड़ा ट्रेडमार्क क्या है? The big M. The moment you will see the M, you will recollect it's a McDonald's. So we cannot say the trademark doesn't hold any value. It is a symbol to create a brand. It is a symbol which attracts the public. It is a symbol which will increase your business. So, trademark is again very important. पेटेंट कराना बहुत जरूरी है। देखो वेरी फेमस, अब तो नहीं है, पहले वुलन फैक्ट्री होती थी, इसका लाल इमली नाम सुना? आपको नाम सुना लाल इमली? So it is to be written Lal, L-A-L, then there's a gap and Imli, I-M-L-I. Over a period of time, what people have done, they have started misusing the trademark with Lalimal, L-A-L-I and a dash, and just M-A-L. In one go, you cannot make out it's a Lalimli or it's a Lalimal. बंदा खरीद रहा है लाल इमली समझ के, और जबकि उसका फेक ब्रांड है लालिमल। So again, the patentship and the improvement of that is very important. Then geographical indications, हर एरिया का अपना अपना कुछ ब्रांड होता है। लखनऊ का क्या है? चिकनकारी। उसी तरह जो है फूड स्टॉक में जनरली होता है आपका नागपुर के संतरे। अगर आपसे पूछा संतरा मिलते हैं नागपुर का, खैर अब तो नाउ विद दिस हेल्प ऑफ ट्रांसपोर्टेशन एंड ऑल दैट एवरीथिंग इज अवेलेबल एवरीवेयर, बट मोमेंट यू से सम पर्टिकुलर नेम you will recollect the name of that place. So again that is for GI. Then patentship. Now in the patentship, then it is an official document giving its owner a sole right to make, use and sale of that particular product. If this the idea discovery. Now, in this, there are two things, patentship. one is of invention. Invention is something which was never exist. It's your creation, or you had invented or that thing. But discovery is that it is means that getting to know and find out something. Means somewhere in some form it was existing. So you have discovered. Then the design. Now, importance of design is very much there. In today's scenario, as I told earlier, the few products used to be there. खरीदना है तो खरीदो, नहीं खरीदना है तो मत खरीदो. आज के समय में एक ही प्रोडक्ट के 25 ब्रांड अवेलेबल है मार्केट में. Now, you got a mobile. मेरे पास सिर्फ मोबाइल है, फीचर्स है, सब कुछ है. हो सकता है दूसरा कोई मोबाइल आ जाए which will have a very different design, look wise. So, because of that, the psychology of novices, the psychology of attraction, you will go for the design. The new car, new model, anything which is having something, a design which is attractive, it holds a very good commercial value. So the patenting of that design again is very important. And plant value. Natural plant which you are growing this thing, you cannot get it patented. But something which you have developed by doing some biological experiment or something, that you can get patented. Now there was a thing called Kala Ghoda rice. Now, as we all know, rice is not good for diabetic person, but they had done some experiment with this thing and they had developed a rice which can be taken by the diabetic patient. Now, that can be patented because they had add on something, some value, some specialty, some USP to that product. So now, the semiconductor IC circuits. When I was doing my BTech in electronics in 1986, in our time, IC circuit was introduced. The first IC was 555, IC 555. Those who are from the engineering, they must be doing. And the size of the IC is this big. Just the 555 which can do the flip circuit was this big. Now, the chips have become this small. And the impact of that design is not only on the chip, it is on the overall size of the product where that chip is going to be used. Anybody has seen the first mobile which was launched by the Motorola? उसका साइज कितना बड़ा था? Any idea? किसी ने देखा है? फोटो देखिए. It was a 11-inch size of that mobile. 11-inch. Because it was installed with the ICs which of this size. 1.5 से 2 इंच साइज के ICs लगे थे उसमें 8 से 10. Now you see the Motorola. फोल्ड करके आता है इतना बड़ा. So इतना बड़ा. कैसे? Because the chip size which was there at that time was this big, now it has been reduced to this. So because the chip scientists, the entire size and shape of the model has been changed. So the importance of this IC circuit design is very much on the development of technology. Now, my main topic of my lecture is the importance of IPR in technology development in India, growth of technology. So, in that, basically, in technology, I'm not going to talk about the creativity or artistic design or copyright of books and all that. We talk really specific to the inventions and technical growth which has contributed in the economic growth. So that protecting the ideas, incentive, R&D, attract foreign FDIs. Now, the foster invention and creativity. The first importance of the IPR in technology is in foster innovations and resilience. आपने as I told earlier, आपने प्रोडक्ट बनाया, प्रोडक्ट बनाने के बाद somebody has taken that design और आपका प्रोडक्ट की सेलेबिलिटी खत्म कर दी, ये उसको बचाता है. It will give you a lot of strength and encouragement कि हाँ भाई मैं प्रोटेक्टेड हूँ, मेरा जो मेहनत है वो पानी में नहीं जाएगा. Then drives economic growth. Once you have done the IPR, your product is well known and it can be contributed in the economic growth of the country. Then it attracts the instrument and funding. Now if you go for the funding, you say my product is already registered and patented, anybody will be ready to do the funding. But if you go and say नहीं मेरा प्रोडक्ट है, बहुत अच्छा है, काम करता है, सब कुछ है, people will hesitate. भैया सही में बोल रहा है, नहीं रहा, बिकेगा नहीं बिकेगा, क्या है, worth it or not. Then build brand value and trust. Very important. Branding is very important. When you are writing that this is my under the brand logo or you are writing that patented under patent act number so and so registration number this, automatically people will have trust in you, and that trust will build your brand value. Then create revenue streams. ट्रस्ट बन गया, ब्रांड वैल्यू बन गई, सामान बिकने लगा तो रेवेन्यू आएगा ही आएगा. That ensures fair competition. Now, no, you are not stealing somebody's idea, not you are allowing somebody else to copy your idea. So, whatever you are doing is a fair competition. Then support startups and SMEs. Very important this idea. In the form, I think that strong IPR is always going to support the SMEs and startups. Because the major fear starting the startup is that कहीं मेरा प्रोडक्ट जो है वो कॉपी ना हो जाए. Then तीन सेक्टर में it can access, that is the technology में encourage R&D, fosters IT growth, facility collaboration. Then pharmaceuticals में जैसे कि अभी आपने कोविड के दौरान सुना होगा जो एंटीडोट्स क्रिएट की गई, ठीक है, उसके लिए प्रोटेक्ट करने के लिए lot many companies they were developing, but only few were able to complete the test and they were given the patentship because they were in the race. सब चाहे तो मेरा जो है एंटीवायरस पहले आ जाए. उसमें they were skipping number of steps, and when they were skipping the number of steps which is supposed to be carried out in any trials, they were not given the patentship. So there the patentship and help in the product which is going to the consumer is not half meat or half-cooked type, which can harm the patients. Then creative industries. All this industries in today's even if you go for the IPL match, that again that industry is based on any idea? The money which is being generated from the viewers. और उसको टेलीकास्ट करने के लिए जो है भरपूर टेक्नोलॉजी का इस्तेमाल होता है। एक शॉट लगाया विराट कोहली ने तो उसके 10 क्लिप्स आएंगे, बॉल भी आएगी, हुक भी आएगा, कितने मारे, कितने, एवरीथिंग विल कम। नाउ दैट इज अगेन creating the value, or you can say earning the economic growth, money for that IPL. So उसका भी पेटेंटशिप जो है वो सिस्टम का कराया जाता है। Now, the type of IPL growth of technology, there are two types of technical this thing. One is the innovation, which generally means they are doing something new and improve the product. And second is that we are getting the technology transfer, and then we are making something new. अभी ऑफ सिंदूर का नाम सुना लोगों ने? ऑफ सिंदूर, उसमें मिसाइल ब्रह्मोस was used. सुना है नहीं सुना है? अभी पीछे स्टूडेंट। So now that BrahMos is not developed solely by the India, it is the technology transfer with the Russian, and then BrahMos was developed. So the technology transfer is also important for developing something. मेरे पास कुछ है, तुम्हारे पास कुछ है, we'll collaborate and we'll develop something else. Or there are countries, those who are economically good, they can spend money in R&D and they can develop the technology. The countries which are not economically that well, you can spend that much money in R&D, they can do the collaboration and they can have a technology transfer. Then innovation and invention and patents. Basically, inventions are bedrock of innovation, and invention is a new solution for technical problem. As I told, you have to develop something new, and patent protects the interests of inventor. And those techniques are truly groundbreaking and commercially successful. Now, the individual companies that hold the patent the right to produce the definition, already you must told you, then the patent that can last for 20 years. Maybe you have to get it renewed after some period, and then usually you have to pay certain fees periodically. Then international patent system. It may be possible that you can get the patentship done in your country, but it cannot be in the foreign country. So you have to separately take up the case. There is a group of 152 countries. If you get yourself registered through their patentship through that, then you will get the patentship of that 152 countries. The benefit of that, if you apply the patentship in 152 separately, it will cost you a lot. But if you go through that, the cost price will be very less. And then you can use the facility in that country. Then common rules and regulations are there with all the countries. Then possibly test the market. Now in this, आपका एक one major advantage is आपने एक बार 152 countries जो है वो किसी चीज के साथ में आपने पेटेंटशिप अप्लाई करके 18 महीने के अंदर आप उसको अगर चाहें तो वापस ले सकते हैं. So the advantage of that 18 months is you will test your product. If you think it is viable to continue, you can continue. If you feel no, then you can withdraw that thing. Now, these are the advantages you can say that patent recognized inventors for their commercially successful invention. Then when technology comes onto the market, society as a whole will come to know and get benefited. Then revenue generated from the commercially successful patentship. Then patent effectively turns an inventor's know-how. You get patentship done, people will come to know in the industry that this thing has come up in the market. Now, holding the patent also makes a small business more attractive. So, because as I told, the trust will generate and trust will build the brand. The technical information of the business intelligence generated by the patent system spark new ideas. आपने एक पेटेंटशिप कराया, उससे जो है it can promote new inventions also, उससे related, उससे मिलते जुलते something. Again, people will start thinking on those lines. Then patent invention can be made. The complete government will also know technical protector क्या है, so एक accountability also generate होती है. Then as patent means that you will stop the third party to use your brand or innovation or idea. Now, technology diffusion means transfer of technology. That is important. We will understand that. It is done in two forms: the formal and informal method. Informal method, it is the international technology transfer refers to process by which firm in one country gain access and employ techniques developed in the another country. एक country से technology आए वो आपके अपने country में आएगी, आके they will help you in developing that. This is a formal, you can say, agreement between the countries and the firms, and they do that. Then, which flow the borders via a number of formal and informal steps. The one challenge is the goods and services, which import goods having the patent transfer knowledge through reverse engineering. Now, formal, they will tell you the engineering, as I told about the Brahmons. There's a formal type of this thing that engineering and the thing has been given, the collaboration has been done, something new has been developed. Then, second channel is the FBI. Now, we had heard this word FBI more in the retail, like Walmart coming with the FBI and other companies they are coming with the FBI, increase in FBI. he must have heard this terminology. But in technology, it got a slightly different connotation. Is that in that MNC is expected to deploy advanced technology in the subsidiaries? So they deploy their technology. Like again in the defense sector, I would say India is getting the technology for the Rafale. They are making the aircraft. They have set up the factory. Their engineers and technology and machines and everything has come, and they are doing that manufacturing in India. But most of them, what happened? Generally, it is the done assembly thing. Okay. Then the licensing. Now, either they do that FDI or they do the licensing in this, which involves the purchase of production and distribution rights. लाइसेंस ले लिया, जैसे कि रिटेल में बात करो, लाइसेंस ले लिया किसी पर्टिकुलर आइटम का, एंड देन यू आर डिस्ट्रीब्यूटिंग इट. यू आर in other form you can say you are more a distributor rather than a business partner. So in that distribution rights are there and the knowledge required for effective use of these rights. So certain training like in technology we require certain know-how also about the equipment. In retail like अब आपने HUL से सोप लेके डिस्ट्रीब्यूशन शुरू कर दिया, यू आर डूइंग सिंपल, उसमें कोई बताने की जरूरत नहीं. बट सपोज यू आर गेटिंग अ कार फ्रॉम Hyundai. Now you should know, your salesperson should know the features, the details about the technology used in that car. So that know-how also has to be transferred with the companies to the countries those who are selling that product. Then the joint venture. Now, the third one is joint venture. Is many properties of FDI and licensing hence will involve technology, complete technology transfer. Whenever such company comes, they start with licensing, then they convert into the joint venture. They start making the product here, the parts in that country. Like again, I will give the example of Rafale. Initially, the parts were imported and they were assembled here in India. Like long back, Korean company, they had launched Santo car. So they had just given the products, the parts which were assembled in India. Later on, they start making that parts in India. So then they become a joint venture. And the movement of skilled workers across the border also acts as a channel of international technology distribution. ये थोड़ा सा फॉर्मल और इनफॉर्मल में एक प्रॉब्लम आता है. अब उनके बंदे आए पार्ट के असेंबली सिखाने के लिए, सब कुछ करने के लिए ऑफिशियली, बट समटाइम इट हैपेंड वो पर्टिकुलर मदर कंपनी को छोड़ के दे कम एंड जॉइन दैट कंपनी ऑफ a country where the company was giving the technical know-how only. So, एक तरह से they are transferring the technology unofficially. Now, that is called informal. Now, in informal channel, the movement of personnel from one firm to another. यहाँ पे जो काम कर रहा है, he had earned, he had learned some technical know-how, then he had gone to some other country, he had transferred the entire information. Again, defense related example, our neighbor, they had developed the nuclear power because of that. One of the scientists who was working in USA, he migrated from there, he come to his own country, and there he had developed the nuke. So, this is the specific knowledge of original form. There is no formal composition. Now, the difference between the formal and informal is informal. If you are leaking out some technology or some information or something, you are liable to be punished or composition has to be given. But in informal, nothing. You cannot say, you cannot blame that person. Now, with the FDI, now FDI again it got two things. One is vertical, one is horizontal. In vertical, it's everything assembly from the component. As I told, that Centro was initially when it was a Korean company started manufacturing in India, they had just assembling it. In horizontal, the subsidy product and the similar product by the patent firm. Patent firm उसको वहीं पे बनाना शुरू कर देते. Now your plant in Chennai, they are making the Centro there only. Then intellectual property right and licensing. Now, licensing is a very complicated type of IPR because it's a large variety of licensing agreements. Like within the form, a joint venture, a technical assistance, codified knowledge, know-how of IPR. So, in some, the fixed fees are there, some franchisee fees are there, royalty fees are there, share of profit is there. Then they may offer the right either to produce or distribute or may not. So, there is such a vast field that IPR become very complicated in licensing. Then, for that, we require a very stronger IPR protection. So, reduce the cost of licensing by reducing licensor expenses. By deterring reflection from contract. Any person is deterring or violating the breach or there is a breach in contract that is very strong or can say very major punishment or you can say fine is likely to be imposed. Now, inventor in one country can register patent to another. As I told earlier, you can register, as Dr. Ruben also said, it can be in one country, it can be in another country. Like in the PCT country, you can get your patentation registered with other countries also. Now, the country providing stronger access protection and more effective restriction. If your IPR system is very strong, you will like to have large number of patentships coming to your country. As Dr. Arun showed one case of non-registering in the patentship. India is known for old traditional system of medicines. We never got it patented. Abhi neem is being used very extensively in all sort of products. नीम सोप आ गया है, नीम का पाउडर आ गया है, नीम का कुछ है. अब तुम्हारे नीम का पेटेंट किसके पास है? इंडिया नहीं भाई, नीम का पेटेंट अमेरिका के पास. ना जिस दादा दादी के जमाने के हम लोग सुनते आ रहे हैं, नीम को पानी से नहा तो ये हो जाएगा, नीम खा लो तो पी हो जाएगा नीम, और हमारे पास इसका पेटेंट नहीं है. अमेरिका से आके उन्होंने इंडिया में नीम का पेटेंट कर दिया. So we can do that. Anybody can do that. कहीं भी किसी दूसरी कंट्री में जाके आप पेटेंट कर सकते हैं. Then it can influence both the domestic IPR and domestic fund patenting. दोनों कंट्रियों को फायदा है. with this, I have covered certain point which is related to the technical group. If anybody got any answer or any question, they can ask.
हेलो प्रिय स्टूडेंट्स, समझ में आया या ऊपर नहीं गया? तो समझ में आया तो किसी को डाउट नहीं है ना क्या? नो, so you may take it as a compliment. I was so convincing when people get convinced. Okay, thank you.
Thank you so much, sir. Dr. Samir Mishra, sir, it was a very beautiful, expanded explanation, and I would like to now invite all the GITM faculties on the stage for group pictures. Rest of you, please enjoy the lunch. We will get it back at 1:30. All the external participants and faculty members, please enjoy the lunch. We will gather back at 1:30. I request all the GITM faculty members and the dignitaries from GITM to please gather on the stage for a group picture. The lunch has been organized for students on the first floor and for the faculty in minority too. Students, kindly collect your snacks on first floor. All the external faculty members and the external participants, please enjoy your lunch on second floor. I request the faculty members of GITM and all the dignitaries from GITM to please collect back near the stage for the group picture. I request Ms. Kanchan Bhatt and Ms. Neha Singh to please arrange the faculties for the group pictures. I request the dignitaries and the male faculty members to please join us on the stage. All the female faculty members are lying near the stage. All the dignitaries, director sir, dean sir, associate dean sir, principal sir, proctor sir, please join us on the stage. All the male faculty members, please join us on the stage, and I request all the female faculty members to please gather near the stage.
I request all the heads of department to please ensure that all the faculties of GITM must be here. All the faculty members of GITM.
I request all the head of departments to please gather near the stage. All the GITM faculties from BTech and MBA, please gather near the stage. All other faculty members, all the diploma faculty also please wait near the stage. GITM diploma, GITM BTech, GITM MBA faculties please gather. All the male members kindly gather on the stage, and all the female faculty members gather near the stage. I request all the students to please enjoy their snacks on first floor. I request all the external participants to kindly enjoy their lunch on second floor.
आशीष सर ये पूरा कर्व नीचे तक ले आइए आकाश नीचे तक हाँ हाँ आ रहा है
सेकंड हाफ अभी बचा है.
दूसरी मैम का नंबर लास्ट में 5 बजे तो आएगा नंबर, लास्ट में 5 बजे चलेगा। लंच कर लिया नहीं?
आगे सब सही।
आइए नारायण सर, ए नारायण भैया,
चलो वहीं चलो,
आओ।
अभी लंच भीड़ खत्म होने दो,
अरे आओ,
भीड़ खत्म हो गई तब खोलो इसको। घर का है क्या है?
बोलो यहीं।
तुम यहाँ आओ पहले।
हम क्या है, हम बाहर नहीं
आओ यहाँ
ये भाई हम नहीं पता, वो डिलीवरी सर ने स्टेटली मना किया और डॉक्टर उससे दिक्कत हो जाए। बाकी यहाँ कोई और होता दे दो हमको, हम नहीं, मेरे पास नहीं है खुद, मेरा नहीं चल रहा।
क्यों?
अरे वो उससे चल रहा है ना, डिलीवरी सर से मांग लो।
अरे तुम रेडी नहीं है यार, जाओ। हमें आज जाना है प्रतिज्ञा के घर। हम घर होते हुए पहले यहाँ जाएंगे, पहले सुरेंद्रनगर जाएंगे, उसके बाद घर जाएंगे, घर से प्रतिज्ञा घर जाएंगे।
भैया कौन? भैया तो वहीं हो।
बच्चा है
कौन बच्चा?
क्यों कर रहा है?
मेरे बच्चा है। हाँ,
पिछले जन्म में किए थे, इस बार बड़ा हो गया, बड़ा पैदा हुआ, बड़ा हो गया।
हेलो,
समझदार हो तो तुम लोग क्या, इसलिए जो समझते हो वही बढ़िया है। कचौड़ी होगी, चटनी होगी। कहाँ गाँव में खिलाते नहीं होगी, आपकी होगी। बुरा बनाओ, तो रहो।
जाइए मैम, लंच करके आइए। बैठे रहिएगा, आप वहाँ नहीं है। तो हमारे है यार, कॉलेज हमारे नाम नहीं है, बस यही ना। इसकी रजिस्ट्री करा लेंगे। आप दोनों लोग जा रहे हैं
तो क्या है?
जाइए, खा के आइए जरा।
आप नहीं लंच करेंगे?
जाएंगे हम लोग, मैं
जाएंगे आप पहले पहले करिए अपना, हम कल का देंगे, बड़ा चलते नहीं आपको। क्या हुआ है? पूरा नहीं, एक्सीडेंट तो हुआ, फ्रैक्चर टाइप का है कि
पूजा
2-3 दिन रेस्ट करिए तभी जाएगी।
रेस्ट यहाँ मिलता है,
मेडिकल तो मिलेंगी ही
यहाँ पर कुछ नहीं मिलता। सेमेस्टर बेस करवाएंगे कि नहीं?
कुछ नहीं, मत धक्का करवाएं, हमसे ज़्यादा इमरजेंसी किसको चाहिए?
नहीं, आपको तो तुरंत बता दो।
तो ही नहीं मिलती है ना।
मैं परसों तो आने का वो है,
आना कंपलसरी है, आइएगा 10 मिनट के लिए, बस फोटो खिंचाई चले जाइए, पंच करके बस।
ऐसा क्यों? नहीं, जब भी ऐसा जरूरी का पहले कभी नहीं था, अभी शुरू।
एक हो दिन नौटंकी। हाँ मैम, हम तो नहीं आएंगे, बात है। हेलो, हाँ, अरे 26 डब्ल्यू की भाई
नहीं बोला है, इससे हम पूछ रहे हैं।
ये हाँ 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 इसको नहीं उससे नहीं उठते, सर्दी आती है सर्दी। अरे हम ला देंगे, रहेंगे तो हम लाते हैं, हम उड़ाएंगे, बेटा भी उड़ाएगा मेरा, दोनों बाप बेटे उड़ाएंगे। हाँ तो बस कह दो आज ना खाए, कल ला देंगे, पापा कल यहाँ ले आ देंगे सब्जी। कल बेटा उड़ाया जाएगा, दोनों लोग आएंगे हमको, कल दोनों बाप बेटे उड़ाएंगे, चिंता नहीं। अरे ठीक है, देखने को बच्चा अरे हम लाएंगे देंगे उसको नहीं। बात नहीं है तो करे तो फर्स्ट ही करे ना, जितने भी लोग ऊपर से लेकर नीचे तक करे, करो तो फर्स्ट ही करो ना, एक आदमी जो GITM में मिलती है।
मेला में जाओगे?
आएला नहीं जाना है, जाना है गाँव।
रोटी पकड़ के मार रहा है, बटे ब्राह्मण
क्या करी मार रहा है, मोदी को घर जाए, योगी को घर जाए।
तो यहाँ में जाओगे
UGC ले आया, क्या कर ले UGC ले आया, कुछ कर पाए? नहीं सर। हाँ ठीक चल रहा है, बहुत तो कितनी उसको
कौन सो
तो भाई तो हमसे कहा लेना देना, हम अपना काम कर। आओ लाला चलिए दोनों भाई।
हेलो हेलो गुड मॉर्निंग गुड आफ्टरनून बताइए मैडम बस बढ़िया नहीं नहीं बताइए हम्म, हम्म, कॉलर माइक हाँ ठीक है ये होगा कितने का? आपका साहब को दीजिए मंगवाएंगे और क्या नहीं हाँ हो जाएगा उसमें क्या ब्रिजेश साहब से बोलिए वो बोल देंगे अपना लेके आएगा तो जाएँ तो हाँ आना होगा एक ही है एक से ज़्यादा है तो और चाहिए तो मंगाना पड़ेगा ना वो आ जाएगा उसमें ठीक है खा लिए एक और अरेंज हो सकता है आपको अयोध्या का है वो तो नहीं करता है वो वाला जो पोर्टेबल वाला है ना दोनों तरफ प्लग एंड पिन वाला प्लग एंड प्ले वाला वो साइकिल से हो सकता है नहीं कभी दिखा रहे तो दूसरा जो प्लग एंड प्ले है सीधे दो से डालो प्लग कर दो उसको और दूसरी तरफ अपना वो 3500 का ये वाला तो इसके मशीन के साथ में है दिखा रहे चलो ठीक है अब रात हम फोटो भेजो मैं कर ले जाओ अरे 28 के महीने देखो तो मैं लेते हुए नहीं करता अरे वो बड़े हो जाते हैं ठीक मैं फोन किया डॉक्टर का बताइए
हेलो हेलो ये वाला है
इसमें आ रही है हेलो इसकी रेंज ही नहीं है, कितनी रेंज है? हेलो 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 हेलो
ये सही है, ये है छोटी प्रॉब्लम नहीं निकलेंगे। हेलो, अब इसका जो दूसरा है वो मशीन नहीं अच्छा बड़ा है, उसमें जो निकला हुआ है
हेलो ठीक है, रेंज भी अच्छी मार्क यहाँ पे काम कर रहे और भी करेगी, आगे कर देंगे। यहाँ तक पूरा हॉल कवर कर रहे। अच्छा है, पीछे तो कवर कर रहा है ऊपर, तो आप यहाँ तक रेंज पूरी है, रेंज में कोई प्रॉब्लम नहीं।
Hello. I request all the faculty members and participants standing near the gate, please settle down. I request faculty members to please take the front rows. All the faculty members, please take the front rows. I request all the faculty members from GITM, please take the front rows. I request all the external participants to please join. I request all the faculty members from diploma sitting at the back, please take the front rows. All the faculty standing near the gate, please gather back, we are about to start. All the faculties in the lunch area, kindly gather back, we are about to start. I request all the faculty members kindly take the front seats, or the external participants kindly take the front seats. I request students standing in the aisle, please settle down. All the faculty members standing in the aisle, please take your seats. We are about to start. All the faculty members, kindly take the front rows. All the external participants, we request you to please kindly take the front rows. I request all the dignitaries to please take the seats. I request all the HODs standing in the aisle, please take the seats. All the faculty members from GITM and the external participants, kindly take the front rows. Students standing in the aisle, kindly take your seats. We are about to start. I request Tenant Tutor Sir Dr. GGI and Tenant Verma Sir, Principal Diploma, to kindly take the front rows. I request all the dignitaries standing in the aisle, please take your seats. I request all the faculty members from Diploma, please take the front rows. Students standing in the back, please take your seats. We are about to start. All the external participants and the faculty members kindly take the front rows. now, after taking a short break and traveled back, welcome back everybody in a refreshing lunch. We now continue with the next session of our workshop with a renewed energy. I request all of you to please gather and settle down so that we can move forward with the next session of this workshop. Before lunch, we had a very meaningful session on intellectual property rights, which helped us understand the importance of protecting ideas and innovations. The discussion was truly informative and inspiring.
Now we express our sincere gratitude to our respected speakers by presenting them with a sapling as a symbol of growth, respect and appreciation. Now I request our respected director, Sir Dr. Rishi Khana, Sir, to present a token of gratitude to Mr. Abhay Dwivedi, Sir, Patent Agent and Assistant Professor, Modi University of Science and Technology, Rajasthan.
We sincerely thank Mr. Abhay Dwivedi, sir, for joining us today and for sharing his valuable knowledge and experience with us. A huge round of applause for Mr. Abhay Dwivedi, sir.
Now I request Dr. Rishi Khana, Sir, to present a token of gratitude to Dr. O. Prakash, Sir, Director, Patent Ventures.
We thank Dr. O. Prakash, sir, for being with us and guiding us with his insightful thoughts. We are very grateful to all of you for joining us today and motivating us with your inspirational words. Now we begin with the next session. It's a pleasure to welcome Mr. Abhay Dwivedi, sir, Patent Agent and Assistant Professor, Modi University of Science and Technology, Rajasthan.
Mr. Abhay Dwivedi, Sir, is a registered patent agent and currently serves as an assistant professor at Modi University of Science and Technology, Rajasthan. Alongside his academic role, he has extensive professional experience working as a Patents Association in Tier 1 law firms and advising on patent fillings and IPR matters.
In a huge round of applause, we welcome Mr. Abhay Dwivedi, sir, on the stage. Can we have a huge round of applause for Mr. Abhay Dwivedi, sir, for joining us today?
Good afternoon, everyone. So the topic for the session is patenting process and legal framework in India. So before we start regarding the patenting process, it's really important to understand the nuance of the topic patent. See, आप पेटेंट करा ही क्यों रहे हैं? आपके पास मान लीजिए एक ऑप्शन है कि आपने कोई नई टेक्नोलॉजी या आइडिया डेवलप किया. अब या तो आप उसको अपने आइडिया को प्रोटेक्ट करने के लिए डिस्क्लोज मत करिए, लेकिन उसमें एक इशू ये आता है कि अगर आप डिस्क्लोज नहीं करते और आपके जो कॉम्पिटिटर्स हैं उन्होंने अगर उसका डिजाइन अराउंड कर लिया, सिमिलर उसमें प्रोडक्ट बना लिया बिना आपके टेक्नोलॉजी को यूज किए, तो आपका प्रोटेक्शन तो खत्म हो जाएगा. इसलिए पेटेंट प्रोसेस एक और प्रोटेक्शन का मेथड है जहाँ पर हम अपनी इंटेलेक्चुअल प्रॉपर्टी को प्रोटेक्ट करते हैं, जहाँ पर इन एक्सचेंज ऑफ प्रोटेक्शन हम क्या करते हैं कि अपनी नॉलेज को डिस्क्लोज कर देते हैं. अब जितने भी हमने इंटेलेक्चुअल प्रॉपर्टी राइट देखे वो कहीं ना कहीं नॉर्मल प्रॉपर्टी राइट से अलग होते हैं. आपकी नॉर्मल प्रॉपर्टी क्या है कि टेंजिबल दिख रही है, आपके पास प्रॉपर्टी के अगर कोई लैंड है तो आपको दिख रहा है, लेकिन जो इंटेलेक्चुअल प्रॉपर्टी है वो एक्चुअल में इंटेंजिबल है, वो आपका आइडिया है और आपका क्रिएशन है, इंटेलेक्चुअल क्रिएशन है. लेकिन इशू क्या आता है इसके साथ? आपने इंटेलेक्चुअली चीज क्रिएट की, लेकिन एक्चुअल में उसको प्रोटेक्ट करना इतना फिजिकल नहीं रहता, उसको प्रोटेक्ट करने में अच्छी खासी कॉस्ट आती है. तो इसलिए गवर्नमेंट क्या कहती है कि आप अपने आइडिया को डिस्क्लोज करो ताकि सोसाइटी उससे बेनिफिट कर सके. हम आपको 20 साल का प्रोटेक्शन देंगे, लेकिन इन एक्सचेंज आप उस इंफॉर्मेशन को हमें डिस्क्लोज करिए. ये जो डिस्क्लोजर वाला पार्ट है, यही आपकी पेटेंट एक्ट का बहुत सेंट्रल एस्पेक्ट है। जब आप इस पेटेंट से रिलेटेड कोई भी काम करेंगे तो आपके ऊपर एक लायबिलिटी रहेगी कि आपको डिस्क्लोज करना है प्रॉपर्ली, और वो रिजेक्शन के ग्राउंड भी हो जाता है। अगर आप प्रॉपर्ली अपने इन्वेंशन को डिस्क्लोज नहीं करते तो आपका पेटेंट रिजेक्शन हो सकता है। इवन ग्रांट होने के बाद भी स्टेजेस रहती हैं जहाँ पर उसमें उसके रिपरकशन आ सकते हैं। तो इसलिए आप उसके लिए आपको प्रोटेक्शन मिलता है, लेकिन इन एक्सचेंज आप क्या करते हैं, गवर्नमेंट को अपनी टेक्नोलॉजी को डिस्क्लोज करते हैं। अच्छा, पेटेंट का आप कॉन्सिक्वेंस देखिए कि बड़ी बड़ी यूनिवर्सिटीज भी इससे इम्पैक्ट हो जाती है। जैसे मान लीजिए कि आप लोगों ने क्रिस्पर टेक्नोलॉजी सुनी होगी, जीन एडिटिंग की, क्रिस्पर कास9। सो वो टेक्नोलॉजी के लिए 2 नोबेल प्राइज मिले हुए हैं, और वो किसको मिले हुए हैं? यूनिवर्सिटी ऑफ कैलिफोर्निया के प्रोफेसर्स को। लेकिन एट द सेम टाइम अभी आप अगर न्यूज में देखेंगे तो एमआईटी और आपका हार्वर्ड इंस्टीट्यूट में वहां के जो इन्वेंटर्स हैं उन्होंने उसमें पेटेंट ले रखा है। तो आप देखिए 2 कंट्राडिक्टरी सिचुएशन, जहां पर उसी टेक्नोलॉजी के आप नोबेल प्राइज किसी और इन्वेंटर को दे रहे हो लेकिन पेटेंट किसी और के पास है। तो इसलिए पेटेंट का सिग्निफिकेंस समझना किसी भी एजुकेशनल इंस्टीट्यूशन के लिए, किसी भी स्टार्टअप के लिए बहुत इंपॉर्टेंट हो चुका है। पहले यूएस में सिस्टम ये था कि जो पहले इन्वेंट करता था उसको पेटेंट मिल जाता था, अगर आप प्रूफ दिखा सकें। आप लोग प्रीमियर इंस्टीट्यूट में हैं और प्रीमियर इंस्टीट्यूट में आप देखते होंगे कि क्या होता है कि आप लोग रिकॉर्ड बनाते हैं कि आपने जो इन्वेंशन काम किया उसकी टेक्नोलॉजी के रिकॉर्ड क्रिएट करते हैं कि अभी मैं इस इन्वेंशन पर वर्क कर रहा हूँ, और उसमें आप साइन कराते हैं अपने फील्ड के एक्सपर्ट से। वो रिकॉर्ड कीपिंग होता है कि हम इस इन्वेंशन पे बहुत पहले से वर्क कर रहे हैं। लेकिन इंडिया में क्योंकि फर्स्ट टू फाइल सिस्टम है, जो पहले फाइल करता है प्रोटेक्शन उसको मिलता है। तो इंपॉर्टेंट ये रह जाता है कि आप फाइलिंग समय से करें। द फाइलिंग शुड स्टार्ट एट द राइट टाइम। जैसे आपने किसी इन्वेंशन में वर्क किया, जनरली क्या होता है कि इन हरी कई कॉन्फ्रेंस आ रहा है, कहीं आपको प्रेजेंट करना है पेपर, तो आप क्या करते हैं, पहले आप अपनी टेक्नोलॉजी को डिस्क्लोज कर देते हैं, और उसके बाद क्या होता है कि फिर आप आते हैं पेटेंट प्रोटेक्शन के लिए। इश्यूज में क्या आता है कि आप प्रोटेक्शन के लिए जाते तो हैं, लेकिन तब तक वो फिर डिस्क्लोज हो चुका होता है और आप उसमें प्रोटेक्शन मिल नहीं पाते क्योंकि पब्लिक डोमेन में आ गया है। तो कुछ कॉन्सेप्ट समझना बहुत जरूरी है पेटेंट के रिस्पेक्ट में आप लोगों को। देखिए, पेटेंट के रिस्पेक्ट में सबसे इंपॉर्टेंट जो फाउंडेशनल पिलर रहता है वो आपका रहता है कि आपका जो पेटेंट है वो नॉवल होना चाहिए। नॉवल इन द सेंस कि वो पहले किसी ने उस पर वर्क नहीं किया हो, ऐसा नहीं। क्योंकि आप किसी भी टेक्नोलॉजी के डोमेन पे पेटेंट नहीं लेते, आप एक पर्टिकुलर इंक्रीमेंटल इन्वेंशन पे पेटेंट लेते हैं। आपने कुछ बना रखा है, उसमें कुछ इंप्रूवमेंट किया, तो वो आपका पेटेंट का टॉपिक हो सकता है। इसलिए इंपॉर्टेंट ये रहता है कि आप उसकी नॉवेल्टी को प्रोटेक्ट करें। नॉवेल्टी को एस्टैब्लिश करने के लिए आपको ये देखना होता है कि कोई सिंगल डॉक्यूमेंट में अगर आपका पूरा एक डिस्क्लोज है तो फिर वो प्रोटेक्शन नहीं मिल पाता उस पर। सिमिलरली दूसरा जो रोड ब्लॉक है, पेटेंट फाइलिंग के प्रोसेस में आपको ये रिकॉग्नाइज करना है कि क्या आपका इन्वेंशन पेटेंटेबल है कि नहीं, क्या आप उसके लिए पेटेंट ले सकते हैं कि नहीं ले सकते। तो सबसे इंपॉर्टेंट पहला स्टेप क्या है कि आपको ये देखना है कि वो नया हो, नॉवेल हो। फिर उसके बाद आपको क्या देखना है कि इट शुड नॉट बी ऑब्वियस टू अ पर्सन स्किल्ड इन द आर्ट। आप किसी फील्ड में काम कर रहे हैं, सिमिलर उसी फील्ड में और लोग भी काम कर रहे होंगे जो कि आपके कॉम्पिटिटर्स होंगे। अगर आपने जो इन्वेंशन बनाया उसमें 3 कंपोनेंट हैं, ए, बी और सी। अगर आपने सी को रिप्लेस करके डी से बनाया उस कंपोनेंट को, तो अगर जो आपकी फील्ड में दूसरा रिसर्चर रहेगा उसको पता है कि ये डी यहाँ पर रिप्लेस हो सकता था, तो वो आपका इन्वेंटिव स्टेप पे हिट हो जाता है। तीसरा इंपॉर्टेंट एस्पेक्ट क्या है कि आपको जो आपका इन्वेंशन है वो प्रोटेक्ट होने के लिए उसका इंडस्ट्रियल एप्लीकेशन बहुत जरूरी है। जैसे आप लोगों ने एडिसन का नाम सुना होगा, थॉमस एल्वा एडिसन। तो थॉमस एल्वा एडिसन जिस समय पे उस समय में लाइट बल्ब की रिस्पेक्ट में उनकी इन्वेंशन की बात की जाती है, लेकिन जब वो लाइट बल्ब में वर्क कर रहे थे तो उनका एक कॉम्पिटिशन था दूसरे उसी समय के कंटेम्परेरी जो आपके इन्वेंटर थे, जॉन वेस्टिंग हाउस। तो वो क्या हो रहा था, उन्होंने कॉम्पिटिशन कर रहा, आप लोगों ने निकोलस टेस्ला का नाम सुना है। तो एक तरफ तो आपके जो ये इन्वेंटर थे आपके थॉमस एल्वा एडिसन, वो ये कह रहे थे कि मैं डीसी करंट यूज करूंगा टू लाइट अ बल्ब, एंड वो क्लेम करते थे कि ये जो डीसी करंट है वो सेफर है। कंपेयर टू ए अल्टरनेटिव करंट एसी। अब आज की डेट में हमने कॉन्सेप्ट बहुत क्लियरली बताया, लेकिन उस समय पर ये बिल्कुल नया था। तो नोवेल्टी टाइम पे डिपेंड करती है, अभी उस टेक्नोलॉजी में कितना डेवलपमेंट हुआ है। अब एआई में काफी डेवलपमेंट हो गया, तो एआई की अब एक फील्ड बन गई है, लेकिन उसमें जो आप कुछ नया इन्वेंशन करेंगे तो वो आपको नोवेल्टी स्टैब्लिश करनी पड़ती है, किसी प्रायर डॉक्यूमेंट को डिस्क्लोज नहीं है, ठीक है। तो थॉमस अल्वा एडिसन और वेस्टिंगहाउस के बीच में डिस्कशन ये चल रहा था कि वो अल्टरनेटिव करंट को प्रोटेक्ट कर रहे थे, उन्होंने निकोलस टेस्ला की टेक्नोलॉजी खरीद ली थी और वो कह रहे थे कि लाइट बल्ब को अल्टरनेटिव करंट से काम करना चाहिए, और एक तरफ थॉमस अल्वा एडिसन क्या कह रहे थे कि लाइट बल्ब को डायरेक्ट करंट से काम करना चाहिए। अब इसमें इशू क्या था कि आप लोगों को डायरेक्ट करंट बहुत जल्दी फेड आउट हो जाता है इन चैनल, उसको रिपीटर्स की जरूरत पड़ती है उसके सिग्नल के लिए, लेकिन एट द सेम टाइम अल्टरनेटिव करंट अगर हम वोल्टेज बढ़ा दें तो करंट कम हो जाता है, लॉसेस कम हो जाते हैं और लॉन्ग डिस्टेंस तक जाता है। तो इस वजह से क्या हुआ कि इवेंचुअली वो बैटल, इवन दो पहले डिस्कवर किसने किया, थॉमस अल्वा एडिसन ने, पहले पेटेंट उनके पास था, लेकिन क्योंकि टेक्नोलॉजी की इंडस्ट्रियल एप्लीकेबिलिटी किसकी बेटर थी, एसी करंट की, इसलिए वो डीसी करंट वाला पेटेंट होने के बाद भी एसी करंट विन किया उस बैटल को। तो आपको ये भी देखना है कि यहाँ पर जो इन्वेंशन है उसकी इंडस्ट्रियल एप्लीकेबिलिटी क्या है। तो ये तीन जो आपके फाउंडेशनल पिलर हैं ये आपको हमेशा याद रखना है, और इन्हीं के बेसिस पे आपको अपना डिस्क्लोजर अपने एजेंट को बताना है। आपको ये देखना है कि जो बता रहे हैं वो पहले डिस्क्लोज ना हो, क्या वो फील्ड एक्सपर्ट है, एजेंट एक्सपर्ट नहीं होगा, एजेंट एक टेक्नो लीगल एक्सपर्ट होगा जो टेक्नोलॉजी को भी जानता है, लॉ को भी जानता है, लेकिन वो उस फील्ड में एक्सपर्ट नहीं जिस फील्ड में आप काम कर रहे हैं। तो आपको डिस्क्लोजर उसी को प्रोवाइड करना है, और इसलिए आपको कभी याद रखना है कि सबसे पहले आपका इन्वेंशन में नोवेल्टी होनी चाहिए, वो ऐसा नहीं होना चाहिए कि आप ही फील्ड का दूसरा आदमी उसको डेवलप कर सके, और तीसरा ये होना चाहिए कि उसकी इंडस्ट्रियल एप्लीकेबिलिटी होनी चाहिए। आप डीसी करंट में काम कर रहे हो, लेकिन अगर वो डीसी करंट पे जो बल्ब है वो अच्छे से इंप्लीमेंट नहीं हो पा रहा, तो फिर विनर कौन होगा, एसी करंट। आज की डेट में सारा हमारा इलेक्ट्रिसिटी ज्यादातर एसी करंट पे है, डीसी करंट कब है, बैकअप के लिए। तो ये रियलाइज करना एक टेक्नोलॉजी के रिस्पेक्ट में बहुत इंपॉर्टेंट है। अब जब आप एक चीज और कॉन्सेप्ट याद रखिए जो आपके लिए बहुत इंपॉर्टेंट है फाइलिंग के समय पे, कि आप ये समझिए कि एप्लीकेंट और इन्वेंटर में डिफरेंस क्या है। इफ यू आर फाइलिंग द एप्लीकेशन देन यू आर द एप्लीकेंट, बट जिसने टेक्नोलॉजी बनाई है वो इन्वेंटर होना चाहिए। आप डिफरेंस देखिए, एक एग्जांपल समझाता हूं। जैसे कि मैं इस टेक्नोलॉजी में यूनिवर्सिटी मान लीजिए फैकल्टी हूं, और मैंने कोई टेक्नोलॉजी वर्क किया और उसमें मैंने पेटेंट डॉक्यूमेंट फाइल किया। वहां पर मैंने क्या किया, क्योंकि मैंने इस यूनिवर्सिटी की टेक्नोलॉजी जो भी सेंटर है, जो भी लैब्स हैं, उनको यूज किया, तो इसलिए उनकी रिसोर्सेज यूज करने की वजह से एक हमारे बीच कॉन्टैक्ट होगा, जिसमें मैं ये करता हूँ कि फाइलिंग मैं असाइन कर देता हूँ इंस्टीट्यूट को, लेकिन डेवलप मैंने किया है। तो डिफरेंस क्या हो गया, यहाँ पर एक यूनिवर्सिटी एप्लीकेंट हो जाती है और मैं क्या हो जाता हूँ, इन्वेंटर हो जाता हूँ। अच्छा, ये जो इशू आ रहा था इस वजह से क्या होता था कि पेटेंट जब ग्रांट होता था उस पर जनरली एप्लीकेंट का नाम रहता है, इन्वेंटर का नहीं रहता। तो उससे क्या हो रहा था कि यूनिवर्सिटी का नाम हो रहा था, लेकिन जो स्कॉलर्स हैं उनको जब अपना एकेडमिक ग्रोथ करनी थी तो उनके पास एक सर्टिफिकेट नहीं होता था। इस प्रॉब्लम को रियलाइज करते हुए अभी लेटेस्ट में रिसेंट में ही आपके गवर्नमेंट ने, कंट्रोलर जनरल ऑफ पेटेंट डिजाइन एंड ट्रेडमार्क ऑफिस ने ये चेंज किया कि अब आप लोग एक नया फॉर्म आया, फॉर्म 8 है, उसके थ्रू एप्लीकेशन फाइल कर सकते हैं फॉर इन्वेंटरशिप। तो आपको एक सर्टिफिकेट इशू होगा कि इस इन्वेंशन के इन्वेंटर आप हो, ठीक है। नेक्स्ट कॉन्सेप्ट ये हमने डिस्कस कर लिया। अच्छा, नॉन पेटेंटेबल सब्जेक्ट मैटर आया कहाँ से? अभी जो लास्ट डिस्कशन हुआ था उसमें कर्नल साहब कह रहे थे कि नीम पर पेटेंट है यूएस के पास। एक्चुअल में ये जो अटेम्प्ट है वो उन्होंने किया था, लेकिन वो जो अटेम्प्ट था उसके बाद जो हमारे तरफ से जो रेजिस्टेंस हुआ कंट्रीज की तरफ से, उसकी वजह से पूरे आईपीआर इकोसिस्टम में ग्लोबली चेंज आया और हमने रिकॉग्नाइज किया ट्रेडिशनल नॉलेज को। तो कुछ चीजें आप समझिए कि कहाँ से जेनेसिस हुआ। जैसे आप एक एग्जांपल देखते हैं, आप लोगों ने केस सुना होगा जहाँ पर नोवार्टिस का एक केस बहुत इंपॉर्टेंट है, जहाँ पर उन्होंने कैंसर का ड्रग बनाया। अब कैंसर का जब उन्होंने ड्रग बनाया तो उसकी प्राइसिंग उन्होंने एक्सेप्शनली हाई रखी। तो इस वजह से क्या हुआ कि फिर सुप्रीम कोर्ट ने क्या कहा कि मेयरली आपने अपने बने बनाए हुए ड्रग में थोड़ा सा उसका आइसोटोप वगैरह चेंज कर दिया, आइसोमर चेंज कर दिया, कुछ उसकी केमिकल प्रॉपर्टी से थोड़ी सी चेंज कर दी, तो पेटेंटेबल नहीं है। और उससे उन्होंने क्या प्रिवेंट करने की कोशिश की, क्योंकि फार्मास्यूटिकल कंपनियां क्या कर रही है, फार्मा की कंपनियां क्या कर रही थी, बार बार अपनी ड्रग में थोड़ी बहुत चेंजेस करके नया ड्रग सिमिलर ले आ रहे थे, और क्या कर रहे थे, अपनी प्रोटेक्शन को 20 इयर्स के बजाय वो रेगुलरली एक्सटेंड करते जा रहे थे। इसको कॉन्सेप्ट के तौर पे कहा जाता है एवरग्रीनिंग ऑफ पेटेंट्स। तो वो एफर्ट कर रहे थे एवरग्रीनिंग की, उसको उसको रिस्ट्रिक्ट करने के लिए हमारी जो एक्ट है उसमें सेक्शन 3D दिया हुआ है। तो पहले कई बार क्या होता है कि प्रॉब्लम पहले रियलाइज होती है, फिर हमारा लॉ में चेंज आता है। कई बार क्या होता है कि लॉ पहले बन जाता है, फिर हम कई बार वो केसेस देखते हैं। तो आप ये देख सकते हैं कि इस तरह की सिचुएशन की वजह से हमारे पेटेंट एक्ट में सेक्शन 3 में कुछ एक्सक्लूजन दिए हुए हैं, कुछ ऐसे सब्जेक्ट मैटर दिए हुए हैं जो कि पेटेंट नहीं कराए जा सकते, और वो आपको पता होना बहुत जरूरी है ताकि आपका टाइम ना वेस्ट हो, ठीक है, आपके रिसोर्सेज ना वेस्ट हो। तो सबसे इंपॉर्टेंट क्या है कि आप किसी एक अगर केमिकल कंपोजिशन है उसमें सिर्फ माइनर कुछ चेंजेस कर रहे हैं तो वो एवरग्रीन आप पेटेंट नहीं करा सकते। वो आपको ये देखना पड़ेगा कि उसकी एफिशिएंसी बढ़नी चाहिए, वो केमिकल स्ट्रक्चर चेंज होना चाहिए, ठीक है। फिर इसके अलावा एक केस और जैसे कि सर ने बोला था कि नीम हो गया, टर्मरिक हो गया, इनके रिस्पेक्ट में बासमती राइस हो गया, यूएस ने पेटेंट कराने की कोशिश की, लेकिन हमने फिर उसका जब अपोजिशन किया तो एक एक्सेप्शनल क्लॉज हमारे उसमें भी एक्ट में भी है कि अब आप हमारे प्रायर नोन नॉलेज जो सदियों से चला रहा है उसको पेटेंट नहीं करा सकते, क्योंकि वो भी प्रायर आर्ट है। देखिए आप जो चीज एग्जिस्ट कर रही है उसको पेटेंट नहीं करा सकते, ये सिंपल सा फंडा है। इसीलिए डिस्क्लोजर आपको सोच समझ के करना है। जैसे आप मान लीजिए किसी कॉन्फ्रेंस में गए, आपने अपना पेपर डिस्क्लोज कर दिया, वो ब्रिलियंट आइडिया था, वो ऐसा आइडिया था जो पेटेंटेबल हो सकता था, उसका कमर्शियल एप्लीकेशन था, इंडस्ट्री में उसकी रिक्वायरमेंट थी, लेकिन अब आपको कोई भी कमर्शियल वैल्यू नहीं मिलेगी क्योंकि आपने उसको क्या किया, पब्लिक डोमेन में रख दिया। तो इस वजह से क्या है कि ये भी एक एक्सेप्शन आ गया। इसके अलावा एक्सेप्शन क्या है, मान लीजिए आपने जो चीजें पता है सबको इन फील्ड में, उसमें आपने थोड़ी बहुत चेंजेस की और आपने कहा मैं इसको पेटेंट लेना चाह रहा हूँ, तो ऐसा पॉसिबल नहीं है। जैसे कि क्लासिक एग्जांपल लोग देते हैं कि मान लीजिए आप अम्ब्रेला में लाइट लगा दो, अम्ब्रेला में फैन लगा दो, ये दोनों चीजें अलग अलग वर्क करती हैं, आपस में इनमें कोई सिनर्जी नहीं है। आप इनको एक साथ अटैच करके चाह रहे हो कि आप इसको पेटेंट ले लो, तो ऐसा नहीं होता। उन दोनों के बीच में कोई ना कोई सिनर्जी, कोई ना कोई कनेक्शन होना चाहिए, ठीक है। तो इस वजह से फिर हमारी एक्ट में क्या आया, देखिए सेक्शन 3 आया जो कहता है कि हम ऐसे इन्वेंशन नहीं कर सकते जो नेचुरल लॉ के खिलाफ है। ये अटेम्प्ट कहीं ना कहीं आपने किसने किया था, ये एडिसन ने कोशिश की थी दिखाने की कि अल्टरनेटिव करंट यूज करने लायक ही नहीं है, वो नेचुरल लॉ के हिसाब से हमारे लिए सेफ नहीं है, लेकिन अल्टीमेटली वो उसको सस्टेन नहीं कर पाया। दूसरा क्या है कि पब्लिक ऑर्डर और मोरालिटी के रिस्पेक्ट में हो, या फिर कोई नो डिस्कवरी ऑफ साइंटिफिक प्रिंसिपल हो। अब आप सोचिए कि आइंस्टाइन ने जब E=mc² बोला तो वो एक ग्राउंड ब्रेकिंग रिसर्च थी, लेकिन वो पेटेंटेबल नहीं थी, क्योंकि वो क्या था, एक नेचुरल प्रोसेस को उन्होंने डिस्कवर किया था, और नेचुरल प्रोसेस की डिस्कवरी पेटेंटेबल नहीं है। ये चीज आपको याद रखनी है, डिस्कवरी ऑफ ग्रेविटी, न्यूटन्स लॉ। अगर आप आज की डेट में अगर आप ऐसा कोई ब्रिलियंट काम करते हो तो आपको भले ही नोबेल मिल जाए, लेकिन आपको पेटेंट नहीं मिलेगा, ठीक है। नेक्स्ट जो अभी डिस्कस किया है एवरग्रीनिंग के रिस्पेक्ट में, एवरग्रीनिंग आपने कोई सॉल्ट बनाया, उसका थोड़ा सा वाटर चेंज कर दिया, नहीं वो नहीं अलाउड है। ट्रेडिशनल नॉलेज जो आपने बोला कि नीम, हल्दी, बासमती, नहीं कर सकते आप, ठीक है। एक और बहुत इंपॉर्टेंट आता है, आप लोग यहाँ अभी देखिए सारा डेवलपमेंट एआई में हो रहा है, कंप्यूटर साइंस में हो रहा है, तो हमें ये समझना बहुत जरूरी है कि क्या कंप्यूटर प्रोग्राम पेटेंटेबल है कि नहीं। उसके रिस्पेक्ट में हमारा जो ऑफिस है और हमारी जो एक्ट है वो क्लियरली कहती है कि कंप्यूटर प्रोग्राम एज सच पेटेंटेबल नहीं है, वो कॉपीराइट होते हैं, लेकिन अगर उससे कोई टेक्निकल इफेक्ट या टेक्निकल एडवांसमेंट आती है तो आप उसको पेटेंट करा सकते हैं। जैसे कि फॉर एग्जांपल आप एक कंप्यूटर यूज कर रहे हैं, आपने उसमें थोड़ी सी टेक्नोलॉजी चेंज की, कुछ सेमीकंडक्टर डिजाइन चेंज की, कुछ आपने नए फैक्टर्स उसमें किए, जिसकी वजह से क्या हुआ, उस कंप्यूटर की स्पीड बढ़ गई, प्रोसेसिंग स्पीड बढ़ गई, कैश मेमोरी हैंडलिंग बेटर हो गई। तो ये क्या है, ये टेक्निकल इफेक्ट है। लेकिन टेक्निकल एडवांसमेंट आप ये देखोगे कि क्या प्रायर आर्ट में किसी में भी वो चीज डिस्क्लोज है और आपने क्या उससे बेटर तरीके से उसको किया है। अगर आप ये दो हर्डल पार कर जाते हो तो आप कंप्यूटर रिलेटेड इन्वेंशन में भी पेटेंट ले सकते हो। लेकिन ये चीज याद रखिए कि आप मैथमेटिकल फॉर्मूला, बिजनेस मेथड या किसी एल्गोरिथम पे पेटेंट बिल्कुल नहीं ले सकते, ठीक है। उसका कारण ये है कि आप मेंटल एक्ट को नहीं पेटेंट कर सकते। मेयर मेंटल एक्ट इज नॉट पेटेंटेबल, इट शुड हैव अ इंडस्ट्रियल एप्लीकेशन। सो विद रिस्पेक्ट टू दैट, जैसे मान लीजिए मैं आपसे पूछूं कि कोई मैथमेटिकल फॉर्मूला क्या हो पेटेंटेबल है, तो आंसर सिंपली नो, क्योंकि एब्स्ट्रैक्ट डिस्कवरी है। आपने एक ऐप बनाई जो किसी चीज को सेल करने के रिस्पेक्ट में, वो पेटेंटेबल बिल्कुल नहीं है। आपने कोड बनाया किसी गेम का, वो पेटेंटेबल नहीं है। लेकिन अगर आपने मान लीजिए तो कोई ऐसा बैटरी में कोई ऐसा चीज किया कंप्यूटर प्रोग्राम के थ्रू जिसकी वजह से उसकी बैटरी डबल टाइम लास्ट कर रही है, तो वो पेटेंटेबल हो सकता है। मे बी वी हैव टू सी कि इफेक्ट है, और मान लीजिए आपके कंप्यूटर ने वैसा ही सिमिलर कुछ बना रखा है, तो इफेक्ट है लेकिन वो एग्जिस्ट कर रहा है, या आपने उससे बेटर नहीं किया तो एडवांसमेंट नहीं है। तो एडवांसमेंट होना भी बहुत जरूरी है। टेक्निकल इफेक्ट इज रिक्वायर्ड बट इज नॉट अ सफिशिएंट क्राइटेरिया। जैसे मैंने कहा technical effect gets you to the door, but technical advancement means what gets you through. तो आपके पास आपने बनाया है वो मेयरली ऐसा नहीं होना चाहिए कि उससे इफेक्ट आ रहा है, ऐसा होना चाहिए जो पहले नहीं किया गया है। जो आपकी फील्ड के एक्सपर्ट जो ट्राई कर रहा है उसको पर्सन स्किल्ड इन द आर्ट कहा गया लॉ में। तो वो जो पर्सन है जो आपकी फील्ड में काम कर रहा है, आपकी जितनी नॉलेज है, जिससे सारा लिटरेचर पढ़ रखा है, क्या वो सेम चीज बना पा रहा है? अगर नहीं बना पा रहा तो आपका पेटेंट हो सकता है। तो ये आंसर आपको करने पड़ते हैं अपने अटर्नी को या पेटेंट एजेंट को, ठीक है। ये मैंने डिस्कस कर लिया, ठीक है। अब आप क्या करें कोशिश कि जब आप ये चीज रियलाइज करते हैं, तो मैंने इनिशियली क्या बताया था आपको कि पेटेंट इज अ बार्गेन। आप क्या कर रहे हैं, अपनी टेक्नोलॉजी को डिस्क्लोज कर रहे हैं, तो उसके बदले में आपको 20 साल का प्रोटेक्शन मिल रहा है। डिस्क्लोजर इसलिए कर रहे हैं कि मान लीजिए आप उस फील्ड में काम कर रहे हैं, आप उस फील्ड में काम कर रहे हैं, ऐसा ना हो कि 20 ईयर का गैप आ जाए, उस इंफॉर्मेशन को कोई विदहोल्ड कर ले। मैंने जैसे बताया कि एसी करंट के थ्रू बल्ब बेटर वर्क करता है। अगर ये हो जाए कि पेटेंट ग्रांट नहीं करे तो वो हिडन रखेगा, सिर्फ कमर्शियल बेनिफिट लेता रहेगा। लेकिन अगर उसने पब्लिक डोमेन में डाला तो उसमें और रिसर्च हो पाएगी। इवन तो उसको कमर्शियलाइज नहीं कर सकते, लेकिन रिसर्च तो कर सकते हैं। रिसर्च की प्रोसेस रुके ना, इसमें बहुत इंपॉर्टेंट एस्पेक्ट है पेटेंट का। तो आप अपने पेटेंट के डिस्क्रिप्शन में डिस्क्लोज करेंगे सफिशिएंट क्लैरिटी के साथ, और उसके लिए कुछ टेस्ट है जो पास होनी चाहिए। जैसे पहले मैंने आपको बताया नोवेल्टी के, इन्वेंटिव स्टेप के और इंडस्ट्रियल एप्लीकेशन के टेस्ट। वैसे ही आपको क्या करना है, जब आप लिखोगे तो आप ऐसा लिखोगे कि उसमें प्रॉपर्ली डिस्क्रिप्शन होना चाहिए, कैसे आप उसको परफॉर्म करोगे, उसके वर्किंग एग्जांपल्स होने चाहिए। कई पेटेंट आपके रिजेक्ट हो गए इवन दो सब कुछ को सेटिस्फाई कर रहे थे, मेनली बिकॉज उन्होंने वर्किंग एग्जांपल्स नहीं दिए हुए थे। तो आप वर्किंग एग्जांपल देंगे। उसके अलावा आप क्या बताएंगे कि द बेस्ट मेथड टू परफॉर्म दैट। जैसे आपको बताया कि कोई प्रोसेस 0 to 100 डिग्री की परफॉर्म हो सकती है, लेकिन आपको ये भी पता है कि 45 डिग्री पे आउटपुट बेस्ट आ रहा है, तो आप 45 डिग्री भी बताओगे, ये भी रिक्वायरमेंट है सफिशिएंसी में, ठीक है। आप अपने क्लेम्स क्लियरली बनाएंगे। क्लेम्स को समझने का तरीका चलिए मैं आपको देखिए आपको एक सिंपल एग्जांपल लेता हूं। हमने जितना डिस्कस किया वो से एक फोटो में है, ठीक है, इसे एक डायग्राम में। मान लीजिए आप बिल्डिंग बना रहे हैं, ठीक है, तो बिल्डिंग के पिलर क्या है? आपका पेटेंट अगर बिल्डिंग बनाने जैसा है तो उसका पहला पिलर क्या है कि उसमें नोवेल्टी होनी चाहिए। क्या उस पर किसी ने पहले वर्क किया? अगर नहीं किया है तो आप कर सकते हैं, ठीक है। दूसरा ये होना चाहिए कि वो ऑब्वियस नहीं होना चाहिए उस पर्सन जो उस फील्ड में काम कर रहा है, उसको ऐसा नहीं होना चाहिए कि ऑब्वियस पता है कि भाई अगर आपने कंपोनेंट सी यूज किया तो डी से रिप्लेस हो सकता है, तो ऐसा नहीं होना चाहिए। तीसरा ये कि इंडस्ट्रियल एप्लीकेशन होना चाहिए, जैसे मैंने आपको एडिशन वाला एग्जांपल दिया। इसके अलावा ब्लूप्रिंट, आप जब अपना डिस्क्लोजर कर रहे हैं तो डिस्क्लोजर एक ब्लूप्रिंट है जो दूसरा आदमी यूज करेगा उस इन्वेंशन को वर्क करने के लिए। 20 इयर्स के बाद वो ओपन डोमेन में, तो मैं भी इसको वर्क करना चाहूंगा। तो इसलिए मुझे क्या चाहिए, आप उसमें सफिशिएंट क्लैरिटी के साथ रिटन डिस्क्रिप्शन दो, आप मुझे एग्जांपल्स दो, और उसके अलावा ये बताओ कि सबसे अच्छा मेथड क्या है काम करने का। जैसे आप बिल्डिंग बना रहे हो तो आप सीमेंट मिक्स सबसे अच्छा क्या यूज कर रहे हैं वो आप बताओ, तो वैसे ही आप इसमें बेस्ट मोड बताओ। उसके अलावा हमने बता दिया कि क्लेम क्या है। क्लेम मान लीजिए जैसे आपने प्रॉपर्टी बनाई, इंटेलेक्चुअल प्रॉपर्टी बनाई, उसके प्रोटेक्शन की पेरिफेरी जो है, जो उसका प्रोटेक्शन का एक बाउंड्री है, लीगल बाउंड्री, वो क्या डिफाइन करता है? वो क्लेम डिफाइन करता है। आपने डिस्क्रिप्शन में क्या लिखा है? नथिंग मैटर्स। आपने क्लेम में क्या लिखा है? दैट मैटर्स लीगली। अगर कोई मेरा पेटेंट यूज करना चाहेगा तो मैं उसके ऊपर इन्फोर्स क्या कराऊंगा? सिर्फ क्लेम्स, नॉट द रिटन डिस्क्रिप्शन। तो आप क्लेम्स को इस तरीके से सफिशिएंटली लिखेंगे कि दे शुड नॉट बी आउटसाइड द रिटन डिस्क्रिप्शन। जो आपने रिटन डिस्क्रिप्शन दिया है उसमें जो दिया है वही क्लेम में आना चाहिए, उसका एक सबसेट आना चाहिए। वो एक अलग प्रोसेस। जैसे मान लीजिए सिंपल एग्जांपल मैं आपको देता हूं, मैं डिटेल में जाएंगे। मान लीजिए जैसे आप किसी राइटिंग किसी पेन पे पेटेंट लेना चाह रहे हैं, पेन का आपने कोई नई टेक्नोलॉजी बनाई, अब आप उसको पेन लिखते हो, तो मान लीजिए पेंसिल अगर मैं टेक्नोलॉजी यूज करता हूं तो आप मुझे रोक नहीं पाओगे। तो मैं क्या लिखूंगा? राइटिंग इंस्ट्रूमेंट। अब राइटिंग इंस्ट्रूमेंट लिखने की वजह से क्या होगा कि वो उसका जो प्रोटेक्शन है वो ब्रॉड हो जाएगा। मान लीजिए आप टू व्हीलर पे बात कर रहे हैं, मैं भी टू व्हीलर पे बात कर रहा हूँ, मैं थार आप ओला, ठीक है। अब क्या है कि आपने लिख दिया कि मैं टू व्हीलर पे बात कर रहा हूँ, आपने क्लेम में लिख दिया। अब इशू क्या आएगा कि टू व्हीलर के अलावा मैंने थर्ड व्हीलर लगा दिया तो आप मुझे रोक नहीं पाओगे। तो बेटर क्या है कि मैं यूज करूँ सैडल्ड व्हीकल। सैडल्ड व्हीकल मतलब जिसमें दोनों साइड पैर फंसा के बैठा है, तो वो क्या है? ब्रॉड है। तो आप इस तरीके से क्लेम्स को डिफाइन करते हो कि इसका प्रोटेक्शन बिल्कुल डिफाइंड हो, वो एजेंट नहीं कर पाता है, ठीक है। तो कुछ मैंने आपको बताया कि आपने एक्ट में रियलाइज किया कि कुछ चीजें हम बिल्कुल पेटेंट नहीं करने देंगे, तो वो क्या हो गया? हमारे स्ट्रिक्ट नो, जैसे कि एवर मीनिंग नहीं अलाउ है, प्योर सॉफ्टवेयर नहीं अलाउ है, या दादी नानी के जो नुस्खे हैं जो हमारी ट्रेडिशनल नॉलेज है वो भी आप पेटेंट नहीं करा सकते। अच्छा, स्टेप बाय स्टेप इसके बाद मैंने डिस्कस किया है स्टेप बाय स्टेप पेटेंट फाइलिंग प्रोसेस। तो पेटेंट फाइलिंग की जो प्रोसेस है उसमें सबसे इंपॉर्टेंट क्या है कि पहले आप अपने अटॉर्नी को एक रिटन डिस्क्रिप्शन इन्वेंशन डिस्क्लोजर के फॉर्म में देंगे, जहाँ पर ये सब क्राइटेरिया सेटिस्फाई करते हुए आप एक डिस्क्लोजर बताएंगे, आप उसके कंपोनेंट बताएंगे, आप कैसे वो कंपोनेंट वर्क कर रहे हैं, कैसे इंटरेक्ट कर रहे हैं, ये बताएंगे, ठीक है। उसके अलावा आप क्या करेंगे, जैसे मैंने आपको बताया कि आपका रिटन डिस्क्रिप्शन में सफिशिएंट एग्जांपल्स होने चाहिए। अगर आप एग्जांपल मिस करते हो तो हो सकता है वो ऑब्जेक्शन का क्राइटेरिया बन जाए, ठीक है। इसके अलावा बेस्ट मोड जो मैंने आपको बताया वो आपको रखना है और क्लेम्स डिस्कस हो चुका है, ठीक। तो ये सब आपको सफिशिएंट क्लैरिटी के साथ अपने डिस्क्लोजर में देना है इन व्यू ऑफ द प्रोटेक्शन प्रोवाइडेड बाय द गवर्नमेंट, ठीक है। पेटेंट जर्नी में मुझे बता दिया, पहले सबसे पहले आप क्या करोगे, अपने अटॉर्नी से कहोगे कि आप सर्चिंग करो। भाई आप मान रहे हो कि आपने एक काम किया है, किसी ने पहले नहीं किया, लेकिन हो सकता है कि वो किसी लिटरेचर में एग्जिस्ट कर रहा हो, तो उसके लिए बहुत इंपॉर्टेंट क्या हो जाता है, हम एक सर्चिंग परफॉर्म करें जो कि कवर करेगा बोथ पेटेंट लिटरेचर एंड द नॉन पेटेंट लिटरेचर, ठीक है। कुछ फॉर्म है जो मैं आपको बता रहा हूँ जो इंपॉर्टेंट रहते हैं, जो आपको फाइल करने ही रहते हैं। जैसे मैंने आपको शुरुआत में बताया एप्लीकेंट और इन्वेंटर के बारे में, तो एप्लीकेंट और इन्वेंटर का जो डिफरेंस है उसको समझने के साथ आपको ये भी समझना बहुत जरूरी है कि एप्लीकेंट कैन नॉट फाइल फॉर द इन्वेंटर अनलेस इन्वेंटर ऑथराइजेस सो। मतलब कि जैसे मैंने एक इन्वेंशन बनाया और मैं कह रहा हूँ कि ये इंस्टीट्यूट फाइल करे, तो मुझे एक ऑथराइजेशन लेटर देना पड़ेगा कि मैंने इसको बनाया और मैं ऑथराइज कर रहा हूँ इंस्टीट्यूट को फाइल करने के लिए। उसको लीगल लैंग्वेज में कहा जाता है प्रूफ ऑफ राइट। तो जो आप प्रूफ ऑफ राइट देंगे तो या तो आप फॉर्म मंथली फॉर्म में दे दें या एक्सप्रेसली कॉन्ट्रैक्ट आप सबमिट कर सकते हैं, जहां पर आप ये बताएंगे कि आई एम असाइनिंग द इंस्टीट्यूट टू रिप्रेजेंट मी इन द फाइलिंग प्रोसेस, ठीक है। फॉर्म 2 की बात करें, जहां पर आपने स्पेसिफिकेशन बताएंगे जिसमें ये सब चीजें हैं जो अभी हमने डिस्कस की, फील्ड ऑफ इन्वेंशन, टेक्निकल डिस्क्रिप्शन, रिटन डिस्क्रिप्शन, एनेबलमेंट, ये सब चीजें आएंगी। एक बहुत इंपॉर्टेंट फॉर्म है फॉर्म 3, जहां पर आप ये बताते हो कि मैंने कहीं किसी और ज्यूरिसडिक्शन में सिमिलर टेक्नोलॉजी में पेटेंट फाइल तो नहीं किया है। उसका कारण क्या है, ताकि मेरे को, जैसे अगर मैं पेटेंट एग्जामिनर हूं तो मुझे ये बता रहे हैं कि आप क्या उस सिमिलर पेटेंट पे जो आपने एप्लीकेशन फाइल की है उसमें यूएस में या यूके में या ईयू में क्या ऑब्जेक्शन आया है। वो ऑब्जेक्शन को रियलाइज करने के लिए मेरे लिए बहुत इंपॉर्टेंट हो जाता है कि आप ऑफिस के सामने फॉर्म 3 के फॉर्म में ये अंडरटेकिंग दो कि आपने कहां फाइल किया या कहीं फाइल नहीं किया है, ठीक है। फॉर्म 5 डिक्लेरेशन ऑफ इन्वेंटरशिप, जो मैंने आपको बताया कि इन्वेंटर मैं हूं या मेरे 4 दोस्त हैं तो उनका नाम इन्वेंटरशिप में जाएगा। लेकिन पहले एक दिक्कत ये आती थी कि आपको सर्टिफिकेट नहीं मिलता था कि आप इन्वेंटर हो। अब क्या है कि वो प्रॉब्लम सॉल्व हो गई है और अब आपको इन्वेंटरशिप का भी सर्टिफिकेट मिल जाता है। फॉर्म 8 फाइल करेंगे तो आपको इन्वेंटरशिप का सर्टिफिकेट मिल जाएगा। पब्लिकेशन के रिस्पेक्ट में आप लोगों को पता होगा कि आपने पेटेंट फाइल किया है तो उसका पब्लिश होना बहुत जरूरी है, क्योंकि प्रोटेक्शन आपको पब्लिकेशन डेट से मिलती है। अब ये बहुत इंपॉर्टेंट लीगल स्टेप हो जाता है। जैसे मान लीजिए मैंने पेटेंट में वर्क किया, नॉर्मली वो 18 महीने पब्लिश होगा। अब मान लीजिए उसी 18 महीने में कोई मेरी टेक्नोलॉजी को यूज कर रहा है तो मैं उसको रोक नहीं सकता उस समय के लिए, क्योंकि मैंने फाइल तो कर दिया लेकिन वो पब्लिक डोमेन में। बेटर ये रहता है कि आप अगली पब्लिकेशन करा लो। उससे अगली पब्लिकेशन से क्या होगा कि अब आप उस डेट से डैमेजेस क्लेम कर सकते हो। तुमने मेरी टेक्नोलॉजी का यूज किया और मैंने इसको फाइल कर रखा है, इवन तो भी ग्रांट नहीं होता कि आप डैमेजेस क्लेम उसी डेट से करोगे जिस दिन से आपका पेटेंट पब्लिश हो जाता है। क्योंकि अगर वो ग्रांट हो गया तो माना जाएगा कि वो डेट ऑफ पब्लिकेशन से पब्लिक डोमेन में था। तो इसके लिए भी आप क्या कर सकते हैं, फॉर्म 9 फाइल कर सकते हैं। अगर आप फॉर्म 9 फाइल करते हैं वो कुछ ही लोगों को अलाउ होता है, जैसे एजुकेशनल इंस्टीट्यूशन हो गए, स्टार्टअप हो गए, तो वो फाइल करके अपना पेटेंट को जल्दी पब्लिश करा सकते हैं, ठीक है। इसके अलावा आप देखिए, आप नियरली फाइल कर देंगे तो ऑफिस आपका पेटेंट डॉक्यूमेंट खोल के नहीं देखेगा। आपको एक फीस सबमिट करनी पड़ती है जिसको कहते हैं रिक्वेस्ट फॉर एग्जामिनेशन, जो कि 2 तरीके से फाइल हो सकती है। अगर आपको नॉर्मली एग्जामिनेशन कराना है जिसमें ऑफिस डिसाइड करेगा कब आपका एग्जामिनेशन हो, 36 मंथ के अंदर हो जाता है। लेकिन अगर आप वैसे जाएंगे तो आपको नहीं पता कब आपका एग्जामिनेशन आएगा। लेकिन अगर आप 8000 रुपीज सबमिट करते हैं तो आपका ये गारंटी हो जाती है कि 6 महीने के अंदर अंदर आपकी एग्जामिनेशन रिपोर्ट आ जाती है। अगर आप 4000 करते हैं तो ऑफिस के डिस्क्रिप्शन पे whenever they will get time they will examine your application and provide a examination report. एग्जामिनेशन रिपोर्ट में वही ऑब्जेक्शन रेज करेंगे जो हमने डिस्कस किया, नॉवेल्टी के, रिटन डिस्क्रिप्शन के, एनेबलमेंट के, इन्वेंटिव स्टेप के, क्लेम्स के। इसके रिस्पेक्ट में जो ऑब्जेक्शन है वो आपके एफआईआर में आएंगे और लास्ट में जब आपका सारा ऑब्जेक्शन और सब कुछ आप रिजॉल्व कर दोगे तो आपका पेटेंट ग्रांट हो जाएगा। ये चीज याद रखिएगा, कॉमनली लोग मिस्टेक करते हैं, याद रखिएगा ये गलतियां मत करिएगा। सबसे पहले अपना डिस्क्लोजर करने से पहले प्रोविजनल एप्लीकेशन फाइल कर लें। दूसरा क्या करें कि अगर आप फॉर्म 3 जरूर फाइल करें, प्रूफ ऑफ राइट ठीक से फाइल करें कि एप्लीकेंट और इन्वेंटर के रिस्पेक्ट में। और एक लास्ट में चीज बताऊंगा, टाइम क्या कंस्ट्रेंट ना हो तो मैं एक लास्ट चीज आपको बताऊंगा। जैसे मान लीजिए कि आप बायोलॉजिकल मटेरियल यूज कर रहे हो, आप इंडिया का बायोलॉजिकल मटेरियल, ह्यूमन की बात नहीं कर रहे, कोई भी प्लांट, एनिमल या उससे रिलेटेड आप कुछ भी अगर बायोलॉजिकल मटेरियल यूज कर रहे हो तो इंडिया से नो आप उसको यूज करने से पहले परमिशन लोगे, किससे? एनबीए से, नेशनल बायोडाइवर्सिटी अथॉरिटी से आप परमिशन लोगे। अगर आप नहीं लेते तो आपका पेटेंट ग्रांट होने के बाद भी वो लिम्बो में चला जाएगा, वो वहीं पर अटक जाएगा। ग्रांट होने के बाद ऐसा केसेस हुए, मैंने खुद देखे, यहाँ पर वो ग्रांट हो गया लेकिन वो फिर एनफोर्स नहीं हो पाया क्योंकि आपने एनबीए का अप्रूवल नहीं दिया। मान लीजिए एग्जाम्पल क्या हो सकता है, जैसे मान लीजिए कि मैंने टर्मरिक यूज की घर पे ग्रोसरी स्टोर से लेकर के, मैंने लखनऊ में मान लीजिए टर्मरिक ली और उसमें मैंने कुछ रिसर्च की उसकी जेनेटिक स्ट्रक्चर पर, और उससे कुछ मैंने चेंजेस करके नया कुछ बना लिया प्रोडक्ट, लेकिन मैंने एनबीए का अप्रूवल नहीं दिया, पेटेंट फाइल कर दिया। तो पेटेंट फाइलिंग के समय में मुझे एनबीए का अप्रूवल लेना जरूरी है, पहले से नहीं लेना है, रिसर्च से पहले आपको अप्रूवल नहीं लेना, लेकिन जब आप पेटेंट फाइल करोगे तो आप एनबीए का अप्रूवल लेंगे। और सोचेंगे ऐसा क्यों? तो उसका पर्पज ये है कि देखिए, जैसे आपने बात की थी टर्मरिक की, बासमती राइस की, नील की, आप इनको यूज कर रहे हो, यहाँ की आप संपदा को यूज कर रहे हो इंडिया की, लेकिन आप फिर किसी को बेनिफिट को शेयर करोगे। बेनिफिट शेयरिंग इज द मोस्ट इंपॉर्टेंट एस्पेक्ट। आप जब एनबीए को बताते हो तो एनबीए क्या करेगा, आपके साथ एक लाइसेंस करेगा जिसका बेनिफिट वो इसको ट्रांसफर करेगा ट्राइबल कम्युनिटीज को, या जो कम्युनिटी उसको डेवलप की होगी टेक्नोलॉजी को इनिशियली जो से एसोसिएटेड है। तो बेनिफिट शेयरिंग मेजर एस्पेक्ट है, जिसकी वजह से और कुछ वो 0.2-0.5% का कुछ चार्जेस लगा देते हैं कि जितना भी आपको कमर्शियलाइजेशन की जो वैल्यू है आप गेन करोगे उसमें से कुछ परसेंट आप उसमें इन्वेस्ट करोगे। ठीक है, सर्टिफिकेट ऑफ इन्वेंटरशिप मैंने आपको बता दिया, ये आप पुराने पेटेंट के लिए ले सकते हैं। आप एक फॉर्म फाइल करिए और आपको ये मिल जाएगा कि आपने ये फाइल ये वाला इन्वेंशन इन्वेंट किया था। ठीक है, कुछ और चीज़ें आपको बतानी चाहिए, जैसे आईपी मित्रा के बारे में बताना चाहिए। आई एम ऑल्सो रजिस्टर्ड आईपी मित्रा। तो हम लोग के पास क्या होता है कि हम लोग एसआईपी की जो स्टार्टअप है उनके लिए जब फाइल करते हैं तो हमें प्रोफेशनल फीस गवर्नमेंट देती है। तो आप आईपी मित्रास को कांटेक्ट कर सकते हैं फॉर फाइलिंग द पेटेंट। फाइनेंशियल असिस्टेंस के लिए आप लोगों को पता ही है कपला स्कीम चलती है, आपने उसका पैनल बनाया होगा, जिसकी वजह से क्या होता है कि जब आप फाइलिंग करेंगे तो फाइलिंग फीस की रिंबर्स हो जाती है। ठीक है, एफईआर के रिस्पेक्ट में मैंने आपको बता दिया, जो हम लोगों ने पहले डिस्कस किया वही सब आपके ऑब्जेक्शंस एफईआर में आते हैं। ठीक है, रिस्पॉन्ड कैसे करेंगे वो आपको बता दूं। कुछ फीस आपको बतानी चाहिए जो इंपॉर्टेंट रहती है। सबसे पहले फाइल करने की जो फीस है वो 1600 है। अब आपने मान ली प्रोविजनल फाइल कर दिया, बाद में आप कंप्लीट फाइल करो तो आपको दोबारा फाइलिंग फीस नहीं भरनी, तो प्रोविजनल वाली फीस से ही वो कवर हो जाता है। तो प्रोविजनल फाइल करने जरूर कोशिश करिए फाइल करने, ताकि आपका इन्वेंशन प्रोटेक्टेड रहे। उसके अलावा आपने फॉर्म 3 फाइल किया, फॉर्म 2 फाइल किया, फॉर्म 5 फाइल किया, जो डिस्कस हो चुका है, इनके रिस्पेक्ट कोई फीस नहीं है। एग्जामिनेशन की जो रिक्वेस्ट है उसकी मिनिमम फीस 4000 है। अगर आप जल्दी एक्सपेडिटेड एग्जामिनेशन कराना चाहें सबको अलाउ नहीं, लेकिन जिनको अलाउ है वो 8000 रुपीज दे करके कर सकते हैं। ठीक है, अगली पब्लिकेशन की फीस जो मैंने आपको बताया नॉर्मली 18 मंथ में होता है, लेकिन उस 18 मंथ में मान लीजिए कोई आपका कॉम्पिटिटर्स को यूज कर रहा है तो आप डैमेजेस क्लेम नहीं कर पाओगे। तो बेटर ये है कि आप क्या फाइल कर दो, फॉर्म 9। ठीक है, पेटेंट ग्रांट हो जाने का ये मतलब नहीं कि आपके पास कोई फाइनेंशियल लायबिलिटी नहीं है, आपको हर साल उसकी रिन्यूअल फीस 20 इयर्स तक भरनी पड़ेगी और वो इंक्रीमेंट होती जाती है। पहले 3 से 6 साल तक वो 800 रुपये रहती है, फिर 2400, फिर 4800 और 8000, इस तरीके से वो चार्जेस बढ़ती रहती है। तो इसलिए इंपॉर्टेंट है कि अगर आप पेटेंट डॉक्यूमेंट अपने पास ग्रांटेड रख रहे हैं तो बेस्ट ये है कि आप उसको वर्क करें, आप उस पर कुछ ना कुछ काम करें, वरना आप उसको फिर अबेंडन करें, आप फीस ना पे करें तो अबेंडन हो जाता है। ठीक है, एक चीज और याद रखिए, अब तो कमर्शियलाइजेशन का भी डिस्कशन होने लगा है, तो अगर आप अपने पेटेंट को कमर्शियलाइज करते हो तो जो डिफरेंस है फाइलिंग फीस में, जैसे कॉर्पोरेट फर्म की फाइलिंग फीस बहुत ज्यादा होती है, वो डिफरेंस भी कॉर्पोरेट पे करेगा। तो आपको ये नेगोशिएशन के समय पे याद रखना है। जैसे कि मान लीजिए कि मैंने फाइलिंग फीस एज ए स्टूडेंट फाइल किया तो मेरी 1600 लगी, क्योंकि नेचुरल पर्सन की 1600 है, लेकिन एक कॉर्पोरेट को मैंने बाद में वो टेक्नोलॉजी सेट कर दी तो कॉर्पोरेट की फाइलिंग फीस कितनी है, 8000 रुपीज। 1600 ऑलरेडी पेड है, 8000 पे होता है, तो जो डिफरेंस है 6400 वो फिर आपका पेंडिंग रह जाएगा और वो कौन पे करेगा, वो लार्ज एंटिटी पे करेगी। लास्ट चीज मैं आपको ये बताना चाहूंगा कि मेरा भी आपका ये पेटेंट अगर ग्रांट हो गया तो आप ये मत मानिए कि वो बाद में रिवोक नहीं हो सकता या वो डिसरिगार्ड नहीं हो सकता। पेटेंट की वैलिडिटी तभी घटे जब तक उसको आप चैलेंज नहीं करते हो। आप प्री ग्रांट पे चैलेंज कर सकते हो, मतलब जैसे मान लीजिए मैंने एप्लीकेशन फाइल की जो पब्लिश होती है तो पब्लिक के पास ये अपॉर्चुनिटी होती है कि वो उसको अपोज कर सके। अब इसका सिग्निफिकेंस आपके लिए क्या है, मान लीजिए आप किसी फील्ड में बात कर रहे हैं, आपको पता है ये चीज ऑलरेडी नोन है, ठीक है, और आपने देखा कि पेटेंट के जो जर्नल है जिसमें पब्लिश हुए डॉक्यूमेंट उसमें वही चीज डिस्कस हुई जो आप ऑलरेडी वर्क कर चुके हैं, तो आप क्या करोगे, आप प्री ग्रांट अपोजिशन फाइल कर दोगे। उसमें फायदा क्या रहेगा, आपको कोई चार्ज नहीं लगेगा, कोई फीस नहीं लगेगी। लेकिन एक बार अगर पेटेंट ग्रांट हो गया तो उसकी वैलिडिटी का प्रिजम्पशन हो जाता है, तो उस केस में क्या हो जाएगा, फिर आप अगर पोस्ट ग्रांट अपोजिशन फाइल करते हो तो उस केस में आपको फीस भी देनी पड़ेगी
और आपको ये भी प्रूव करना पड़ेगा कि आप उस फील्ड में काम करते हो। पर्सन इंटरेस्टेड ही फाइल कर सकता है, लेकिन प्री ग्रांट कोई फाइल कर सकता है। मैं उस फील्ड में काम कर रहा हूँ नहीं कर रहा हूँ, आई कैन फाइल अ प्री ग्रांट अपोजिशन, बट इफ आई एम नॉट वर्किंग इन द फील्ड देन आई कैन नॉट फाइल फॉर द पोस्ट ग्रांट। लेकिन इसके बाद की कहानी खत्म नहीं होती। एक चीज आगे हमेशा आ जाती है कि सारा पेटेंट का काम प्रॉपर्ली होना चाहिए, क्योंकि आपके पास लास्ट में ब्रह्मास्त्र रह जाता है रिवोकेशन का। रिवोकेशन आपके पेटेंट को कभी भी किल कर सकता है अगर उसने सारी प्रोसीजर और सब्सटेंटिव रिक्वायरमेंट को फुलफिल नहीं किया। प्रोसीजर कौन सी थी? पेटेंट डिस्क्रिप्शन, एनेबलमेंट, डैशबोर्ड, क्लेम्स, ठीक है। और सब्सटेंटिव रिक्वायरमेंट क्या थी? जैसे नोवेल्टी, इन्वेंटिव स्टेप और इंडस्ट्रियल एप्लीकेबिलिटी। अगर ये सब बार आप क्लियर नहीं करते हो, आप ये नहीं देखते हो कि आपका सब्जेक्ट मैटर पेटेंटेबल है कि नहीं है, तो ये मान के चलिए कि आप गलत तरीके से जो पेटेंट आपको ग्रांट हो गई है, तो हमेशा एक स्वॉर्ड और डमोक्लिस आपके गले पे टंगी हुई है। कभी कोई ऑब्जेक्शन रेज करेगा तो वो कट हो जाएगा, ठीक है। थैंक यू सो मच। कोई क्वेश्चंस? The floor is open to questions, please. Thank you so much. Thank you. Thank you for the applause.
Thank you so much, sir. It was indeed a very informative information about patent filing and non-patentable topics.
Now we move to the next keynote session. We welcome Dr. Om Prakash Sir, Director, Petalita Ventures. Dr. Om Prakash Sir, a company incorporated in Lucknow focused on deriving innovation and industry growth. He brings leadership and strategic insight to the organization's effort to support entrepreneurial activity and practical application of business ideas in emerging sectors. So give a big round of applause for Om Prakash Sir.
In a huge round of applause, please welcome Dr. Om Prakash Sir.
So, very best of afternoon to all of you. I have chosen the topic IPR and law, and I have tried to make it very basic because there are two aspects on which I will be focusing today. One is on the law, because IPR, as you know, is nothing but law. Right comes from the law itself. If you have a right, then it could be or should be protected by law. So one focus will be on law. And the second thing, I have tried to make this presentation very basic because I have dedicated this to the students who are learners, who are learning, and that's the reason I have dedicated this to the students. So the agenda for this session will be as follows. First, I will give you a brief description about law itself, what is law and what is IPR, because as I said that it will be very, very basic presentation. Second would be nature of IPR, because not only patents, there are a lot of other things on which you can go for IPR. It could be design, it could be copyright, and there are a few more things. Right. So I will be discussing on the nature of IPR. Then several times we have disputes, not from today, but since time immemorial, there have been disputes on the patents and copyrights. So then I'll discuss about the territorial and global rights. There are very interesting case laws on patents. I think all of you should know about this. So there are certain very, very important, very interesting case laws also with respect to IPR. And finally, I will talk about the legal remedies. What legal remedies are with you? Since IPR is protected by law, and there will be legal remedies should anyone challenge your IPR. Just for the thought for today. Now, maybe I'll give you some brief description about law itself. What is law? Because, as I said, that rights doesn't come to you unless and until, whether it's a property right or whether it's an intellectual right. Property right is a tangible right, and intellectual right is intangible. But both the rights should be protected. Suppose you have a property, but you cannot prove that this property is owned by you, then simply you cannot have a right on that property. Similarly, intellectual property, if you have invented something, but you cannot prove that this invention belongs to you, then you don't have the protection. Maybe somebody will acquire that invention, unless and until you've gone for IPR. So, coming to the law, what is law actually? Law is nothing but, we can say that it's a constitutional law, then several acts which have been enacted, and one thing which we don't, mostly I've seen that people forget this aspect, that from time to time, what the Supreme Court or the higher court judges rule, that is also part of the law, which are the case laws. So, law is very, very dynamic. It's more dynamic than artificial intelligence. You see how the law is evolving over the time. Because the cases which have been decided with respect to IPR is also law. So these were the thoughts just for today. And most of us are aware about the society. Currently, our technology, our skills are ushering us to the Industry 5.0. And industry is akin to the society. We started as gatherers and hunters, then we went to agriculture-based society, then industries, then information technology, and now AI. So AI is the fifth generation. This is what it says. And the aspects of law I already discussed. Ignorance of law cannot be the protection of law. Suppose you are ignorant about IPR. What tools we have with respect to IPR, or as somebody also told us about the patents, if you're not very well aware, then that cannot be the protection from law. I hope I am clear about this. So IPR, as I said, because right doesn't come to you unless and until there's a law which protects it, whether it's intellectual or a property-based law, tangible law, tangible property. So IPR is protected by law, and law is extremely dynamic itself, because we have to be very well aware about the cases which have been decided, yes, from time to time. And so many cases have been decided on IPR, that somebody told about neem and basmati rice and all. So we should be aware that what could be patented or what could be copyrighted or what could not be copyrighted. And it's just not the act, it's also, you see, the cases which have been decided from time to time. So we should be aware about those cases as well, and this helps us to, file new patents, new copyrights. This is really helpful. Now, what happens if you are ignorant about the law? Yes, we are all aware about Alan Turing and Robert Oppenheimer. Who are these guys? Alan Turing has been regarded widely as father of AI, because AI is not, we have sometimes this misnomer or misunderstanding that AI is latest development. It's not true. AI was since 1930s or 1940s. These guys existed in 1940s, and they single-handedly, like Alan Turing, as per one version, single-handedly won the Second World War for the Allies. And so is Robert Oppenheimer. But what actually happened? That Alan Turing and these guys were not very well aware about the law, and they got into some sort of a trouble. And there was no concept of IPR. So despite that Alan Turing developed the first computer, he was the one who developed, and we study about the Turing machine or Turing process or Turing theory. But there was very unfortunate end for both of these. And Oppenheimer developed the A-bomb, but there was no concept of, getting the IPR, and that information was disseminated to Soviet Union and other countries. So all of them, they were able to develop the A-bombs. And in return, they didn't
didn't get anything because somewhere or somewhat they were not very fully aware about the law. And law itself is a very, very important concept in today's world. This is what I wanted to exert to the students, to the young minds, that they should be quite well aware. Now, this is something about, what I tell my students is that I've worked for Symbiosis for 12 years in Pune, and then here also a couple of colleges I've worked, and entrepreneurship was also given to me earlier on. And I see the students and most people, they are running after the jobs. I always tell them that the world is so big, you need not always run for the jobs, you can invent something of your own as well. And this is how the Patanita Ventures was formed, and it has got 5 verticals. This is just to tell you that how we can start our own work. But later on, I will come to the intellectual property. Unless somebody might steal your ideas, as Mr. Dwivedi also told, that it's very important that we should, acquire the intellectual property rights on something which we have invented. Right? So, like 5 verticals are here. There is the compost which I developed. So the patents are pending on that. I have already. And then some term which you coin, some technology or some design, you can also go for getting the intellectual rights on that. If you want to ensure that nobody else, like we saw in the Oppenheimer's case or Alan Turing case, right? So somebody else stole their ideas and they were out from the mainstream. Though they were the most important, inventors, but suddenly. And let's see what Ilkar Ramso is a Finnish intellectual property. So he actually expressed about the different stages of the society and different stages of the industry. And at every time, that has to be protected. Now we are in the world of AI. So whatever inventions we have done in AI, they need to be protected. As I said, that it's very basic, and this is dedicated to the students. Maybe we know, but IT includes original ideas. Not only the original ideas, the research results, the results of the research which you might have done, and the critical business information. Critical business information is also something which can be protected under intellectual property. You can get the rights on such things as well, not just the patents only. Okay, so while it takes time that it resumes, I'll discuss more about that. So, for instance, we have the patents, which Mr. Dwivedi also told you in detail that how you can go and file about it. But besides, you can develop a software and go for the copyright. And I would recommend that one time the students especially can do it on their own, right? It just costs rupees 500 to file a copyright, maybe in the software, or maybe you can go for a particular design. Suppose you have designed something, a new pillar maybe, or a new machine. The design can also be taken as an intellectual right, and there are different interfaces where you can go for the design as well. Then another term is trademark or the logo. So for a company, if you have designed a logo or maybe a particular line which is comes under the logo of your company, you can also go for the trademark. We have the different company names, and these are within the trademark. And there are interfaces where you can go for the trademark, registering the trademark of your company. And intellectual, we know that which has come from our intellect, something which has come from our intellect, that is intellectual. And property, which can be of two kinds, public and property, public and private property. So public is in general, and private is our individual property. Now, as I said that I will be focusing more on the law so that we are able to understand that what it means. We have a particular Benami Transactions Prohibition Act 1988 which defines the property, and it includes the intellectual property as well. The concept of intellectual property, because the property word is embedded in IPR, so how the property can be defined, which is in the particular Benami Transactions Act 1988. Right? So the definition of property comes from here, and it could be very useful to understand this definition. And right, as I said, that unless and until some law or act protects your right, it is not a right at all. And right gives you a liberty. I think if you can focus on that, the right gives you liberty and license. If you own something, then you have the complete ownership of that. But at the same time, you can also provide the license to somebody else. जैसे हमें प्रॉपर्टी होती है ना, हम लाइसेंस दे सकते हैं किसी और को यूज करने के लिए, बिकॉज वी ओन दैट. सेम इज द केस विद द IPR also. So these are the basic things, and this is what we have actually discussed so far. This is a summary of. Now let's come to the tangible and intangible property and what rights we have. See, we can use it, live and build for the tangible, but in intellectual we can actually stop the usage. That's the basic difference between tangible and intangible, and we can sell, rent, mortgage, give both the properties. The tangible property has indefinite rights, whereas intangible may be having the definite rights, definite period. Now, for the IPR, there are certain things which can be discussed. One is the territorial right jurisdiction, what jurisdiction we have, then time bound, assignable, independent, balance between public and private, which can be sold as well as bought. So even the IPR can be sold or can be bought. So general concepts which we should be very much aware of these things. Now coming to the case laws, there is a very interesting case law, Toyota Gidosha versus Mrs. Price Automotive Industries Limited. So before that, Toyota was owning certain brands, but Price was used by, the name itself was used by a company which came prior to the Toyota. And there was a legal case, and the case was in the favor of Price because it was ruled that Price can be used by that particular company. And the territorial right is one important aspect. We all know about the term Mazda. So Mazda was owned by Bisleri earlier, and they had sold the rights to Coca-Cola. And later on, Coca-Cola had restricted that Mazda cannot be exported by Bisleri company. However, the ruling was such that the court already allowed Coca-Cola in favor of Coca-Cola that they will prevent this company, Bisleri, because they had sold the rights to Coca-Cola. So they allowed Coca-Cola that they can actually prevent Bisleri to export it because it's a territorial right. You see? This is a territorial versus global. So if the right is there within a country that can be within that country itself. That means it's territorial. So they can sell the rights to a particular company like Coca-Cola, and then they have sold it for good. So that means they cannot export to any other country. So that was a very, very important case, Coca-Cola versus Distillery, and we have given the case number as well. And as I said that there are various acts. So intellectual property is just not the patent. There are other things as well. So patents are governed by Patent Act 1970. Then there is the Trademarks Act 1999, Copyright Act 1957, Design Act 2000. So these are the various acts which govern the different aspects of intellectual property. Then we also have geographical indication. That is another IP, geographical indication. So IP is just not limited to patents. There are other things as well. And then there are plant varieties and even the Information Technology Act 2000. Then about the time-bound aspect, you can see patents have a duration of 20 years. Trademark is just for 6 to 10 years. Design is 6 to 10 years, and copyright is 60 years after the death. So this is the duration which we have for these particular IPs. And I think this is a very good slide about the mobile phone. You can see that software, it can be protected by copyright, and the improvements can be protected by patent. Then shape is protected by industrial design, and name or logo is protected by trademark. So different aspects are there. In one particular piece of technology, we can go for different IPs, and this is very clear from this particular slide. Then another aspect is balance between private and public. So even if you have got a patent on certain thing, and if it is for the interest of public, then there comes about a term which is known as compulsory licenses. So if you, no matter if you have developed something, and if it will be in the interest of a particular community, then the government will tell you that, okay, other people can also develop such a technology or the drug. That's a very important aspect. So the government has the rights to actually work on those patents which you have invented, if it is in the public interest. So we talked about territorial and geographical, then also the public interest. And somebody also spoke about this. So Nexavar was a particular anti-cancer drug, and the cost of the drug was very, very high. So there was a ruling that, okay, other companies can also be allowed to develop those drugs similar to Nexavar, or they can be allowed to sell it in the reasonable price, because this is in the public interest. It's a very important aspect that we should understand, because patent doesn't give you a complete authoritative and indefinite right. There are laws, and there are things which we must also understand. So, different things. Idea, expression is copyright. Invention and innovation comes under patents. The quality and identity comes under trademark. The appearances come under the design, and confidentiality and trade secret also can be patent. Also can be under the intellectual property, like secrets of business secrets. Then different, we have this distinction classification as well. So as to understand that what particular intellectual property we have, like trademarks, like designs. So it's just not the patent. And another thing which I will emphasize is that we can do it ourselves. I always emphasize in doing it yourself, rather than seeking the help of other company. For instance, you want to go for a copyright, you can do it yourself. You want to go for a patent,
you can do it on your own. Because I have 5 patents and now I'll be having more copyrights because almost 5 more copyrights. I have 5 copyrights. I've done it everything myself and I have my own digital signature and I've never taken help of anyone. Because if you're caught somewhere, if there's any difficulty, you will be informed and you have to correct the defects. So you can also call the copyright office which is in Delhi and you can also call the patent office which I know one is in Mumbai. So you can always contact the people and get the things done. And in the concept of Atmanirbhar Bharat, these things are getting expedited. So you get all the help which is necessary so that if you do not infringe a particular law, then it is the duty of the particular organization that the trademark or the copyright or the design or the patent will be granted to you, unless and until it infringes. For the patent itself, it is published for many days. If somebody has any problem, they will raise the objection and will come to you, and then you can remove the defects. So finally, what I want to say is that to try to do it yourself, because there will be many companies who will be trying to help you, and sometimes what they do is that they steal your idea. You share the information with your attorney, with your advocate, then what will happen that they tend to steal your ideas and they will face some problems, but ultimately you will lose on the trademark or copyright. Since it's an intellectual property, I think if you are that clever, that intelligent, that you can develop a new idea, why can't you file it yourself? I've done it myself, and you can also, especially the students, I encourage the students to file the copyright, designs, whatever. Do it yourself. That's the key. Because I have learned very hard way. In 2001, for instance, I was in Singapore and I was developing some software. And I wanted this thing to be published because it was certain innovation in replications. In 2001, I published my article in Database Journal. And then I also pasted some codes there. So what happened that companies like Oracle, there was another company called Toad, which was developing Oracle products. So they tend to get the idea from me, the software, and they went on to develop a commercial product. But that time I was not very well aware about the IPs and all, It was not very, that knowledge was not available to me. And then that idea was particularly stolen. So I learned the very hard way that try and do those things yourself as much as possible. That message was especially for the students who are trying to develop new things and new things and trying to develop on the new ideas. So once you do it, and lot of in Google, if you Google particular form, all the information is available to you, and the help is available to you to how you go and fill it. Rather than giving it to some other company and that company may charge, for instance, I keep writing books. I have written around 30 books. So they tell me that we will copyright the books for you, you see. And but I do it myself, just to prevent any plagiarism. Other thing, see, law, I always say that because of my experience, I always say that it's an in thing for everyone. We must be aware about the law. Suppose somebody is claiming about or somebody is disputing about your patent or the copyright or the trademark, then you have certain legal remedies which are available with you. And these are the legal remedies. There are civil remedies, criminal remedies, injunction, damage account, Anton pillar, Manual injunction, John Doe orders. These are the various legal remedies which are very well available for you, and you can use them if your particular intellectual property is being challenged. So you have these tools in your hand to protect your intellectual property. Because I said that this right which you have, the IPR, this right which you have, is protected by the law. And then we should not forget about the territorial thing. The IPR is very much territorial. Somebody has developed somewhere else and you are developing similar idea yourself in your territory. So you must also remember that it's territorial, not global. And even if you get the IPR for a particular IP, that is within that territory. It's not global. That is one thing we must keep in mind. Then I have just given some definitions about the injunction and all. Injunction is nothing but the court prevents you to either do or not to do certain things. This is particularly the injunction. So if there is any violation or infringement of your IP, then you can go for the injunction. Damage, if somebody is illegally or infringing your rights of IP or particular trademark. I will come to that also. There are very interesting cases where people have misused somebody else's trademark. And then what rights which we have available. See, damages and account of profit. How much damages you incur because somebody else used your name. You see? Then there is very interesting Anthem Pillar order. This is a landmark order for IP. Everybody who is IP professional, I think they must be aware about this. And Anthem Pillar, because it gives the defendant right to inspect, and many people used Microsoft products that time without getting the license, and Microsoft products were copyrighted and patented. So you could not actually use. So how much order was given? 1,975 million was awarded to Microsoft. That's the landmark order. So what do we understand from this? That we just cannot use somebody's right, somebody's trademark, somebody's product without giving the due credit to that particular company. So Anthem Pillar Act we should be very well aware of. There is a narrow intention. Then it means that the court prevents you to sell the assets. John Doe order. Then this is an order you can see, particularly the ESPN software. It was very, very popular that time, ESPN versus Studio. They were not having the rights and they were broadcasting the ICC in 2011, the year which we won the World Cup. And many channels were broadcasting. These are particular John Doe orders. And we are seeing that many times we download the movies, right? A lot of torrents are, there's a torrent site. We tend to download the movies from certain sites. So John Doe is just, the right that nobody should be able to either upload or download something which doesn't belong to you or where they have not paid the enough amount. There is John Locke. If you have done something, then the credit should go to you. So all of these are related. If you have developed something, then you should get the credit of whatever you have developed. That is basically the jurisdiction. Jeremy Bentham and John Stewart. Another very important aspect, sometimes we tend to ignore these, that we talk about patents, we talk about copyrights. But one important thing is that that particular patent or copyright or trademark should not harm the society. Otherwise, you will not get it. So it should be in the interest or for the happiness of the society. Unless and until it is for the happiness of the society, for the well-being of the society, it will not be granted. That is about utilitarian society. The concept which was brought by Jeremy Bentham. Incentive theory. Incentive theory means that if somebody has developed certain things, they should get the incentive. That's basically something which we must understand. Unless and until there is an incentive, nobody is going for taking the patent or copyright unless and until they have that particular incentive. This is the incentive theory about IP. And these are certain justifications by et al. I see that in India, there are not many patents which have become. We see that even the ordinary products are developed by the foreign countries we are merely using. Because somewhere this knowledge is lacking. So only the top institutes I have seen that they go for a lot of patents, but commonly the institutes they are not having that many patents as compared to other universities which are there in the foreign country, we see the normal, even the normal products like Suzuki and all, they are coming from the foreign countries, but somewhere or somehow we have ignored these aspects about the incentive theory, about what the rights are for, and how we can go about getting it. This is about the Pirate Bay and about the torrents. They keep uploading the torrents, and they have the right to actually visit the site and control the piracy. The piracy of, for instance, films. Films are also intellectual property, and we cannot just go and download it. And so there are certain laws which can prevent it from the download. Right. So this is a summary of IPR, what we have discussed in this session. We discussed about the territorial rights, we discussed about certain cases, we discussed about being time bound and assignable, independence, the balance between public and private, what can be sold and what cannot be, what can be bought, and what can pass under will. Even IP can be passed under will. Right? So it doesn't mean that somebody dies and then the IP is also gone. IP means the trademark, the company trademark, you know. So whoever has got the trademark doesn't mean that if the person dies, then their generations cannot use it. They can actually. That's the will. And I think that's all for today. And if you have any questions, you can always come up and ask any questions. So thank you.
Thank you so much, sir. Can we have a huge round of applause for Dr. Prakash, sir? Thank you so much, sir, about explaining us about various laws related to IPR.
Now we proceed to our next keynote session. We welcome Professor Dr. Varun Sir, Professor, Faculty of Law.
I request Dr. Rishi Asthana, sir, Director GITM, to please present the token of welcome to Dr. Varun, Professor, Faculty of Law, University of Lucknow. Please put your hands together and welcome Professor Dr. Varun, sir. I would now like to invite sir on the stage to share his insights on IPR.
Dr. Goel sir has a 14 years of teaching experience. He has currently a member of planning board at Baba Saheb Bhimrao Ambedkar Central University, Lucknow, and serves on as a member of Academic Council of University of Lucknow. He also director of Dr. Shankar Dayal Sharma Institute of Democracy and the RTI cell at the University of Lucknow. Please give a huge round of applause for sir.
Can we have a huge round of applause when we welcome sir on the stage?
All the dignitaries of the dais and my dear students. I think it is an honor and a privilege today that I have been invited to deliver a talk on a very important subject matter, which is a matter of concern for the whole of the world and specifically India. When you are a last speaker, sometimes it becomes very difficult for you to cope with the situation. You know why? Because all have spoken so much about it. My last speaker has spoken everything about it. Now the point is that being a last speaker, it becomes a very, it is a kind of a dilemma, what to speak. But I'm trying that, you will not see any kind of repetition. Now, this is my responsibility also. So, the point here is that there is a lot of debate. And the most important aspect at this point of time regarding the debate is, in institutions across India, that how the universities work within an environment where every day you see a lot of change. Why I'm saying so, there is a lot of changes in the public policy at this point of time, and there is a discourse everywhere. And that discourse talks about novelty, inventions, discussions at the international forum and on the Indian forums. But in academia, there is a lot of issues and there is a lot to be discussed. Because in academia, the institutions are not very much inclined towards filing for patents. And this is what is an issue. And that is what is a matter of concern for the institutions in India, specifically educational institutions. Now, when the situation is such, what becomes more important is that we'll have to first understand whether we do have that idea which do have the novelty. Now, everybody is writing, being a professor of law, it's been almost 15 years. I started my deliberation as a student from Delhi University and then from Jamia. And it's been a long association with different national universities across India. And what I find is that there is a lot to be learned in India regarding the ideas. There are a lot of people, John Stuart Mill, abhi hamare sir ne pehle bataya, there is a lot of jurisprudence. Now, the jurisprudence worked for almost 200 years, but the idea is still a very serious kind of an issue, because nobody knows what is something novel in the idea. Now, who can think about it? Anybody. It is you, it is me, everybody who is working in the field, who is working in the domain of the policy or otherwise. We see a number of changes in the whole of the world order. So we need to invent something which is new. Now, we saw a very difficult kind of a situation where the whole of the world had to see 9 months of, closure. And there was coronavirus. We all were praying to God, कैसे बचेंगे? क्या अब हम बच पाएंगे या नहीं? That was something which was, a matter of concern in everybody's mind. But somebody developed an idea at that point of time. And that idea, when transformed into a medicine, you saw an injection. Now, when you saw that injection, you saw that medicine, and then Serum Institute and a number of Pfizer and everybody across the world, they developed that injection. So that was an idea. And that is what is my core area, because I've seen, I was not here for the other speakers, but I was there for my last speaker, and he talks about each and everything about it in a very classical manner. So I thought that it is my duty, to talk about the whole of the structural aspect, the philosophical understanding. And the philosophical understanding is that when you have an idea, and when you transform that idea into an asset, what kind of asset? Bauddhik sampada se nikla hua asset, that is intellectual property. And that is something which is new. That is something which is, nobody has seen, that there is a novelty, unexplainable. Nobody knows about it. And there is a lot of new idea in it. And from there, the whole story started. And from there, the intellectual property becomes a matter of concern. Now, when we talk about this whole discussion of intellectual property and specifically, the areas, the important aspect which becomes qualitative kind of understanding is the economical aspect. The whole of the world is working on it. Novartis specifically, if we talk about the cancer medicine, there is a lot of discussion and debate in the society and even at the Supreme Court. Now, the developing countries will have to again and again request developed countries to transfer technology. Now, the economic imperative, is a very difficult kind of a situation because it do not allow developed countries to sell their ideas. Now, who will pay? The developing countries, the African subcontinent, the Asia, lot of population. And then this whole ecosystem, when this whole ecosystem strategizes itself in form of a tool, the problem lies with an idea and the solution lies with intellectual property laws. Why? Because somebody said that innovation is the engine of progress and IP is the shield. Now, if you want to progress, if you want to develop, if you want to develop your society, and if you want to develop your intellectual domain, you will have to work on newness. You will have to work on innovations. You will have to work on faster technologies. Every day you see now, we are becoming a hub. Very soon we're gonna, by the virtue of the Honorable Prime Minister's idea of Make in India, you are an engineering institution. You very well know how it works. And this idea of Make in India, and you see that the whole of the progress we demand at some juncture becomes a very important kind of tool. So the universities, specifically the engineering colleges or the research institutions across India, they all want technologically driven system. Every day in engineering institutes and universities across India and world, there is a lot of invention, there is a lot of discussion, there is a lot of work going on different kind of engines which can accelerate, the society. I've never been a student of science, but I was a student of economics and I'm a student of law. But what I can understand is that if you want the growth rate to go up, you need to think about something new. So that when you think about something new, then only your GDP will increase. Then only the per capita income will increase. Then only the microeconomic constraints can be controlled. And that is how, you see Viksit Bharat. We all talk about it. But that is something which is an important criteria. And this engineering shield in the Indian context, because we are a service-based economy. So, innovation-driven economy is the need of the hour. Every engineering institution must produce new ideas, new technologies which are driven by qualitative intellectual property and information technology. Because that is what is increasing every day. You see a lot of, last speaker has already talked about so many things like, the Oracle, Microsoft, and number of things, and number of, companies across the world. You see, we have one system from Microsoft, another system from Mac. Mac is very fast. This is all about the technology. Why somebody is buying a phone, iPhone, at a price of 70, 80,000, 1 lakh. On the other hand, you can buy a similar kind of a phone. I'm not saying it is similar, but to some extent the technology, maybe the software may be different, but you can buy it in 20,000 or 30,000 rupees. But what is something special with the Apple? It is all about the technology. It is all about the qualitative invention they made through this particular aspect of intellectual property. Now, when it changes in the technological advancements, the most important aspect every institution has to face is the failure. So people think that if their invention fails, what will they do? So what we'll have to understand is we will have to strategize. We will have to strategize in such a manner wherein we must have a qualitative workforce with a qualitative idea. I just ponder on this particular aspect. There is a national group. Why I am saying so? Because if there is a rejection, as my last speaker rightly said, you file patents, unless and until you file patents, you may never be able to understand the deliberation. You will have to file patents. You have patent agents. They talk about different things. You don't need to go by those things. You need to go by your own conscience. Because you are the creator. You created that. You know the deliberations. You know the outcome. You know the possibilities. So, when you see all these aspects, you see there is a lot of problem in filing patents. And there are 4 failure points which I find are very, very relevant to discuss. The first point is a procedural lapse. So, supposedly if you miss the deadline within a stipulated time, if you do not file it, you may never be able to, because the extensive use can only be utilized when you prove that there is a newness. The second is weak drafting. You are not being able to, prove your point that your idea is new. When you are not being able to prove it, that your idea is new, then there is a very, low possibilities that the person who had to check it, verify it, he may verify it or he may allow it. So, a lot of issues regarding the weight specifications you see in different kind of patent draftings. Then the third one, the most important one, is loss of novelty. Now you develop an idea, you keep it in your mind, you do not deliberate upon it in your labs, you just keep it with your group. And there are a number of labs in India who are working on it. They produce their idea, they file the patent, they fulfill the specifications, and you are still thinking that yes, we will do it. There is a lot of time, sorry, the situation is not such. The economy is on the very steady path in the whole of the world. And patent is not a municipal kind of idea. We are not talking about the municipal law. We are talking about the international law. So, you are filing patent for a particular configuration, for a particular idea. There are hundreds and thousands of people across the world who are already, in their mind, who do have this particular idea in their mind, and they may deliberate upon it. Intellectual property law, and specifically patent, is a universal kind of a phenomenon. So you cannot just think that हमारे लखनऊ में नहीं हो रहा है, या हमारे उत्तर प्रदेश में नहीं हो रहा है, या भारत में नहीं हो रहा है, तो ठीक है हमारे पास टाइम है. No, it is not like that. It's a world order, by the way. It's a universal order. And that is why, the loss of novelty. And sometimes there are a number of accidental disclosures. It happens, because of which there is a failure in filing. So, what we need to understand is, the moment the idea came into your mind, process it with the best of your ability. Take the best technical advice from the best technical person. Do it. File it. The moment you file it, you come to know what are the objections, supposedly, if they are. And then, you can remove them by the virtue of your own intellectual domain. The last one is misunderstanding the criteria. Now, sometimes, some ideas in my mind, they are very novel according to me. But the point is, when you see the whole world order, you do not know what is happening in Denmark. You do not know what is happening in France. You do not know what is happening in Australia. But you know what is happening in your mind. So it's better off that what comes into your mind, just file it. What is the worst point you can see? The worst point is your patent will be rejected. No problem. But at least you will have one exposure to file it. And then you come to know that what are the intricacies. I mean, this is the best idea. This is how the intellectual property domain works within the multi-dimensional system and multi-dimensional societies across the world. Now, when we move a little bit further, there are three pillars of patentability. And these three pillars are very, very essential pillars. Let me tell you this time. You want to get grant of your patent application. First of all, the foremost thing which you will have to keep in mind, again and again I am using the term novelty, this is the key. This is the strategic point. This is the base, crux. So there must be newness in your idea at the global scale, which is first foremost pillar of patentability. The next one is that it must reflect in your research that it is an inventive step. Now, there must be some sort of skill in it, that intellectual skill, which is new as an idea, which you have the novelty. More importantly, its applicability. You make something which do not, suffice the need of the people at all. And what is the usage? बहुत सारे मैं देखता हूँ universities में, I'm very sorry to say that, but I see there are a number of people who used to get patent. But if you ask what is the usage, कितनी marketability है आपकी, तो वो नहीं पता. कितना आपने उससे कमाया और कितने को रोजगार दिया, ये अभी आपको नहीं पता. What is the usage? You will have to make such things which are useful for the society, which are useful. So, if it can be used in the industry, then otherwise, there are lot of softwares developed for the world with integrated systems. You make so many IT solutions, but these solutions become solutions when they provide solution to the people. If they do not provide solution to the people, what is the need? The point is such. There may be novelty, but what is the usage? This is the important skill we need to understand. Now, a number of cyber security tools at this point of time, and we see there is a failure again and again. Somebody call you, ask for the OTP, and it happens. Then, if it happens, all this IT, technology, I mean, what are they doing? But why can't they provide shield? So, they cannot provide shield because there is some idea in mind. That idea may be unethical, but it's an idea of an hacker. And he just, destroy everything and make you look at it. It is also an idea, though it may be an unethical idea. So the distinction ought to be understood. Your idea must always be noble, legal, not legal, then it is unethical. It has no usage for the society at large, and hence of no use. I'll just put few of the case studies and I'll just end my discussion. You know, there is a power of incremental innovations in every idea. Now, some particular example, there is a scenario, there is a startup and cooling system for data centers, yes, and sensors and automations. The inventors, had a guy, and he improvised that by the virtue of the technology. And that idea of improvisation was granted as a patent. Now, that idea provides cooling to the system, because of which that aspect remains untouched and it is working efficiently without any problem. अभी हम क्या कर रहे हैं? I'm speaking बीच में हमारा माइक बंद हो जाता है. There is a lag. So now, if somebody will have to control that, he will have to use the technology. Now, this is what is the notion of advancement. And that particular advancement can only come when the technician knows the idea. Whether he do have an idea to control this technical glitch, this is the skill. I'm just giving a very a micro kind of an example. But let me tell you this fact that if you adopt this micro kind of idea at the macro level, the idea is always an idea and it can change the whole of the system. Now, it's a key lesson. Let me tell you this fact that, you see, the base and the idea. In public policy discourse, I used to work in public policy discourse. And every day we used to see a number of developments in environmental ecosystem, because we are seeing a lot of changes in our environment, and there is a lot of climate change. Now this climate change and this idea, again, is a matter of concern. Why? We have a lot of discussions from 1972 Stockholm Declaration, then 1992 Rio, then 2002 Johannesburg, then 2015 Paris Agreement, then, Conference of Parties. Now when we see a whole of the discourse, so the outcome which we see at this point of time, wherein we have just now concluded with COP, Conference of Parties 30, Conference of Parties 28, 29, 30, about idea. They all talk about idea to tackle climate change. How? Through the technology. Through the technology transfer. We will have to create funds. We will have to create quality kind of an environment. And when you talk about this particular idea of changing the whole discourse, हम तो बात कर रहे हैं 2030 तक हम 5 डिग्री कम करेंगे, क्योटो प्रोटोकॉल है, ये है, वो है, number of discussions. I'm sometimes amazed, in AC halls people sit and they talk about chlorofluorocarbons. What is the point? What is the point? Why don't you sit outside in the nature and you talk about the idea? And you develop a patent. And when you develop a patent, you develop the intellectual property discourse. But you don't. And that is why you see a lot of talk on the carbon emissions. But engineering institutions across the world, whether they are able to cope with that emission, this is a issue. And intellectual property will have to cope with issue. Because time and again, you need to develop a roadmap. If you are not being able to develop a roadmap, then अभी तो आप कह रहे हैं कि हिंदुस्तान की 10 में से 7 बड़ी सिटीज हाईली पोल्यूटेड हैं। आपका AQI लखनऊ का 700 मिनिमम है, छोटी मोटी जगहों पर, कई जगह तो 1000 से। दिल्ली इज अ गैस चैम्बर। आपने CNG ले आए, there is a lot of MC Mehta filings in the Supreme Court, n number of Supreme Court orders, MC Mehta versus around 12 orders. But still we are on the same discussion. Where is the idea? Where is the idea? Every day we will have to face, we talk about carbon footprints, we talk about carbon trade, at the cost of what? At the cost of human life. And ultimately, for what? For economy. Why there is no discourse on intellectual property law here in this hall? Why? For the economics. We need to maintain balance between the economics and we need to maintain balance with the development. And the idea is required to sustain those technologies within the understanding of our ecosystem so that we may have sustainable development for the growing economies. And that is why we talk about intellectual property. Otherwise, there is no need. So there is no need to discuss the whole of the discourse here. Why we are discussing this discourse? So, you will have to first, talk about the ideas in a very social kind of a manner. It's an art. Just think it as a painter. Think about it as a painter. You are a painter. You're making a new kind of an idea. A painting. If people like it, it will have to go to crores of rupees. But if people don't like it, useless. Now if people don't like it, who will grant patent? By the way, it must have marketability. And this is what is a matter of concern. So, you do drafting, you do examinations, and when there is a lot of discussion on examination point of view with respect to the patent, the examiners will have to deliberate upon these ideas in a very, social manner. They will have to think about that particular idea, whether it will suffice the need of the society, social needs. Somebody said, Professor Bakshi, Upendra Bakshi, he said, law is an instrument of social change. And that is why we need law. Now, I'm a person from law. So, when I think about intellectual property law, I think that a very serious kind of foresight is required. I'm very much concerned about it. Why? Because I see there is a lot of change. Why there is a change? There is a problem. There is a problem. I can discuss a case study here with you. That when we talk about climate change, and because we don't have technologies, so the deprived section of the society do not have the chance to live with dignity. So what is happening is, the government will have to file an affidavit before the Supreme Court that we have almost 40% of people live below poverty line. Now, if you want the deprived section of the society to work, if you want employment, if you want qualitative, sustainable development, property rights. And as a patent owner, you will also have to think about distributing your ideas to the deprived section. Next week, I am moving to France in University of Lyon. There is a discourse by IPR, International Public Policy Association, and I am speaking there on this particular aspect of case study. That the scheduled caste women, who is a major contributor, in fields across India, is not getting an edge. They are not getting their, what they deserve. Why? Because there is lack of technology. They are killing themselves with cancer and any number of problems they face every day. Why? Because we do not talk about technology in response to the public policy discourse, which is a matter of concern at this point of time. So this discourse of filing, drafting, and identity is a very serious kind of an issue we need to dwell upon. This is the need of the hour. Now, identification and critical search, as my previous speakers have already talked about it, let me tell you this while that first of all you will have to see the problem. What is the problem? Whether your idea problem or not, this is what is the matter of the. What is something which is technically new is the core of the matter, and how it is better than the existing solutions which are available in the market. This is the core method. And this is the core idea of identification. The more you identify critical problems, the more you develop qualitative ideas. Now, in this context, we have a patent office, we have a World Intellectual Property Organization set up for the patent scope, we have the Goel patents, and many of the applications fails, in these because there is a lack of novelty, there is a lack of usage, and there is a lack of proper research. The more qualitative research you will have, the more qualitative invention you may produce. This is something which is important. आपके हर डिस्ट्रिक्ट में वन डिस्ट्रिक्ट वन प्रोडक्ट, कहीं का रसगुल्ला बहुत अच्छा है, कहीं की काश्तकारी बहुत अच्छी है, कहीं कोई चादर बनाई जा रही है, कोई टेक्सटाइल का काम है, you will have to transform this idea that look, we produce the best of the mangoes in Lucknow. Yes, no doubt about it. The sherry, it goes to the whole of the world. But the point is, whether we have been able to make it an industry at a larger scale, with the advancement of the technologies, with producing more breeds, right? One person, got publishing from this, in Lucknow. Now, why can't the inventors think about these ideas in biotechnological ways? The more biotechnological advancement you think, through these ideas, there might be possibility that you may produce a very qualitative kind of an idea. Again. So, keeping this particular aspect, timing is everything. As I told you, if you don't have the timing, if you don't comply with the provisional specifications in order as per the filing requirements, then there is a problem of a vague idea. There are a lot of applications of the similar kind of ideas. To complete specification, complete legal drafting, complete, there must be no variation at all. And if there is, that must be taken into consideration. This is something which is important. So, yes, somebody said that I have a legal right. On the other hand, you will have to understand that there are claims also. So, legal rights wireframes. You will have to understand that everybody needs technology ultimately. And you cannot put the whole of the society at ransom because you do have the exclusive use over it. No. You will have to think about it. Why you develop technology? For the development, for the advancement of the society, and for all sections of the society, because advancement cannot, happen unless and until you take everybody with you. If you do not, there is a lot of gap. आज आप यही बात कह रहे हैं कि साहब गरीबी की रेखा से नीचे रहने वाले काफी लोग हैं, तो माननीय प्रधानमंत्री जी ने भी कहा कि 80 करोड़ लोगों को हमने लंबे समय तक अनाज उपलब्ध कराया है, अभी भी कहा थ्रू फूड सिक्योरिटी एक्ट 2013। तो एक बड़ा बोनस हमारे जो वैज्ञानिक हैं उनके ऊपर, हमारे एजुकेशनल इंस्टीट्यूशंस के पास, they will have to think about it. That unless and until they develop an idea, then it is very difficult for the Food Corporation of India to distribute these grains for a longer period of time. We will have to think about it. Basically, you see there is a lot of development in outskirts, and you see that circuit cities are developing. But at the cost of what? You killed the whole of the ecological system. सारे तालाब आपने पाट दिए. The water population is a very serious concern at this point of time. Water tanneries. You're killing water tanneries. You don't see small ponds in your villages also nowadays. लोग प्लॉटिंग कर रहे हैं, प्लॉटिंग आप इसको बंद कर देंगे, स्टार्ट कर. You don't even think, that when you do such kind of things, you're killing agricultural ecosystem. And the technology and the regulation now have a role to play. The government will have to regulate, and the engineering institutions will have to focus on technology at low price. Why we need to go to United States for every technology, or to the Russia? Why can't we develop here? We can. With a very limited kind of understanding. People are developing so many things since 200 years back. Why can't we at this point of time, when we do have a lot of technology with us, why can't we make use of it? And why can't we develop intellectual property domain as an instrumental factor? Nowadays, we have another kind of development, and that is artificial intelligence. Why can't we, see that interface of AI with the IPR? And there is a lot of development in that particular area. So you will have to, when you talk about this particular aspect of patentability and specifically the intellectual property rights, there are two kinds of claims, narrow claims and broader claims. And when you see a case study, there is a clean energy startup. Initially, when you talk about the clean energy startup, first of all, you said that we'll use ethanol at this particular point of ratio. Then you see that, we will increase the rate of ethanol. Now, ultimately, you say that it is also creating pollution. Now, this is something which is a very vicious kind of a story. It's a vicious circle. First of all, we talk about, we will close diesel, we'll work on petrol. Then we'll work on CNG. Now we are working on e-vehicles. But the question is, what will happen to the waste? This is a serious concern. So, if you develop an idea that you may recycle that waste, this is a novel idea. Because nobody talks about this idea. US में The number of vehicles are very limited. But यहाँ it is huge. दिल्ली जैसे शहर में we see around 50 lakh to 80 lakh vehicles. Lucknow maybe I don't have the exact data, but hypothetically I can say that 10 lakh तो हो गई. अब उसमें से अगर 2% भी अगर e-vehicles हैं, तो you know what may be the repercussion. It's a very serious kind of a repercussion. So, you know that idea becomes an important story. क्योंकि वो जो उत्सर्जन हो रहा है एमिशन, उसको कंट्रोल करने के लिए इंटेलेक्चुअल प्रॉपर्टी का बहुत बड़ा रोल है, and we will have to work on that particular on a very serious note. So, if you have a narrow claim, you may never be able to justify. But you have a broader claim, it will always be justified. So this is something that will have larger interest of the society will have to be fulfilled. Now, there is always a debate that let me first publish. I'll be the first one to publish. But there is a lot of disbelief in this. There is a fallacy. You do not provide a solution. You do not provide solution in your communication. But you say that I am the first one to talk about it. No doubt that you talk about it firstly. No doubt. But whether you have given solution, you are the first one to talk about it. No doubt about it. Sorry. No doubt about it. But have you given the solution? This is the key. And the golden rule is that patent first, publish later. What people are doing at this point of time is they are publishing it first. publish कर दिया, अगर कोई आइडिया था तो in public. So what is the point? So this is something which we have to keep in mind. You know, supposedly a research team published a paper on their purification mechanism before filing, then the outcome is very it is inevitable. The patent was rejected. It could be far better that first of all you put these deliberations in your lab, file for the patent. The moment you are granted, publish it. This is the best strategy. This is a golden rule with regard to this particular thing. Now, software challenges. It is also a very serious kind of an issue at this point of time when we talk about the intellectual property laws and specifically patenting. You know, there are a lot of algorithms per se, and there is a lot of debate on algorithms. I am not a very technical person, so I do not know about algorithms. But what I understood is there is a lot of technicality in it. Why? Because every algorithm is not same. If you have some kind of a newness in it, which is proved. So the solution is that hardware interactions with data flow is an essence. So you will have to understand that the more you talk about qualitative hardware, the more you talk about qualitative software and connection within the system, there will be a quality output. And that is something which is a very important kind of a criteria. Indian tech companies, you know, this is a very important case. Initially rejected for software claims. क्योंकि उसमें कुछ नया नहीं है, सोल्यूशन नहीं है. सिर्फ यू नो आप ऐसे कर रहे हैं, चश्मे का नंबर थोड़ा पॉइंट में आपने इधर उधर कर दिया और आपने कहा ये चश्मा नया है सर, आपका चेंज हो गया पूरा. यू नो यू विल हैव टू चेंज. आपको प्रोग्रेसिव लेंस लेने पड़ेंगे, थोड़ा बदलेगा. जाते हैं ना चश्मे वाले की दुकान में, तो वो जाके कहता नहीं सर ये बदलेगा, ये काम नहीं कर रहा, आपका नंबर बढ़ गया. बट इन योर वे, तो व्हाट यू आस्क इज there is nothing like that. So, I mean, technical specifications are very, very important for the purpose of this particular context. Now, these are certain checklists which are very, very essential. I have already discussed almost all of them and my previous speaker has also talked about them. So I already told you that there will be no repetition, so I will stick to my idea. So, but when I read this line, this is something which is very important. I find this line very interesting. That failures in patenting are rarely due to lack of ideas. They arise from lack of awareness, strategy, and procedural discipline. No, this is the key. When you don't have the procedural discipline, what you do is बिना आइडिया के ग्रोथ के आपने पब्लिश कर दिया, 5 लोगों की टीम है, आपने कहा हमें तो स्कोपस इंडेक्स चाहिए प्रमोशन. Universities are facing this problem. I used to visit so many places across India. People are just, publishing it at any cost. What is the usage for? It is a matter of concern. God knows. Strategy and awareness. Whether you are aware of what you are producing, nobody is aware of the consequence. पता ही नहीं है आपको, आप क्या कर रहे हैं. आपने बस जल्दबाजी में कर दिया, उसके बाद आपको पता चलो वो भी तो करना नहीं था, ये तो बाद में था, अब हमारा पेटेंट गया. So, this is something. तो और साथ में you will have to understand what commercial output you will produce. This is something which is essential. So if you ignore commercial potential, there is no usage. And hence, I believe that when you talk about the patent and patentability, you will have to first check that your idea must fulfill these green flags, and you will have to keep in mind that you will have to avoid the red flags, which I put it in my slide. This is something which is important. Now, potentially, why you are creating an intellectual property domain? You are creating it for the competition in the market. This is all about newness. हमने monopoly से competition की तरफ आए. We had the Monopolistic and Restricted Trade Practices Act 1969. But there is a lot of things which are going in the market, and that was unfair trade agreements and restricted trade agreements. Later on, we find that there is a new kind of issue, and that was the abuse of dominance, anti-competitive agreements, and a lot of cartelization in the market. Now, when you see all these things, that there is a lot of cartel in the market, तो क्या हुआ कि सीमेंट की 12-14 कंपनियों ने मिलकर डिसाइड कर लिया प्राइस क्या होगा, बाकी कंपनियों बेचारे थे वो. एक टेलीकॉम कंपनी ने कहा 2 साल तक फ्री इंटरनेट और बाकी की कंपनीज. Now you have to understand this. So competition is the essence. The more competition you will have, the more qualitative product you will produce. This is the key. This is the idea behind intellectual property domain. So, commercialization, ultimate goal is commercialization. As I already told you that, somebody said, let's create a highway. We will have to just cut 1,000 trees. But we'll pass through easily. We'll have a speed of 100 km per hour, 120, 30, Australia में 200, China में 180. This is how you go. My God. Now the problem is, you commercialize everything and you do a lot of carbon emission. And you say there is a development. So everything is for the economics. Everything is for the commercialization. तो आपने डेवलपिंग कंट्रीज को कहा कि आप तो कुछ प्रोडक्शन कर नहीं पा रहे हैं, लेकिन हमारे पास बहुत फैक्ट्रीज हैं, हम आपसे कार्बन ट्रेडिंग कर लेते हैं. आपने कार्बन ट्रेडिंग एक नया फिनोमेना तो डेवलप कर लिया, बट एट द कॉस्ट ऑफ व्हाट? हुआ क्या? एमिशन तो जस्ट का तस है. Nothing has changed. Instead of doing carbon trade, if you would have developed intellectual property domain and develop an idea intention that, you will produce quality kind of inventions for the development which is not a development but it is a sustainable development. Then only, the whole purpose will be true. You can develop any number of startups, but unless and until the solution is not there with the startups, there is no usage to these startups. आपने स्टार्टअप शुरू किया 2 साल में बंद हो गया, 6 महीने में बंद हो गया, 10 महीने में 1 साल में बंद हो गया. What is the usage? So the most important thing is that you will have to develop credibility, and credibility can only be developed when you talk in reality, not in hallucination. Everybody wants to talk in hallucination, nobody wants to talk about the reality. And the whole of the world is running for the development at the cost of human life. This is what is happening. So intellectual property needs to focus on commercialization, keeping in mind less harm to the society. Keeping in mind the ecological balance. This is something which is important. Now, stakeholders who will be benefited from this kind of discussions, who will be benefited from the patentability? Students, you will have a team tomorrow, they will do MTech or MSc, then PhD, they will develop a new device. Who will be benefited? It is the student. He will get scholarships, he will get potential, environment, and that is how he may produce qualitative products with his supervisor or somebody else in the group. Employability will increase. That is it. Academic output, this is a key. So you produce good papers with solutions, and that is how you do qualitative kind of development. Now, students, faculty, when they combine together, the institution will grow. You will have more patents, you will have more solutions, so you will get more placements. So more companies will come to your institution. That look, this is an institution which is producing very quality papers, very quality solutions. And then ultimately, Atmanirbhar Bharat, the key. So you have to understand there is a chain from students to faculty to institution to niche, and this is how we grow. Self-reliant India, which is a domain which we need to work on, and that can only be achieved when the student, faculty, institution combine together for the holistic intellectual development. Now, there is a lot of change going on in the 21st century. Technological advancement. So, from law to opportunity. Now, the problem with patent is bureaucratic hurdles and formalities. Now, if you talk of innovative policies, it is better off that you must control these bureaucratic channels and make such policies which do have less red tapeism, so that a qualitative kind of environment may be available for filing patents in a longer course. So this is all I have. Thank you so much for your patience hearing. And I do not know whether I am able to, convey my idea, but still, I tried my level best. Thank you so much. I'm deeply honored. Thank you.
Thank you so much, sir. That was very indeed enlightening and now I would like to call upon the stage Dr. Abhay Prakash Srivastava sir on the stage For his keynote, he is an 18 years experience associate professor with 53 SCI publications and 4 patents. He has also been awarded as a Young Scientist Award by Scientific Reports. In the huge round of welcome, please put your hands together and welcome Dr. Abhay Prakash Srivastava, sir.
Good afternoon. Welcome all dignitaries present here for this organized program and respected directors of Goel Group of Education. I want to discuss all the dignitaries are always also discussed about the patent, how can you file patent, but the reason being behind this is how can you search novelty, research gap, and how ideas are new ideas that beneficial for the society. तो इसको लेकर मैं आपसे three papers are discussed here. 3 research papers that are selected for the Oxford University for the 1,000 scientists in this field, that is called density functional theory. The first papers in this PPT, you can see atomic level design of the TiO2 for instance lithium storage density functional theory approach. In this paper, you can see that there is a new functional material designed by me for enhancing the storage capacity of the lithium and battery. In such way, we have those multiple metallic elements in the lithium and TiO2 carbon dioxide for enhancing the capacity of the device, storage device. In this paper, you can see how can find novelty. In recent years, the lithium ion battery only store 320 mAh power per gram. This is the drawback for the electrical vehicle as well as in which we can use lithium-ion battery. If by some means we can enhance the capacity of lithium-ion battery, then this becomes a new idea and this will be beneficial for the society. In this PPT paper, this is the atomic level design. This is testing TiO2 without dope. This is doping by the molybdenum and this is doped by the molybdenum. 3 structures you can see in the PPT. First question that having a storage capacity 320 mAh per gram. But after doping the vanadium, we enhance this property 455 mAh per gram, and after that we do vanadium into this paper and we can find 620, that is increased by 84%. Increased by 84%, this is a big deal.
There is a small announcement for all the faculty members who are going by bus that the college bus will leave at 5, so there is no rush. This is to inform all the faculty members who are going by the college transport that the bus will leave at 5.
After doping the vanadium, the capacity of the lithium-ion battery enhanced by 84%. This is the beginning for the electrical vehicle and novel challenges that are present in the electrical vehicle cases, mobile and other utilized that lithium-ion battery. This paper is published in the Japan Chemical Society and taken as a award winning from the Oxford University. तो सबसे बड़ी बात ये है कि हम रिसर्च गैप कैसे ढूंढे, कहाँ से पाए या कुछ क्या नया कर सकते हैं। सबसे पहले आपको प्रॉब्लम ढूंढनी है। क्या प्रॉब्लम अभी भी प्रॉब्लम बनी हुई है कि इलेक्ट्रिकल व्हीकल्स अगर आप बहुत लॉन्ग डिस्टेंस तक चलते हो तो देयर इज मतलब प्रॉब्लम ऑफ चार्जिंग एंड माइलेज।
mileage must be 2 to 400 kilometers per charging. If we can enhance by some means, the storage capacity of battery, then that mileage will be 800 to 1000. In this paper, we are enhanced the capacity of lithium battery that will be 620 mAh per gram. That saves the lithium material also, because that is also called white gold, very costly. And by the working of molybdenum, this is enhanced capacity. So this is mobility. Now after that, to scope of this history, if by the defect engineering, that capacity also increase in future 4200 mAh per gram. Thank you for that.
Thank you so much, Abhay sir. That was indeed very enlightening. Now I would like to call upon the stage a very dynamic personality, Head of Department Management, Dr. Jyoti Agarwal. She has been working as the Head of Department since last 8 years at GITM with an experience of 15 years in management. Please put your hands together and welcome Dr. Jyoti Agarwal.
Very good evening to all the dignitaries present here and my dear students. I am thankful to our director sir who has given us this privilege that we are today having a discussion on IPR. And we are discussing IPR. And if I want to say anything about IPR, it will be just like giving a shine to the sun. Because since morning we are hearing so much about IPR that I am 100% sure that our young faculty and our students must have got a lot of enlightenment about IPR. As we all know, like if we are having a small property, we just get it registered. So if we are having an idea, it should also be registered, and that all come under the IPR. I would like to let you know that AKTU is also working on it. We have added a subject called mini project from last 2 years. And what is the basic idea behind it? Those young ideas which are being developed by our students, which were not being registered anywhere. Earlier, what is done? All those ideas were files were being made, and then all are deposited somewhere. But that young idea is not being showcased anywhere. So what AKTU has done? They have developed 50 portal ID, and we all are submitting those ideas which are being developed by our students on those on that 50 portal ID. And if I'm having 215 students right now in the first year, so out of 215 ideas, maybe there are 10 to 15 ideas which can be developed, which can be taken to prototype, and which can be give benefit to us. So for that, it is very important that we should know that if we are having an idea, it is required to be filed somewhere. We need to patent it. We need to get it registered. We need to get it copyrighted. Unless and until we are aware about it and we are doing such kind of things, might be that idea is being copied by someone else. Someone else is being getting benefited of get out the benefits out of that idea. So it is very important that we all should be aware of what intellectual property rights are, how we can get it patented, how we can get it copyright, how we can preserve idea, and not only this we are benefited, but we can monetize also. We can get the brand value, we can get the reputation, everything we can do. And that is the reason not only AKTU, each and everyone is working on that we all should have that creative idea. With due respect to our team I request all of you to get up and welcome them. Please be seated. So that is the reason. At last, please maintain discipline and settle down. So what I was saying was that you are saying about IPR. The reason why it is so important. All of you, please get up and welcome. We are happy that Chairman sir is also with us.
A very huge round of applause. Please welcome our chief guest. Can you have a huge round of applause for our chairman, sir?
IPR improves professional reputation, supports research growth, helps in career promotion, encourages innovation in teaching, prevents plagiarism, supports collaboration, helps in institutional development, legal protection, and boosts confidence. I am sure that many of us have been benefited by today's workshop, and that is the reason why we have organized this workshop. So that young minds should get an idea, and not only get an idea, they should know where they should find their idea, so that idea should not be copied by someone else. As we all know that when idea is only created when we identify the problem. A very our peers are saying that one-time use plastic is to be banned. And when we used to have fruity and all, we all must be knowing that, and that plastic straw was there. So our problem was identified, and then we came with the solution that rather than using that one-time use plastic straw pipe, we are having the paper straw. So if you are identifying the problems, as we all know that agriculture, Indians are predominant in agriculture. But rather than having the dominance in agriculture, in spite we are using the working for AI and all. But if we are working for our agriculture, then we can be benefited, we can develop many ideas by which not only our production cultivation can be increased, but we can go for the production also increase, the crop cultivation can also be increased, the seeding also can be increased. So this is the way, if we are working on different ideas and we are getting it patented, we all can be benefited. Thank you so much.
Thank you so much, ma'am. It was indeed very inspiring. Now, we will move forward to welcome our guest of honors, representing the sapling as a token of welcome and respect. I would like to invite Dr. Brijesh Pandey, Director GITM, to present the token of gratitude and welcome our guest of honor, our respected and honorable Chairman, Sir, Engineer Mahesh Agarwal, sir. Please put your hands together and welcome our Chairman, sir.
Now I request Director Sir to present a token of gratitude to Professor Anurag Tripathi Sir.
A huge round of applause and welcome our guest of honor, Professor Anurag Tripathi Sir, Dean UGC CSTUP Lucknow. Now I request our Honorable Chairman Sir to present the token and welcome Mr. Mardeep Singh Sir, Chief Executive Officer, Innovation Hub, AKTU. A huge round of applause for our guests. start with the validating session of this IPR workshop, I would like to call upon the stage Professor Dr. Brijesh Pandey, sir, Director GITM, to please come upon the stage and welcome our guests. A huge round of applause for Dr. Brijesh Pandey, sir, Director GITM.
Good evening, everybody. Respected dignitaries, directors, HODs, as I have told you that in the morning, that the small minds always talks about the people, but the great minds always talks about the innovative ideas. And you have seen 5 different great peoples here, as well as some of the guest of honor, chief guests from the CSTUP. And now in the conclusion, we are again having some more great minds here in our sessions. So first of all, as the director of the institute, I humbly welcome Dr. Anurag Tripathi sir, the Dean UG from the AKTU, as well as the Professor IIT Engineering College, as well as, you know it, when we are saying about the idea, you have doing the IPR workshop for patenting and transfer, technology transfer. No better person can be here as our guest of honor, the CEO of the Innovation Hub, Mr. Mahesh Singh sir, from the AKTU, as well as the source of the inspiration, new constructions, new belongings, new groups, as well as inspiring everybody of us, not only me, all the directors, all the faculties, and for my dear students. He has done a lot of hard work from since 2008, and now we are coming here with a lot of achievements. Our respected Honorable Chairman, sir. Right. So these 3 people who have joined here enriches us in the conclusion of this workshop, IPR workshop. And not taking much of your time because you are sitting here since 10 of morning. Only half an hour break was there for the lunch. And now it is about to having the 4:30. Seeing the discipline of the students, seeing the discipline of the faculty, I know that with the help of these 5 intellectual lectures, as well as the inspirational words of everyone, you have now came up to the mind that you will be converting all the ideas into patent. Many of the patents are now floating in the GITM as well as in the Goel group of institutions. We are having the MBA. You may be glad to know that we are having the MBA in the pharmacy in the second times also. And I think that no other college in the whole UP is having that achievements in 6 years. We are having the MBA in our GITM in the Computer Science Engineering Department, as well as we are having the NAC in the GITM here. So every time of you see, we are having 3 times, 4 times we are having the 4-star rating in the Institute Innovation Council. And this time also we will be getting the 4-star rating. I am very confident for it. I have taken you to our new skill development cell. This is all because of our respected chairman, sir. What a good Blue Star Center of Excellence, what a skill development center, training placement, other things I have shown to you. So this is how we want your blessings so that we can give more type of achievements. So, not taking much of your time, I again welcome all of you here, all the directors here who have made all my day throughout very humbly. Thank you very much for here. Thank you.
Thank you so much, sir.
Now, we invite our respected guest of honor, Mr. Mahesh Singh sir, Chief Executive of Innovation Hub AKTU. So please give a huge round of applause for Mahesh Singh sir.
Thank you. Honorable Chairman, Goel Institute of Technology and Management, Lucknow. Professor Anurag Tripathi sir, PUG, also my boss. Dr. Brijesh Pandey sir, a very talented and very energetic director. अभी आपने दिखाया कि we have a very good skill center here. जो आप लोग अभी बना रहे हैं बहुत प्यारा सा skill center. So sir, it shows your vision. I must congratulate you for this vision, which is in the benefit of the student. And I'm sure that the leadership, entire leadership, what you have, will bring this institution from a certain level to higher level. So congratulations once again all the faculty members sitting here since morning, all the students. Good evening everyone. कैसे दोस्तों पीछे ना हो? Very good, very good. So IPR session में you must have heard lot of things since the morning. How to find the IPR? I'm sure there would be lot of patent attorneys also who told how to go for the IPR. What are the legal process, legal language, how to write the IPR, especially for the patent, because patent is more relevant to you and it has been my core area and very dear to my heart. Because 5 मिनट बोलूंगा, थोड़ा सा आवाज अगर कम आएगी मुझे अच्छा लगेगा. मुझे पता है 5 बजने वाला है तो ज्यादा टाइम नहीं है. So thank you for attention. बहुत छोटी सी स्टोरी है. एक बार सुबह मेरे साथ भी एक घटना हुई. हमारे यहाँ एक काम करने वाली दीदी आती है मेड, उनको एक कुत्ते ने काट लिया सुबह. मुझे नहीं पता कि कुत्तों को क्या ऐसी दिक्कत होती है काम करने वाले लोगों के साथ. कैंपस में 4-5 कुत्ते हैं, ठीक. अब मैं सर्च करने लगे इसका तरीका क्या है. जब मैंने बाकी लोगों से पता किया, I found that this incident has happened number of times in the campus. Why it's happening is a different story, but how can we protect them? तो ये हमने जब सोचना शुरू किया, and I spoke to lot of people, lot of stakeholders. What I found that there are certain symptoms of the dogs. आपको शायद ना पता चलता होगा, लेकिन अगर आप किसी कुत्ते को सामने से देखते हो, अपने पेट को अगर सामने से देखते हो, तो आप अगर बहुत माइन्यूटली ऑब्जर्व करो तो आपको पता होगा कि इस टाइम उसके बेस्ड ऑन हिज एक्शन एंड नंबर ऑफ अदर मोमेंट्स व्हाट एग्जैक्टली ही इज थिंकिंग इन हिज माइंड. हम सबके लिए वो थोड़ा टफ है बिकॉज़ वी डोंट हैव द पेट. बट जिन लोगों के पास है वो लोग समझ पाते हैं, बट नॉट एवरीवन इज हैविंग पेट, और सबके दोस्त नहीं है वो. तो अब इसका सलूशन कैसे निकला आप ये समझो. एक स्टार्टअप जिसने इतना बढ़िया काम किया, उसने क्या किया कि एक डिवाइस बनाई छोटी सी, एंड बेस्ड ऑन द आई मूवमेंट, बेस्ड ऑन द ईयर ओरिएंटेशन एंड बेस्ड ऑन द टेल, एआई लगा के उसने उस डिवाइस के थ्रू डॉग से कम्युनिकेट करना शुरू किया. सोचो कितनी बड़ी प्रॉब्लम को सॉल्व कर दिया, राइट. सो वो एक छोटा डिवाइस जो कि सिर्फ 700-800 रुपए का है, उससे आप अपने पेट से कम्युनिकेट कर सकते हो कि व्हाट एग्जैक्टली ही इज थिंकिंग राइट नाउ. भूखा है, बाहर जाना है, घूमना है, सोना है, थका हुआ है, इरिटेट हो रहा है, वो सारी चीजें आप पता कर सकते हो. ठीक. मैं इस कहानी के माध्यम से आपको क्या बताना चाह रहा हूं कि IPR फाइल कैसे करना है वो तो आप सबने देख लिया. लॉट ऑफ इंफॉर्मेशन इज अवेलेबल ऑन द इंटरनेट आल्सो. पेटेंट अटॉर्नीज आके, आई एम श्योर IPR सेल आपके यहाँ होगा, वो बताएंगे आपको IPR फाइल कैसे करना है. पर IPR किस चीज पे फाइल करना है, पेटेंट किस चीज पे फाइल करना है, ये ज्यादा इंपॉर्टेंट है. अगर आपके पास आइडिया नहीं होगा, कंटेंट नहीं होगा, तो आप पेटेंट किस चीज पे करोगे. एंड बिलीव मी, इट क्रिएट्स अ बिग डिफरेंस बिकॉज़ इट इज अ पार्ट ऑफ एंटरप्रेन्योरशिप. अगर आप अपने फर्स्ट ईयर, सेकंड ईयर, थर्ड ईयर तक भी चल के 1-2 पेटेंट अपने नाम पे कर लेते हो, देन इट विल मेक अ रियल डिफरेंस. मतलब यू नीड नॉट टू प्रूव योरसेल्फ इन फ्रंट ऑफ द इन्वेस्टर और इन फ्रंट ऑफ द जॉब गिवर्स, इंटरव्यू पैनल दैट यू आर टेक्निकली साउंड. उसके बाद आपको जो पूछना पूछो. और एक चीज, जब आप इंटरव्यू के लिए बैठते हो कभी भी, तो आपके पास बहुत गिने चुने लिमिटेड चीजें होती हैं जिसमें इंटरव्यूअर खेलता आपके साथ. लाइक इंटर्नशिप आपने कहां पे की है, दैट इज फर्स्ट थिंग. प्रोजेक्ट आपने कौन सा किया है, माइनर, मेजर प्रोजेक्ट आपने कौन सा किया है, और एक्स्ट्रा आपने क्या किया है टेक्नोलॉजी के एरिया में. और अगर आपने वो सब चीजें अपने आप नहीं की हैं तो फिर वो आएगा फर्दर कोर्स पे। लेकिन अगर आपने सच में ये दिखाया है कि हाउ टू इंप्लीमेंट द टेक्नोलॉजी एंड हाउ टू इंप्लीमेंट व्हाट यू हैव लर्न फॉर द इयर्स, देन आप उसको उसी के चारों तरफ उसी के इर्द गिर्द आप मूव करवा सकते हो। पेटेंट उनमें से एक, अगर आप बोलते हैं आपके पास पेटेंट है तो देयर इज अ फेयर पॉसिबिलिटी दैट द पर्सन सिटिंग इन फ्रंट ऑफ यू इज नॉट हैविंग एनी पेटेंट, पर आपके पास है, राइट? सो ऐसे ही एक छोटी सी बात हो, तरुण और स्वप्निल, दो लड़के, उन्होंने फाइनल ईयर प्रोजेक्ट अपना शुरू किया, आपकी तरह थे बिल्कुल। थर्ड ईयर से शुरुआत की, फाइनल ईयर तक आते आते उन्होंने बोला कुछ करते हैं, उन्होंने बोला क्या करें, उन्होंने बोला काम करते हैं, हम एक साइकिल बनाते हैं, उसको मोटर लगा देते हैं, कुछ नहीं करते। मैं बात कर रहा हूँ 2008 की। तो उन्हें साइकिल में मोटर लगा के मोटराइज साइकिल बनाते। उस टाइम पे इलेक्ट्रिक व्हीकल्स बहुत पॉपुलर नहीं हुआ करती थी। मोटराइज साइकिल उन्होंने बना दी। मोटराइज साइकिल बना के उन्होंने फाइनल ईयर तक आते आते अपने कैंपस में 5 लोगों को भेज दिया 2,000 रुपए में। कुछ खास इनोवेशन नहीं किया उन्होंने, पर वहां एक पॉइंट ऐसा आया जहां की उनकी समझ में आया कि हम कुछ कर सकते हैं, वी कैन क्रिएट रेवेन्यू आउट ऑफ आवर नॉलेज एंड स्किल। फिर उन्होंने पूछा कि भाई आप लोगों को और क्या नीड है अपने कलीग से। कलीग ने बोला भाई हमें साइकिल तो नहीं चाहिए जो कि 20 की स्पीड में चलती हो, हमें थोड़ी हाई स्पीड में चलने वाली अगर कोई बाइक आप बना दो तो हमारे लिए ज्यादा अच्छा होगा। उन्होंने बोला कैसे करें? बोला दो ही तरीका है, या तो आप मोटर की पावर को बढ़ा दो या तो आप ओवरऑल वेट को लाइट कर दो। उन्होंने कंपोजिट मटेरियल यूज करके वेट को लाइट कर दिया। ठीक, फिर भी मजा नहीं आया। फिर बोले अब क्या करें? बोला हब से निकाल के उसको सेंट्रल मोटर लगा के डिजाइन करो ताकि स्पीड भी ज्यादा हो जाए। उन्हें स्पीड भी ज्यादा कर लिया। बोले अब क्या करें? अभी भी अच्छा नहीं लग रहा है। ये करते करते 2012 आ गया। 2012 के बाद यूथ से उन्होंने जब इंटरेक्ट किया, यूथ ने बोला हमें तो स्पीड और ज्यादा चाहिए, इतने में मजा नहीं आता हमें तो 80-90 की स्पीड चाहिए। उन्होंने बोला ठीक है काम करते हैं, इसमें हम 5 किलोवाट की मोटर लगाते हैं, लिथियम आयन बैटरी लगाते हैं, लिथियम फेरोफॉस्फेट प्रिसाइजली LFP बैटरी लगाते हैं, इसको IoT बनाते हैं। IoT बनाते बनाते करते करते अगले 4 साल में उन्होंने एक बाइक लॉन्च कर दी जिसका नाम है एथर एनर्जी। आपने सुना? ठीक है, उसके जो मेंटर है मुस्तफा वाजिद और हमारे जो मेंटर हैं वो दोनों सेम ही है, इसलिए मैं इतना क्लोजली उन लोगों को जानता हूँ, मल्टीपल टाइम मिल चुका हूँ उनसे। तो उस एथर एनर्जी पे जो पावर ट्रांसमिशन है उस पे एक पेटेंट, IoT का जो उन्होंने IoT का वो इंटरफेस जो यूज किया है उस पे दूसरा पेटेंट, उन्होंने जो पावर ट्रांसमिशन के लिए गियर डिजाइन पुली डिजाइन किया है उस पे तीसरा पेटेंट। कुल मिला के उनके पास 11 पेटेंट्स हैं। और ये एकदम से नहीं शुरू किया उन्होंने, वो जब उन्हें लाइट वेट करना शुरू किया पेटेंट ने तब से डालना शुरू कर दिया। स्टोरी के थ्रू मैं ये बताने की कोशिश कर रहा हूँ पेटेंट कोई रॉकेट साइंस नहीं है, इट्स जस्ट ऑब्जर्वेशन। आप ऑब्जर्व करो अपने चारों तरफ क्या चीज आपको ज्यादा पेनफुल लगती हो और मल्टीपल टाइम वो रिपीट हो रही हो प्रॉब्लम, वहां पेटेंट का स्कोप है। ठीक, अच्छा, ऐसी सारी चीजों को सपोर्ट करने के लिए हमारे पास फ्री ऑफ कॉस्ट पेटेंट सेंटर है, व्हिच इज विद द नेम ऑफ कलाम पेटेंट सेंटर, which was recently launched, where we provide free of cost patent facility because all the facility available across the state, across the country is on reimbursed mode. Means if you are done with the patent once, based on your papers, you will be reimbursed. That too the filing cost, including 4,000 और रुपए जो कि प्रोफेशनल कॉस्ट है। ठीक, उसके बाद भी बहुत सारी चीजें, बहुत सारे स्टेप्स और इन्वॉल्व है। सुबह से आपने सीखा होगा, इसके बाद हम अर्ली पब्लिकेशन पे जाते हैं, फिर हम FER पे जाते हैं, फिर हो सकता है हियरिंग पे जाना पड़े, फिर पेटेंट को प्रोटेक्ट करना पड़ता है ग्रांट होने के बाद। तो बहुत सारे स्टेप्स हैं, ऑल टुगेदर अराउंड 50,000 इज टोटल कॉस्ट अगर हम प्रोफेशनल के थ्रू जाते हैं तो हम वो पूरा कॉस्ट बेयर करते हैं, दैट फ्री ऑफ कॉस्ट। वी डोंट चार्ज इवन अ सिंगल पेनी फ्रॉम द स्टूडेंट, वी डोंट चार्ज इवन अ सिंगल परसेंट ऑफ इक्विटी फ्रॉम द स्टूडेंट्स। आप आइए, पेटेंट करवाइए अपने इंस्टीट्यूशन के नाम, एंड दिस इज वैलिड फॉर आवर फैकल्टी मेंबर्स आल्सो, दे कैन आल्सो कम टू अस एंड गेट डन विद द पेटेंट। वो हम करवाएंगे आपका फ्री ऑफ कॉस्ट, यूनिवर्सिटी की तरफ से ये फैसिलिटी है। ठीक, चूंकि मैं एंटरप्रेन्योरशिप बैकग्राउंड से आता हूं, इसलिए बताना मेरे लिए जरूरी है कि हमारे पास एक स्कीम भी आपके लिए कि अगर ऐसा कोई आइडिया आपके दिमाग में क्लिक करता हो तो उस आइडिया के बेसिस पे हम आपको अपनी एक पॉलिसी के तहत 1 लाख रुपए भी दे सकते हैं। सिर्फ आइडिया, आपको रजिस्ट्रेशन कहीं नहीं करवाना है। आपका आइडिया अगर आपके दिमाग में है तो आप हमसे 1 लाख रुपए ले जाइए, आइडिया प्रोटोटाइप पे काम कीजिए और हमें यूसी सबमिट कर दीजिए। ठीक, गवर्नमेंट ऑफ यूपी की भी बहुत सारी ग्रांट्स हैं। अच्छा, तो आइडिया पे अगर आप अपना रजिस्ट्रेशन करवा के अपना स्टार्टअप शुरू करते हैं तो गवर्नमेंट ऑफ यूपी आपको 15 लाख का और ग्रांट देती है। ग्रांट मींस एक बार पैसा दे दिया वापस नहीं करना, उसके अगेंस्ट में आपको यूसी सबमिट कर दीजिए। तो 15 लाख का और भी ग्रांट मिलता है आपको अगर आप किसी आइडिया पर काम करते हैं तो कुल मिला जुला के गवर्नमेंट का बहुत सारा सपोर्ट है, सेंट्रल गवर्नमेंट का बहुत सारा सपोर्ट है, स्टेट गवर्नमेंट का बहुत सारा सपोर्ट है। ओनली पॉइंट इज यू हैव टू कम अप विद द आइडिया। We are seeking to support throughout, right? So let's begin this innovation journey, let's begin this entrepreneurship journey together, and with this belief that out of so many students, around 300, 400 students sitting here, at least 10%, 10%, 15% should be the hit rate. इतने students आप में से आए, निकल के पेटेंट करवाने के लिए, इनोवेशन करवाने के लिए, स्टार्टअप शुरू करने के लिए, with this expectation, I just stop myself here. Thank you so much for listening.
Thank you so much, sir. Before we proceed, I would like to summarize the first session of this workshop so that we can put forward a glimpse at what we have done in this workshop since morning. The workshop started with the lamplighting and the traditional values of our India. Next, we move forward with our introduction about the workshop. Then we had Dr. Pooja Yadav ma'am, Joint Director of Council of Science and Technology Uttar Pradesh, as our guest. We also had Sri Ravi Rao sir, Joint Director of Council of Science and Technology Uttar Pradesh, as our chief guest. Moving towards our guest of honor, we had Professor Kuldeep Sahai sir, Director RUC Basti UP. We also had a guest of honor, Professor Arun Kumar Tiwari sir, who is working as a Dean, Faculty of Engineering and Technology, GITM Lucknow. We also had a guest of honor, Professor Anil Sharma sir. He is working as a Dean in Research and Development in Industry Consultancy, GITM Lucknow. We had many key speakers, starting with Dr. Arun Kumar Singh. He is an associate professor in Rajkir Engineering College, Kannauj. Dr. Arun Kumar Singh talked about the intellectual property rights in a very clear way. He explained the meaning of IPR, why it is important for students and researchers. He mainly focused on patent and how they help in protecting new innovations. He told us that when we create something new, we should register it so that no one can copy it. He also explained which idea cannot be patented and what are the rules for that. Secondly, we have Colonel Dr. Sameer Mishra sir. He is working as an executive director, Lucknow Management Association. Colonel Dr. Sameer Mishra sir gave us a very interesting and motivating talk. He explained management, branding, and copyright in a very simple language. He used daily life examples from market and shops so that students can understand easily. He told us how companies build their brand names and protect it. He also shared his personal story from his time in the military. His story was very inspiring and motivating for the students. He told the students to build confidence and be strong. Next we have Mr. Abhay Dwivedi sir. He is working as a patent agent and assistant professor in Modi University, Rajasthan. Mr. Abhay Dwivedi sir talked about patents and how to file them. He explained everything step by step in a very easy way. He gave simple examples so that students could understand better. He told us the difference between inventor and an applicant. He also shared real-life stories about people who have protected their ideas. He explained how important documents are for patent filing. He told students that every good idea should have legally patent. He talked about the various laws and the aspects of patent filing. He motivated students to learn about law and procedures. His section was very useful for the students who want to work in research and innovation. Fourth, we have Dr. Om Prakash Sir, Director. He spoke about the law and the nature of intellectual property right. He explained the meaning of tangible and intangible rights in simple words. He told about ownership of inventions and getting legal rights. He shared stories of people who lost their rights because they didn't know about the law. He explained the importance of case laws related to patent. He also talked about how humans develop and grow in old time and talked about artificial intelligence. He encouraged students to learn legal laws carefully. He said that legal knowledge protects our future. His session helped students understand the importance of law in innovation. Moving forward, we had our last key person, Professor Dr. Varun, Professor at Faculty of Law, University of Lucknow. Sir talked about turning ideas into valuable assets. He explained how a small idea can give big achievements. He focused on idea generation and creativity. He said that every idea must be new and original. He encouraged students to always try, even if they fail. He said that success comes from continuous effort. He also talked about uniqueness and development of ideas. He motivated students to work hard and never give up. He told students to believe in themselves, and his session was inspiring to think differently and grow in life. All total, the intellectual property right workshop was very informative and useful for all the students and participants. The speaker explained patents, copyright, trademarks, and law in very simple and easy way. They motivated students to protect their ideas and work in an honest and an ethical way. The session helped everybody of us telling the importance of creativity, discipline, and legal knowledge related to IPR. Overall, the workshop was inspiring to students and they become very confident, responsible, and successful innovators. That was all about the first session that we have conducted before and the key speakers we had today with us.
We now invite our respected guest of honor, Professor Anurag Tripathi Sir, Dean, UGSC APTU Lucknow, to kindly share his valuable words with us. Sir is known for his strong contribution towards academic development and quality education. So give a huge round of applause for Sir.
Please put your hands together and welcome Professor Anurag Tripathi Sir.
A very good evening to all of you. Respected Chairman, Goel Group of Institutions, Shri Brijesh Agrawal ji, Director, GITM, Dr. Rishi Asthana ji, my dear friend, Mr. Mahib Singh, Chief Executive Officer, Innovation Hub, Uttar Pradesh, Dr. APJ Abdul Kalam Technical University, Lucknow. Distinguished resource persons, respected faculty members, dear researchers and students. As we conclude the one-day workshop on intellectual property rights, sponsored by the Council of Science and Technology, Uttar Pradesh, and organized by the Department of Computer Science and Engineering, Goel Institute of Technology and Management, Lucknow, I express my sincere appreciation to the Institute for organizing this timely and meaningful program. Under the able leadership of Dr. Rishi Asthana, an academician with over 25 years of academic experience, the Institute has consistently promoted research, innovation, and academic excellence. The theme of today's workshop aligns well with the vision of AICTE, particularly its focus on research, IPR, startups, and industry collaboration. In today's academic environment, research, innovation, and IPR go hand in hand. National frameworks such as the National Education Policy 2020, NAC, NBA, NIRF, and the National IPR Policy emphasize outcome-based research, patenting, technology transfer, and societal impact, all of which were effectively addressed during this workshop. The deliberations reinforce the need to move beyond publications towards patents and commercialization, as Mahirji very well explained, while ensuring ethical, original, and impactful research. I sincerely thank the resource persons, the organizing committee, and all participants for their valuable contributions. I am confident that this workshop will serve as a catalyst for protected innovation and quality research. With these words, I declare the workshop successfully concluded. Thanks. Jai Hind.
Thank you so much, sir. Now, it is a proud privilege to warmly welcome the respected Chairman, sir, of Goel Group of Institution, Engineer Mahesh Kumar Goel, sir. Your visionary leadership and constant support have been a guiding light for our institution. We truly honored by your esteemed presence on this occasion. With great respect, we now invite you on the stage to bless us with your inspiring and valuable words. Please, with your huge round of applause, I would like to invite on stage Chairman PCI, Engineer Mahesh Goel, sir.
Very good evening. Good evening to all my respected persons, especially from AKTU and all the speakers and the person who came from to attend this workshop. I am very thankful and thanks from bottom of my heart. I especially welcome Dr. Anurag sir to give us the time for this institute, and sir is known this institute since from the bottom 2008. So it's a proud for us, my dear students. You are listening since from the morning very patiently. We need a huge clap for you that you people have done, because of this is for you only, and you are the becoming leader of this organization. You are the only person who can be deliver all these things for future. Is my all director, especially Dr. S.S. Thanaji, and all the other institute directors have given the time, faculty members. We are very thankful from the management side to maintain this institute displayed in such a way that all students are having patience and at least they are interested for this listening this whole workshop. I am also very thankful to Dr. Alok Jain. He is commanding the all institute and encouraging the all directors to run in such a good way that how we can maintain new ideas, new development for the institutes. Recently, we developed a skill development program center which will be for students, and we must say all students must visit at least once in a week or fortnightly for that department, and we are trying to maintain the programs and trainer also to run that department. And सर गोयल का एक ही सपना है कि जो बच्चा यहाँ से निकले वो परफेक्ट होके निकले, वो एक जॉब ओरिएंटेड बच्चा निकले, और जिससे जो इनके माता पिता ने, जो इनके परिवार ने आशा जोड़ी है, और मुझे लगता है कि हमारा हर एक फैकल्टी, हमारे हर एक स्टाफ, सबका ये इच्छा रहती है, सबकी एक कर्तव्य भावना रहती है कि हम अपने बच्चे को बॉटम से जोड़े रखें। और यही आपको आज दिख भी रहा होगा कि यहाँ हम लोगों ने कहा से और आप कहाँ पहुंच रहे हैं AKTU की रैंकिंग में भी, AKTU के रिजल्ट में भी और AKTU के इनोवेशन सेल में भी। I am very thankful to Dr. Rishi Asthana and entire team of the Dr. Rishi Asthana that he has made such an innovative cell in 4-star rating since from last 4 years, and nobody in UP I can say इस तरह के रेटिंग 4-star रेटिंग किसने पाई हो। हम और भी बहुत अच्छे काम कर रहे हैं और करते रहेंगे लगातार निरंतर। हम लोग की कोशिश है कि हम इंस्टीट्यूट के नाम और आगे बढ़ाएं और अच्छा लेके चलें। और मुझे ये भी बताते हुए बड़ा हर्ष हो रहा है कि इस बार हम लोगों ने AKTU में गोल्ड मेडल, सिल्वर मेडल, ब्रॉन्ज मेडल, ये एक अपने आप में एक बहुत बड़ा बात है कि ये सभी डायरेक्टर, सभी बच्चों की मेहनत है कि AKTU के गोल्ड मेडल, ब्रॉन्ज मेडल, सिल्वर मेडल और 10 बच्चे टॉप 10 में AKTU की लिस्ट के कन्वोकेशन में थे। तो ये इंस्टीट्यूट का एक संस्था का और संस्था का चेयरमैन होने के नाते मेरे लिए बहुत गर्व की बात है और मैं आप सभी का आभार व्यक्त करता हूं कि आप लोग के सहयोग बिना यहाँ कुछ नहीं हो सकता। अकेले मैनेजमेंट कैन नॉट डू एनीथिंग, ओनली द मैनेजमेंट कैन प्रोवाइड द फैसिलिटी, मैनेजमेंट कैन प्रोवाइड, बट द हीरो इज यू। You are the main hero who can do the work, who can see how the need is required for the student. So we again thanks to all the speakers, all the persons, especially students, and we hope to do this type of workshop in future regularly. Thank you very much. Thank you.
Thank you so much, sir. You being the head of this Goel family, we will definitely achieve heights. Now I would like to call upon all the dignitaries for moving forward with the valedictory session. I invite Dr. Alok Chan, sir, Director Planning and Coordination, Dr. Rishi Asthana, sir, Director GITM. I also invite Dr. Karuna Shankar Shukla, sir, Director GIPS, Dr. Om Prakash Verma, sir, Director GIPS on the stage. Now I invite Dr. Devendra Agarwal, sir, Dean Academics, GITM, and Dr. Brijesh Pandey, sir, Dean Associate on the stage. Before we start the session, we would like to invite our students who have been working for the innovation and their ideas has been selected by UPCST along with the innovation cell convener Dr. Priyanka Jaiswal ma'am and all the students whose idea was selected for UPCST. I request you all to please come up on the stage for a group picture. Please put your hands together and welcome all the students and Dr. Priyanka Jaiswal ma'am. I also request our guest of honor, Mr. Maneet sir, Chief Executive Officer Innovation Hub AKTU, and Professor Anurag Tripathi sir to please join us on the stage.
Now I invite our respected guest of honor, Professor Anurag Tripathi sir, Dean UGSC AKTU Lucknow.
I And we request our respected chairman, sir, to please come forward and present him the token of gratitude. We also thank him for coming to our institution and taking out time for this IPR workshop. A huge round of applause while we present the token of gratitude to our guest of honors.
Now I would like to invite Mr. Maheep Singh, Sir, Chief Executive Officer, Innovation Hub, AGTU.
We request our chairman, sir, to please present the token of gratitude as we thank you, Dr. Maheep Singh, sir, for taking out time to visiting our college for this IPR workshop. A huge round of applause for Mr. Maheep Singh, sir.
Now I would like to invite Mr. Abhay Dwivedi, Sir, Patent Agent and Assistant Professor, Modi University.
Please put your hands together and welcome Mr. Abhay Kumar Dwivedi, sir. We request our chairman, sir, to please present him the token of gratitude as a keynote speaker for today's IPR workshop.
Now I would like to invite Dr. Om Prakash, Sir, Director, Petalita Ventures.
Can we have a huge round of applause for Dr. Om Prakash, sir? I request our chairman, sir, to please present him the token of gratitude. A huge round of applause for Dr. Om Prakash, sir, as we thank him for taking out time for the keynote session of the IPR workshop.
Now I would like to invite Professor Dr. Varun, Sir, Professor, Faculty of Law, University of Lucknow.
I request our chairman, sir, to please do the honor as we present him the token of gratitude as a keynote speaker for the session in IPR workshop organized by Goel Institute of Technology and Management. I request all the dignitaries to please move ahead a little bit for a group picture. I request the technical team to please cover the group picture.